Court officer. Court officer. Court officer, court officer. Court officer. Court of sir.
Tomorrow there is no sitting, so give the memo. Kodi alla.
My lord,
All memos you give. Fresh matters ella kodi.
My lord,
All fresh matters.
all fresh matter only, my lord. Actually, ಇದು
Actually, factually ಏನಿಲ್ಲ ಎಲ್ಲ fresh matters ಕೊಡಿ.
311 actually fresh case 311 ಸಸ್ಪೆಂಡ್ ಮಾಡಿದ್ದಾರೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ನಲ್ಲಿ.
ಒಂದು ನಿಮಿಷ ತಾಳಿ.
ಬೆಲ್ಲೂರ್ ಟು
Just a moment sir.
Yes.
ಎಲ್ಲ ಕೊಡಾಯ್ತಾ?
fresh CR. My lord, this is a Monday. Please, there is some
Fresh
urgency.
matter ಇರೋದೇ ಒಂದು ಮಂಡೇ ಸರ್. ಎಲ್ಲ fresh matter ಕೊಡಿ.
Monday, there is an urgency matter in this matter. Please, Monday have it.
ಯಾರದು ಅರ್ಜೆನ್ಸಿ ಹೇಳಿದ್ದೀಗ? ಬರುತ್ತೆ. ಕೊಡಿ ಸರ್. ಪೆಂಡಿಂಗ್ ಆದ್ರೆ ಬರಲ್ಲ, ಯಾವುದೇ ಕಾರಣಕ್ಕೆ ಕೊಡ್ಬೇಡಿ. ಫ್ರೆಶ್ ಇದ್ರೆ ಕೊಡಿ. ನೋ ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ ವಿಲ್ ಕಮ್. ಕೊಡಿ. ಯಾಕೆ? ಯಾಕೆ? ವೈ ಆರ್ ಯು ವೇಟಿಂಗ್ ಆಲ್ ಆಫ್ ಯು ಸ್ಟಿಲ್? All of you wanted at 2:30?
not 2:30.
Give it sir.
My lord,
ಎಲ್ಲ ಕೊಡಿ ಸರ್.
311 ಅಪ್ಲಿಕೇಶನ್ ಫಾರ್ಮ್ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ.
ಪರವಾಗಿಲ್ಲ, ಕೊಡಿ.
ಟುಡೇ ಇದೆ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್.
ಟುಡೇ ಇದೆಯಾ?
ಟುಡೇ ಇದೆ ಅಲ್ಲಿ ಬೇಲೂರಿನಲ್ಲಿ ಇರೋದು.
ಹೌದು ಸ್ವಾಮಿ. ಈಗ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ ಯಾವಾಗ?
ಅದು 20 ಸಾರಿ 30 ಸರ್.
20, 30
ಸರ್ 90 ಸರ್ ಡೇಟ್ 23/8 ಸ್ವಾಮಿ ಡಿಸ್ಮಿಸ್ ಮಾಡಿರೋದು. 23
ಇದುವರೆಗೆ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ
ಸ್ವಾಮಿ? ಆಕ್ಚುಲಿ ನಮ್ಗೆ ಪರ್ಮಿಷನ್ ಕೊಡಾಗ ಆಕ್ಚುಲಿ ತಮ್ಮಿಂದಾನೇ ಕೊಟ್ಟಿದ್ರಿ. ಅವ್ರು ಒಂದು ಮಾತ್ರ ಇದ್ ಮಾಡಿದ್ರು, 4 ಮಾತ್ರ ರಿಜೆಕ್ಟ್ ಮಾಡೋದು. ಅದನ್ನೇ ಅಡಾಪ್ಟ್ ಮಾಡ್ಕೊಂಡು ತೊಂದ್ರೆ ಅಷ್ಟೆಲ್ಲ ಅವ್ರು ಚೇಂಜ್ ಆದ್ರು. ಸ್ವಾಮಿ ಮಂಡೇ ಮಾತ್ರ ಹಾಕೊಳ್ಳಿ ಸರ್. ಮಂಡೇ 4 ಇದೆ ಕನೆಕ್ಟೆಡ್ ಪೇಪರ್, ಒಂದೇ ಪಾರ್ಟ್ ಸೇಮ್ ಪಾರ್ಟ್
ಎಲ್ಲ ಕೊಡಿ. ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟ್ರಾ? ಮಿಸ್ ಆಗಿ ಪೆಂಡಿಂಗ್ ಹೋಗಿದ್ಯಾ? ತೊಂದ್ರೆ ಇಲ್ಲ, ಅಲ್ಲೇ ಇರುತ್ತೆ ಬಿಡಿ. ಮೂವ್ ದ ವೆಕೇಶನ್ ಬೆಂಚ್. ಎಸ್ ಕೊಟ್ಟಿದ್ದೀರಾ? Very good. We will keep this memo in abeyance. Give it.
There is a threat of disposition, my lord.
Police will dispose you.
No, my lord. The respondent is now
Injunction ಯಾರ ಫೇವರ್ ಇದೆ?
in my favor.
Then why will be disposed? Come.
Plus 2:30.
Give it sir. ಏನ್ ತೊಂದ್ರೆ? No. Police protection application ಏನಾಗಿದೆ?
It is kept in abeyance. That is the reason.
We'll direct the court to consider it. I am not going to grant police protection.
The direction may be
ತೊಂದ್ರೆ ಇಲ್ಲ, ಕೊಡಿ.
taken up today itself, my lord.
No problem. Give it.
Because there is only 1 week.
No problem sir. I will only direct. I am not going to grant police protection.
Direction, my lord, because there is only 1 week.
2:30 told. Yes. One ನಿಮಿಷ. You come.
Lord, one matter, my lords, in which office objections was raised, my lords, I have submitted that I have adopted
ಕೊಡಿ ಸರ್.
complaint, my lords.
ಆಯ್ತು, ಬರುತ್ತೆ ಕೊಡಿ.
This is for withdrawal, my lords. Request.
2:30. Yes.
It's a tax matter. It's a fresh matter, but on the first day only the previous judge has been recused. From
Give
that
it,
day,
sir.
it's not coming.
You please give it. Yes.
Kindly take it out on Monday, my lordship. No stay also it's there.
Give it.
Your lordship, I'm challenging an interim order granted by the trial court because
Granted.
granted by the trial court because of which I as a
File an
developer am
appeal.
not able to develop the
File an
property.
appeal. Yes.
This
GMCPC ಅಲ್ವಾ?
ಹೌದು.
File an appeal against the order. No, if you file an appeal ಅಂದ್ರೆ ಮೆಮೊ ಇಲ್ಲಿ ಕೊಡಬಾರದು. Yes. 2:30.
I'm in possession. NHAI also applies the same man.
ಆಯ್ತು
Where I have not been granted compensation.
ಕೊಡಿ ಸರ್. ಪೆಂಡಿಂಗಾ? ಬರಲ್ಲ.
Interim order has been followed not to change the nature,
ಬರುತ್ತೆ. ಎಸ್.
not to change the nature of the suit, my lord. Based on that order, they are
ಪೆಂಡಿಂಗ್ ಫ್ರೆಶ್.
fresh man. CRP, my lord, 7-11.
ಅದು ಕೊಡಿ ಪರವಾಗಿಲ್ಲ.
My lord, pending matter, subject matter is of the year 1996, my lord.
Even if it is 1886, I won't take.
Well, matter reserved.
Don't tell me all that, yes.
Matter reserved, my
Move
lord.
the-
Filing
move
written
after
arguments.
vacation. Yes.
Matter is reserved. Filing written arguments.
ಯಾವ್ದ್ರಲ್ಲಿ ಸರ್?
My lord, it's a civil revision petition.
ಕೊಡಿ.
Lord, I have a decree in my favor. The suit is barred. My 711 application is rejected. Trial court is
Give it,
proceeding.
yes.
Evidence is going ahead.
Give it, sir. 230 ಬೇಕಾ?
ಇಲ್ಲ, Monday was.
230 ಗೆ ad interim order rejected, my lords, because impersonated, said it has been impersonated. I am the owner.
ಬರೀ ನೋಟಿಸ್
fake
ಇಶ್ಯೂ
Aadhaar
ಮಾಡಿದ್ದಾರೆ.
card, notice-
ಬರೀ ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿದಾರಾ?
ಬರೀ ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ, ಸ್ಟೇಟಸ್ ಬಿಕಾಸ್ ಖಾತಾನು ಚೇಂಜ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಆಯ್ತು ಕೊಡಿ. 230.
230.
138 proceedings, sir. ಇಲ್ಲಿ ಯಾಕೆ ಬಂದ್ರಿ? Why have you come here?
Stay, my lord. CC number has been changed.
ಅಷ್ಟೇನಾ?
I'll try a court proceeding staff.
ಆಯ್ತು ಆಯ್ತು. ಅದೊಂದು being spoken document. Sorry? Yes. Next. No pending matter. Move the vacation bench. Move the vacation bench, yes. No, madam, no pending matters. No pending matters. Graveyard. No, photo. Move the vacation bench, madam, yes. Kodi.
My lord,
Monday. Fresh matter, give it, sir. Why are you still waiting to make a mention? Tomorrow sitting illa tane. ಮತ್ತೆ ಕೊಡಿ ಎಲ್ಲ. ಕೊಟ್ಬಿಡಿ ಮೆಮೊ ಎಲ್ಲ ಕೊಡಿ. ಮೆಮೊ ಕೊಡಿ ಸರ್. ಡೇಟ್ ಏನ್ ಕೊಡಲ್ಲ ಕೊಡಿ. ಎಲ್ಲ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಬರುತ್ತೆ ಕೊಡಿ. ಏನ್ 1000 can I take 1000 in a day? ಆಗಲ್ಲ ತಾನೆ. ಅದು ಕೊಟ್ಟಿರೋದು FR ನಂಬರ್ ಬೇರೆ. ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ. ನಾನು 1000 ತಗೊಳಕ್ಕಾಗಲ್ಲ ದಿನದಲ್ಲಿ ಕೊಡಿ.
my lord, vacating the stay, my lord.
Seriously, sir. Very good. After vacation.
Talking the
After
road and-
vacation, sir. Yes.
My lord, it's a fifth.
Give the
occasion we are
memos.
moving the memo, my lord.
Pending matters, please don't give. Vacating stay, please don't give. Give it, yes. Memos ಬೇರೆ ಇದ್ರೆ ಕೊಡಿ.
It's been,
No, sir. No time to hear vacating stay applications. After vacation.
it's blocking the public road, my lord.
No, move the vacation.
Lord, I am the
ಈಗ ಕೊಡ್ತೀರಾ ಬೇಡವಾ? ಫ್ರೆಶ್ ಪೆಂಡಿಂಗಾ? ಫ್ರೆಶ್ ಪೆಂಡಿಂಗಾ? ಬಿಟ್ಬಿಡಿ. Yes. Next.
Your lordship, appeal has already been filed. This writ petition is challenging that appeal.
Anything. Appeal is filed.
It's filed.
Then give it. Yes. Pending matters, please don't.
Posted on Monday, your lordship.
It will come. ಈಗ ಕೊಡ್ತೀರಾ ಮೆಮೊ? ಕೊಡಿ ಎಲ್ಲ. Give all the memos. Pending ಇದ್ರೆ it won't come, please don't give. Yes. Give it. Where? ಕೊಡಿ ಎಲ್ಲ. ನೋ ಸಂಡೇ ಎಲ್ಲಿ ನೆಟ್ ಮಾಡ್ಬಿಡ್ತಾರ? ಕೊಡಿ.
Insolvency case in city civil.
That's all right. No problem. Give the memo. Give the memo, sir. Memo ಕೊಡಿ. Call the cases, man.
May I request, my lord? Dharwad bench, madam.
Fresh matter, my lord.
ಕೊಡಿ ಮೆಮೊ ಕೊಟ್ಬಿಡಿ.
Completion of.
No submission. Give the memo. Please give all the memos. Give all the memos, sir. Pending ಇದ್ರೆ ಕೊಡ್ಬೇಡಿ.
And permission, lord.
Once I'd ask for a convenience compilation.
We'll
For
see.
dictating orders, I'm just.
When
I'm
it
just passing across
when
the
it is
top.
called, you give it.
Please, my lord, I'm great.
Give the memos. Yes, call the cases, man.
Kind permission, lord.
ಕೊಡಿ sir. Tomorrow I can't take. Give it. Yes. We'll see.
Kind permission, lord.
91 man.
My lords,
2 weeks.
may I make a mention, my lords?
ಕೊಡಿ ಮೇಡಮ್. ಪೆಂಡಿಂಗ್ ಆದ್ರೆ ಕೊಡ್ಬೇಡಿ. Will not come. ಏನ್ ಪರವಾಗಿಲ್ಲ. ಪೆಂಡಿಂಗ್ ಆದ್ರೆ ಬರೋದೇ ಇಲ್ಲ, ಕೊಡಬೇಡಿ. Yes.
Serial number.
My lords, a matter was heard and reserved for orders on
Give it.
11th.
Give it.
There is a subsequent development that has come to our.
ಯಾವ್ದ್ರಲ್ಲಿ sir?
Sir, this is a DGGI illegal recovery. This was argued by my senior Lochna Babu.
Oh yes, give it.
The show cause.
You want it to be posted again?
No,
Then?
my lords. There is the show cause notice that was issued
All right, we'll see.
2 weeks
Yes.
back. It has no bearing on the outcome of the writ.
Then why are you giving it?
No, to be on.
Serial number 91, my lord. Senior is.
Mention
not
when
filling
it is called. ಬೆಳಗ್ಗೆ no adjournment. Next.
Being spoken till number
Kind
1.
permission, lord. Dharwad bench, madam.
2:30. Yes.
My lords, a connected matter is coming up on Monday, my lords. May be taken up with them.
ಏನ್ being spoken to ಏನಿದೆ? ಮೈಕ್ ತಗೊಳ್ಳಿ ಸರ್.
My lords, one unintended mistake has crept in. My lords have passed orders to dispose of in 3 months, my lords, FTP. ಅದರಲ್ಲಿ pending ಅಂತ ಆಗಿದೆ. It should be, my lords,
FTP is already disposed.
Disposed
Dispose
of.
ಆಗಿರೋ.
FDP dispose ಆಗಿದೆ.
Dispose ಆಗಿದೆ.
actually, my lords,
ಮತ್ತೇನು ಉಳಿತಿದ್ದು?
prayer one itself, my lords,
The petition was disposed by the following order. The learned counsel for the petitioner now submits on instructions that the FDP itself is disposed. In that light, nothing would survive for consider.
my lords, kindly, may I request my lordships to see the prayer.
AN prayers, sir.
Prayer, it is for the setting aside the impugned order which is available at page 24. Page 24 is the order, my lords. The counsel for the petitioner files a memo. It has been stated therein that the petitioners are not interested to prosecute the matter. Therefore, petition may be dismissed and not pressed. My lords, respondents, they come to the FDP court and say that they are not interested to prosecute, and without application of mind, learned civil judge dispose of
ಏನ್
the-
ಮಾಡ್ಬೇಕು ಇದ್ರಲ್ಲಿ?
ಇಲ್ಲ, ಇದನ್ನು ಕಾಸ್ಟ್ ಇದನ್ನ ಸೆಟ್ ಅಸೈಡ್ ಮಾಡಿದ್ರೆ
ಯಾವ್ದನ್ನ set aside ಮಾಡ್ಬೇಕು?
page 24 annexure impugned order, page 24.
Set aside ಯಾಕೆ FDP ನೇ ಇಲ್ಲ, ಏನಕ್ಕೆ set aside ಮಾಡ್ಬೇಕು ಈಗ?
Hello, this is the FDP which I sought for setting aside. My lords, kindly see my prayer.
Yes.
It's at page number 19.
Post the matter on Wednesday. In the same
Great,
stage.
great.
ಎಲ್ಲ ನೋಡ್ಬೇಕಾದ್ರೆ ಹೇಳಲ್ಲ.
Apologies, my lords.
What is this?
Bill number 2.
Yes, Lakshmikant. ಇದು ಎರಡು. Yes. We'll post it tomorrow. Tomorrow, Monday. Next.
Orders.
ಆ ಜಡ್ಮೆಂಟ್ ಯಾವ್ದು ಕೊಟ್ಟಿದ್ದೀರಿ ಅಂದ್ರಲ್ಲ? ಇದೆಯಾ ಇದರಲ್ಲಿ?
By the justice.
All right. Yes, next.
Orders. Bill number 4.
Non-compliance of office objections.
Serial number 4 and 9 are connected matters.
4 and 9.
4 and 9, my lord.
My lords, there are two other matters, my lords, which has been filed by the co-accused that may also be taken up together, my lords.
Number ಕೊಡಿ.
I'll provide the numbers.
ಈಗ ಎಂಟ್ರಿ ಮಾಡೋದು ಇದೆಯಾ?
No entry matter, my lords. I am
No
requesting
entry
for
matter.
entry matter, my lords, because the trial court is insisting for the appearance, regular appearance of the
ಹೋಗಿ
parties.
ಏನೀಗ?
Both were doctors, my lords.
Both are doctors.
Both are doctors.
So you go only when your patients are there, is it?
No, no, my lord.
ಮತ್ತೆ?
If they are in emergency, my lord, then
ಎಮರ್ಜೆನ್ಸಿ ಇದ್ರೆ ಎಕ್ಸಾಮಿಷನ್ ಕೇಳಿ 207 ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ. CRPC 207 BNS ಅಲ್ಲಿ ಏನ್ ನೋಡ್ಕೊಂಡು ಹಾಕಿ.
no, this is under CRPC. This is under CRPC.
CRPC ಹಾಕಿ.
But the trial is not going on, my lord, since
We'll direct the trial to get concluded if you want.
Lords, records are in this, before this honorable court only.
We will send
The
everything.
records.
Next week, your lordships may have all the four
And
matters.
covered by your lordship judgment, my lords, both the petitioners.
ಏನಿದು?
My lords, this is this PGET matter, my lords. Your lordships.
PG
have-
scam.
Please, matter.
Yes.
Because next week,
I asked Prasanna Kumar to prepare a synopsis
they had
and give.
already prepared the chart. I had sent it for approval. Your lordships may kindly have it next day.
Next week ಅಲ್ಲಿ ಏನಾಗಲ್ಲ madam, it can't be heard. The learned counsel appearing for the petitioner submits that the issue in the list stands covered by the companion, the petitions disposed by the co-accused. ನಿಮ್ಮಲ್ಲಿ ಏನಿದೆ?
Same similar role, my lords, we are the rank holders.
ನಾರ್ಕೋ ಅನಾಲಿಸಿಸ್ ಟೆಸ್ಟ್ ಅಲ್ಲಿ ಏನಿದೆ?
Negative, my lord.
Illa, it is
One of the
positive, my
petitioner
lords.
is
ಯಾವ್ದ್ರಲ್ಲಿ
negative.
ಪಾಸಿಟಿವ್ ಯಾವ್ದ್ರಲ್ಲಿ ನೆಗೆಟಿವ್?
It's positive, my lords. In
ಯಾವ್ದ್ರಲ್ಲಿ ಪಾಸಿಟಿವ್? Which for this?
fact, of the accused, my lords.
Both the petitions positive?
Please, my lords. It clearly says there is a
I'll make
knowledge.
my case. I'll make out my case.
ನಾವು
my lord.
ಕೇಳಿದಿಷ್ಟೇ
Respect to the-
ಪಾಸಿಟಿವ್ ನೆಗೆಟಿವ್?
First, with
Positive.
respect to the petition, first petitioner is concerned, it is a negative.
ಯಾವ್ದು ಈ serial number 4?
4.
My lords,
Four
kindly
negative,
pass
ah?
over. I'll provide the documents, my lords, in that case.
ಎಲ್ಲಿದೆ ನೆಗೆಟಿವ್? ತೋರಿಸಿ
I'll
ಪೇಜ್.
produce it.
It's not on top.
I'll produce the narco analysis test, my lords. I have not produced the entire charge sheet. I'm apologies.
ಆಯ್ತು. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಆಗಲ್ಲ? ಆಫ್ಟರ್ ವೆಕೇಶನ್.
Yes, but till then, my lords,
ಆಫ್ಟರ್ ವಾಟ್ಸ್ ದ ನೆಕ್ಸ್ಟ್ ಡೇಟ್?
state is.
ಡೇಟ್ ಗೊತ್ತಿಲ್ಲ, ನೆಗೆಟಿವ್ ಪಾಸಿಟಿವ್ ಗೊತ್ತಿಲ್ಲ, ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಬೇಕು ಅಂತೀರ. ಎಸ್, ಇಮಿಡಿಯೇಟ್ಲಿ ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಹೆಂಗೊಂದು ನನ್ನ ಹತ್ರನೇ ಬರಬೇಕು ಚಾಯ್ಸ್. ಎಸ್,
Unless I'll provide the details.
ನಂಬರ್ಸ್ ಕೊಡಿ ಮೇಡಮ್.
Please, ma'am.
ಅಂಡ್ ಆಸ್ಕ್ ಪ್ರಸನ್ನ ಕುಮಾರ್ ಟು ಗಿವ್ ದ ಸಿನಾಪ್ಸಿಸ್
I shall.
ಇನ್ ಎವ್ರಿ ಕೇಸ್. ನಿಮ್ದು ನೀವು ಕೊಡಿ,
I'll-
ಹೋಮ್ವರ್ಕ್ ಮಾಡಿ ಬಿಟ್ಬಿಟ್ಟಿದ್ದೀರಾ,
ಇಲ್ಲ, ma'am.
ಮತ್ತೆ ಕೊಡಿ. ಹೌ ಕ್ಯಾನ್ ಸುನಿಲ್ ಲೀವ್ ದಟ್?
Appeal, my lords, since last 2 weeks. ಅದಕ್ಕೆ ಇದನ್ನ
ಏನಾಯ್ತು?
The today's that appeal, my lords, they are also appearing. ಅದ್ರಲ್ಲಿ 2 weeks
Finding-
ಅದ್ರಲ್ಲಿ
ಓ
we are preparing
ಓಕೆ,
synopsis.
ಆಲ್ ರೈಟ್. ಅದನ್ನ ಮುಗಿಸೋಣ ಬಿಡಿ.
ಅದಕ್ಕೆ ಇದನ್ನ
ಅದಕ್ಕೆ ಪ್ರಸನ್ನ ಕುಮಾರ್ ಶುಡ್ ಕಮ್, ಡೋಂಟ್. ಎಸ್,
let's mean till then, let the appearance may be.
ಆಯ್ತು, ವಿಲ್ ಲಿಸ್ಟ್ ಇಟ್ ಆನ್ 31st. The appearance of these petitioners before the concerned court till the next date stands exempted. ಆಯ್ತು, ಅಷ್ಟೇ ಸಾಕಿ.
Much of it.
5.
Post immediately after the service of notice upon the second respondent. Entry ಮಾಡಿದ್ರೆ
My lordship, the petition number 3 has passed away today early morning.
early morning.
Yes.
Learned counsel submits that the third petitioner has passed away and would abate ಆಗುತ್ತೆ ಇನ್ನೇನದು. In the light of the said fact, the proceedings against the third respondent stands abated. The petition now remains only against the petitioners 1 and 2.
My lordship, we also, his aged parent, my lordship. Our allegation ಏನಿಲ್ಲ.
ಏನಿದು?
Page number 15 of the petition.
498 ಏನ?
498.
498 ಅಲ್ಲಿ, page number 15, if you just see para number 20, my lordship. There is no allegation against second and third petitioner except allegedly asking the daughter of de facto complainant to go in for the medical checkup.
Medical checkup ಅಷ್ಟೇನಾ?
Medical checkup ಹೇಳಿದ್ದಾರೆ, ಅದಕ್ಕೆ ಅವರು ಇದು ಮಾಡಿದ್ದಾರೆ, my lordship.
ಅಷ್ಟೇನಾ?
Yes.
Come to column number 17. Page 46.
Yes, my lordship.
Column number 17 ನಾನೇ ಪೇಜ್ ಹೇಳ್ಬೇಕಾ ನಿಮ್ಗೆ?
Sorry, my lordship. Okay. ಕನ್ನಡ.
ಇದು ಯಾರಿದೆ ದೈಹಿಕ ಕಿರುಕುಳ ನೀಡಿರುತ್ತಾರೆ ಅದೇ ವಿಚಾರಕ್ಕೆ ಸೋಣ್ಸೋ.
My lordship, last time.
ಯಾರದು? ಹಸ್ಬೆಂಡಾ?
Husband.
ಜಯೇಶ್ ಜಗದೀಶ್ ಸರ್.
First time my lordship
Husband.
said.
Husband ಮತ್ತೆ ಇವ್ರ ಮೇಲೆ ಹೇಳ್ತಾರೆ.
ಒಬ್ರು ಹೋಗ್ಬಿಟ್ರಲ್ಲ.
Petition number 2 and 3 will be considered in the last time ಹೇಳಿದ್ರು.
ಆಯ್ತು, ಈಗ ಒಬ್ರು ಹೋಗ್ಬಿಟ್ರಲ್ಲ. Yes.
ಇಲ್ಲ ಹಸ್ಬೆಂಡ್ ಇದ್ದಾರೆ.
ಎಲ್ಲಿ? ಇಲ್ಲ, ಹಸ್ಬೆಂಡ್ ಕೊಡೋದೇ ಇಲ್ಲ.
Against husband, my lordship.
ಹಸ್ಬೆಂಡ್ ಕೊಡೋದೇ ಇಲ್ಲ. ಈಗ ಹೂ passed away?
Number 3, my lordship. Petition number 3.
Father-in-law passed away.
No, mother-in-law.
Mother-in-law.
Brother-in-law na? Mother-in-law passed away. So father-in-law ಮೇಲೆ ಏನಿಲ್ಲ. The petitioner is before this court. Petitioners are before this court calling in question the proceedings against them in CC 22391 of 2022 registered for offences punishable under section 498A inter-alia. During the subsistence of the subject petition, it transpires that the third accused, the mother-in-law, is no more, and therefore the proceedings stand abated against the third petitioner. Insofar as the petitioners 1 and 2, a perusal at the summary of the charge sheet as obtaining in column number 7 would clearly indicate that the allegations of torture and other overt acts are only against the husband accused number 1. A perusal of it would not indicate even sprinkling offences against the father-in-law, the second petitioner herein. Therefore, permitting further proceedings against the father-in-law would run foul of the judgment of the apex court in the case of Payal Sharma versus so 2024 SCC online SC page 3473. In that light, I deem it appropriate to stay all further proceedings qua the second petitioner, the father-in-law. It is made clear the proceedings against the husband shall continue.
Much obliged.
In Jagdish sir.
406 and misappropriation. What they have done, they have taken the property, so fabricated the document, sold it to CW8.
Yes, sir.
6. I complain the office.
Learned counsel seeks 2 weeks time to comply with the office objection. List on 31st October if the office objections stand compliant. Next.
7.
Petitioners, the entire order sheet is not produced. The only
Produce
objection. Only one the date ಮಾತ್ರ ಅಷ್ಟೇ. ಅದನ್ನ ಆನ್ಲೈನ್ ಕಾಪಿ ಹಾಕಿ.
Accepting the submission of the counsel of the petitioner, office objections overruled. What's the matter?
But the second respondent led the complaint regarding assault and the used
354B, sir.
abusing working.
354B.
There is a civil.
307.
307 ಇದೆಯಾ?
So there is no injury set up, but there is
You
no court
parallel
certificate. Sir, there is a civil suit is pending.
Civil suit gu 307 gu ಏನ್ ಸಂಬಂಧ sir?
Only further treason.
Civil suit is not a license to assault.
There is no injury action.
ನೀವು ಎಲ್ಲ ಕಡೆ ಹೇಳ್ದಂಗೆ ಅವನ್ನ ಹೇಳ್ಬೇಡಿ ಇಲ್ಲಿ. Civil suit is not a license to assault.
There is a civil dispute is pending between the parties.
So what, sir?
And second ground, my lord, she had lodged a complaint against the petitioner number 4. And there's a civil case and counter case between the parties.
ಕೇಸ್ ಅಂಡ್ ಕೌಂಟರ್ ಕೇಸ್
Case and counter.
ನೀವು ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ್ದೀರಾ?
First ಅವ್ರದ್ದಾಗಿದೆ.
ಅದ್ರಲ್ಲೆಲ್ಲ ನಿಜಾನಾ? ಬೋತ್ ಆರ್ ಫಾಲ್ಸ್. ನಿಮ್ದು ಫಾಲ್ಸ್, ಅವ್ರದ್ದು ಫಾಲ್ಸ್. ಅವ್ರು ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ವಾ? ತೊಂದ್ರೆ. Emergent notice to the second respondent. Additional SPP is directed to accept notice for the first respondent. List on 31st October. Same. ಈಗ ಅವ್ರನ್ನ ಕರ್ಕೊಂಡ್ ಬಂದ್ಬಿಟ್ಟಿದ್ದೀರಾ?
My lords may recollect, this was one matter, my lords, quite an interesting proposition. The informant, my lords,
Where are you, sir? Not to be seen. ನಮ್ಮ CPC ಕೋರ್ಟ್ಗೆ ಯಾಕೆ ಬರ್ತೀರಾ?
ನನಗೆ ಅಡ್ರೆಸ್ ಇಲ್ಲ, my lords. My lords, the informant would cheat the bank, take back his property, sell the property, and proceeds of that crime, he gives a portion of it to me. And then, my lords, he would file this complaint saying, I have cheated him. So, my lords, the interim order which my lords had granted is charges not to be framed. But, my lords, I did some research on it, whether a person who has cheated and if he's got the money, and if he says that I've lent that money to someone else and that person has cheated me, can he set the law in motion, my lords? Some my lords, just as kindly notice the proposition. One more second.
Any opposition to the proposition?
My lords, on the page 16 one tav nodidre, my lords, just that propositions, because this may be quite interesting to argue also, my lords.
We will, yes.
Page 16 alli, the Latin maxim, my lords, from a dishonest cause, an action does not arise. This doctrine prevents individuals from pursuing legal action if their claim is based on illegal or immoral act they committed. That would be the first principle, my lords, which I will point out on the basis of judgments. Then the second one, my lords, public policy. No court would lend its aid to a man who founds his cause of action upon an immoral or illegal act.
Correct.
Then earlier complaint, my lords, which was filed against them, the CBI, that where a charge sheet has been filed. Now the present dispute which they point out, will be one of civil in nature, is one of the contentions that I'll point out. Then charge sheet is filed for both 420, 406, Delhi Race Club, and again which has been followed thereafter. Mechanical order of taking cognizance, my lords, I was relying on, and Anjaney Reddy 1, but now Anjaney Reddy 2 has come. So probably this proposition I will rethink, my lords. Then, my lords, doctrine of alter ego. Company, you can't proceed against the others. So these 9 propositions, my lords, individually I will point out, but I will give them a set, my lords, so that even they can prepare on these propositions. Maybe it will be something which will be interesting for us to at least argue before this court, my lords, on these propositions.
Before that,
proposition ನೋಡಿ ಸರ್.
ಅದಕ್ಕಿಂತ ಮೊದಲು ಸ್ವಾಮಿ.
ನಿಮ್ ಪ್ರಪೋಸಿಷನ್ ಇದೆಯಾ ಹೇಳಿ?
Last date of hearing, before the last
my lords, sorry, before they start,
this court has directed to call back the lower court records, because I said I have made a submission before this honorable court. The petitioners are so powerful that they can hide
ಬಂದಿಲ್ವಾ?
even the lower court's records.
ಬಂದಿದೆ ಮೇಡಮ್. ಅದೇ ಇತ್ತಾನೆ ಮಿಸ್ಸಿಂಗ್ ಫೈಲ್.
ಹೌದು.
ಇದೆ. It's there. We have summoned the records.
Yes, my lord. From last 2 hearings, it has not come.
Why are you worried?
No, my lord. Because my lord, charge sheet is completely stayed by this honorable court.
No,
your lordship,
charge frame ಮಾಡಬೇಡಿ ಅಂತ
charge
ಹೇಳಿ.
framing of the charges is stayed, my lord. On the other hand, my lord, these people, the petitioners are so powerful, they are threatening each and every day to their wife. Complainant's wife. And even his child, daughter, she is only a 14 years child.
They are threatening her also.
Following him. Every day, my lord, 2-3 people they follow, and they're threatening.
Pokso ಹಾಕಿ ಸರ್ ಅವ್ರ ಮೇಲೆ ಕಂಪ್ಲೇಂಟ್ ಹಾಕಿ.
ಅದರಲ್ಲೇ ಹೊಸೂರು ಅದು
ಕಂಪ್ಲೇಂಟ್ ಕ್ಲಿಯರ್ ಸೆಕ್ಷನ್ 11 ಹಾಕಿ. ಆತರ ಇದು ನಿಜ ಇದ್ರೆ ಹಾಕ್ಬಿಡಿ.
ಹಾಕ್ಸ್ತಾ ಇದೀನಿ. ಹೊಸೂರಲ್ಲಿ ಇರೋದ್ರಿಂದ jurisdiction is in ಹೊಸೂರು.
ಅಲ್ಲಿ
ಅದಕ್ಕೋಸ್ಕರ ಅಲ್ಲ ಹಾಕಕ್ಕೆ ಹೇಳಿದ್ರು.
ಹೊಸೂರ್ಲಿ ಇರೋದು ನಿಮಗೆ ಹೇಳಿದ್ರ ಅವರು?
ಹೌದು. ಅಲ್ಲ, they are staying in ಹೊಸೂರು itself. The complainant earlier was in Attibele. Now presently Attibele and Asura.
Accused ಎಲ್ಲಿದ್ದಾರೆ?
Because of the threatening of these.
Accused ಎಲ್ಲಿದ್ದಾರೆ?
Accused in Attibele only. Accused also in Attibele.
ನೀವು Attibele ಇಂದ ಹೊಸೂರಿಗೆ ಯಾಕೆ ಹೋಗ್ತಾ ಇದ್ದೀರಾ? ಹತ್ತಿ ಬೆಲೆಯಿಂದ ಹೊಸೂರ್ಗೆ ಯಾಕೆ ಹೋಗ್ಬೇಕು? ಸುಮ್ಮನೆ ಇರಕ್ಕಾಗಲ್ಲ.
Really don't know. but
ಅಲ್ಲಲ್ಲ ಸ್ವಾಮಿ,
what
business
will
is in
If they
Krishnagiri.
really feel that there's any threat, let them register an FIR against us. If it is there,
that is
this
what-
is just for the purpose of.
ಏನು ಯಾನ್ ಮಾಡ್ತಾ ಇದ್ದೀಯ? ನಿದ್ದೆ ಬರ್ತಾ ಇದೆಯಾ?
ಇಲ್ಲ ಇಲ್ಲ sir.
ಮತ್ತೆ ಎಸ್ ಇನ್ನು 10:30 ಅಂತ.
ಇಲ್ಲ ಇಲ್ಲ.
ಹ್ಮ್.
ಇಲ್ಲ sir, that's less only. The complaint itself that there is a threat. My complaint and the prima facie itself is a threat, and as learned senior counsel said, it is not the proceeds of the crime. It is the intentional cheating of the petitioners. He has transacted with the petitioner or the accused, the complainant.
ಅದಕ್ಕೆ ಸ್ಟೇ ಕೊಟ್ಟಿಲ್ಲ, ಬರೀ ಚಾರ್ಜ್ ಮಾತ್ರ ಡೆಫರ್ ಮಾಡಿದ್ರೆ.
ಆ ಅಮೌಂಟ್ ಅನ್ನ ಏನ್ ಮಾಡ್ತಾರೆ, ಇದನ್ನ ಇನ್ವೆಸ್ಟ್ ಮಾಡ್ಬೇಕಾಗಿರ್ತಕ್ಕಂಥ ಅಮೌಂಟ್ ಅನ್ನ illegally they get the MOU done in his name, and the MOU will not going to get registered at all. And after that he says that no amount is being given. All the entire amount is been transferred online.
My lords,
Don't worry.
Then how can we
be given,
Date
we
fix
will go on
ಮಾಡ್ತೀನಿ.
with the matter.
ನೀವು ರೆಡಿ ಆಗ್ಬಿಡಿ ಫುಲ್ಲಿ. ಅವ್ರು ಎಲ್ಲೆಲ್ಲಿ ಫಾಲೋ ಮಾಡಿದಾರೆ ಎಲ್ಲ ಕೇಳ್ಕೊಂಡ್ ಬಂದ್ಬಿಡಿ.
My lords, I'll give the
ಒಂದ್ ನಿಮಿಷ.
judgments
They
also.
heard the learned senior counsel Sandesh Chowta appearing for the petitioner. Owing to the issue in the list, this court had directed the concerned court to defer its act of framing of charges. The matter is at that stage. The learned senior counsel has now projected the following grounds in the for his submissions, and to buttress the grounds, he has placed on record plethora of documents and the judgments. The learned counsel for the respondent submits that the charges there has been stalling of the act of the concerned court in framing of charges. Therefore, it is imperative that this matter be heard. In the light of the projection of the grounds as quoted herein above, the matter requires consideration and a detailed hearing. Therefore, list this matter on 24th October. The interim order of directing the concerned court to defer its act of framing of charges shall continue till the next date of hearing. ಯಾಕಂದ್ರೆ ಬರೀ ಒನ್ ಲೈನ್ ಆರ್ಡರ್ ಬದಲು ಇನ್ನು ವೆಕೇಶನ್ ಅಲ್ಲಿ ವೆಕೇಶನ್ ಇಲ್ಲ ಅಂತ ಹೋಗ್ಬಿಟ್ರೆ
Number 10.
8 and 9 ಎರಡು ಅದೇನಾ? 4 and 9. Madam Prasanna Kumar, yes.
For the petition in this case, Your Lordship, we'll pay the process fees in the course of the day, and kindly we'll pay the process fees, Your Lordship.
All right.
During the course of the day,
All
kindly
right.
extend the interim order, Your Lordship.
The fraud on the bank loans have been obtained by.
ಏನಿದು? ಅಲ್ಲ ಕಂಪ್ಯಾನಿಯನ್ ಪೆಟಿಷನ್ ಏನೋ ಸ್ಟೇ ಇದೆ ಅಂತ ಹೇಳಿದ್ರು.
ಎರಡು ಸೇಮ್ ಕೇಸ್
Stay there, Swami.
Bank loans na page 28 mirror column 17 disclose how much of loan they have.
ಏನ್ ಮಾಡಿದ್ದಾರೆ?
Krushi without showing that they obtained a loan without showing
ಬೇರೆ ಖಾತೆಗೆ ಮಾಡಿ. Willful defaulter and fraud. It's not. Next time or guest. List the matter on 31st. Office objections become needful be done by then, failing which the interim order would stand automatically vacated.
Okay.
Interim order subsisting subject to the aforesaid condition shall stand extended.
11.
11 is also
Same order.
12.
For the petitioner, my lord.
So,
For the respondent, my lord, cell number 12, my lord.
Please, my lords. 11,000 rupees state exchequer cost ಮಾಡಿದೀವಿ ಅಂತ ಹೇಳಿ allegation. Complainant is the
interim order ಇದೆಯಾ ರಜತ್?
Area where my building was being constructed.
We'll take it on
please,
31st.
There is an interim order.
List the matter on 31st. Interim order. Post immediate police report. Post immediately after service of notice upon the second respondent. Interim order subsisting in all these cases shall continue till the next date of hearing. Yes.
It will be given for this reason. 2012 is the complaint, my lords. 2012 only PCR file.
Interim order ilva?
We have lots.
You are the complainant.
We are the accused. 12.1 have 12.2 only.
Yes, sir.
In fact, lords, he is not available is what the, in fact, the
police report are barli.
Please.
Adike immediately after the receipt of the report.
13.
Okay, for respondent number 2, my lords.
A week's time is granted to do the needful. Yes, next.
May I make one submission? In serial number 13, the trial court has sought time to extend on the earlier date.
Wait.
Certainly, Milords.
6 months to dispose the suit without any further interim time. Direction. 11. The 2015 matter.
2009, Milords.
Seriously? The coordinate bench of this court had directed disposal of the subject CRP within 6 months, 10 years ago. The learned 15. Again, it was directed that the matter be taken up on day-to-day basis and disposed on 25/3/2023. 6 months' time is again sought by the presiding officer for disposal of the CRP, which is now 10 years old. In the light of the reasons so rendered, there is no warrant of any further grant of time in the light of the order passed by two benches, one 6 years ago and other 2 years ago, to dispose it within 3 months. The request for rejection stands rejected, and if the matter is not disposed in terms of the directions, the matter would be viewed seriously. Yes, next.
14.
Hand summons may be ordered, my lord, with respect to R4, in addition to the process.
List after 4 weeks. IO. Next.
Lord, hand summons may be there. We'll take hand summons, my lord.
Yes. Petitioner is at liberty to serve the unserved respondent by way of hand summons. Yes, next.
Great.
15. Interim order.
Post immediately after service of notice upon the respondent, interim order subsisting will continue till the next date of hearing.
16. Interim order.
Say 16. Needful to be.
Hand summons on the
Yes, I agree with that. I'll file your color.
Yes.
After vacation, please.
After vacation.
Please.
The message Janardana.
Janardana.
Learned counsel appearing for respondents 2 to 5 seeks 2 weeks time.
Madam.
List the matter after vacation. IO.
17.
Interim order may be extended.
IO andre ade sir. Madam, IO andre ade. Yes.
17.
Settlement talks are going on, my lordship, in this case.
Where?
In this case, my lordship. Yes, my
Oh,
lordship.
that's-
Settlement ಆಗ್ತಾ ಇದೆ.
Heard the
Registrar office ಗೆ ಹೋಗಿದ್ರು, ಆಮೇಲೆ ಅದ್ಯಾಕೋ
Heard the learned counsel for the petition, learned senior counsel for the Shri Uday Hulla appearing for the respondent. The learned counsel for the petitioner, the learned counsel for the petitioner and the learned senior counsel would submit that the talks between the parties for settlement are afoot AFOT. In that light, list the matter 4 weeks. List the matter after 4 weeks.
18.
2 weeks time to granted to do the needful. Next.
19.
Petitioner, I have served a notice to the,
Either.
he is appearing.
Yes. The learned counsel appearing for learned counsel so and so undertakes to enter appearance for
Respondent.
only
Respondent number,
Only one
respondent
respondent.
number 1.
the respondent. Yes.
And I filed a
Registry to
memo,
print the name of so and so. List after vacation. IO. Next.
I filed a memo to dispensation of the notice to respondent number 2 to 5.
Memo hakidira.
ಹಾಕಿದ್ದೀನಿ sir.
The learned counsel of the petitioner has filed a memo seeking dispensation of issuance of notice to respondents 2 to 5. In terms of the memo, no issuance of notice stands dispensed at the risk of the petitioner.
And respondent number 6 has contested in a lower court, Your Honor. I may be permitted to issue.
Learned counsel is permitted to take out hand summons upon the 6th respondent.
I have one
To the
submission.
advocate who is appearing in trial court.
The petitioner is at liberty to serve on the counsel who represents the 6th respondent in the trial proceeding.
Well,
Yes,
I have
madam.
one submission, my lord. The respondent number 1, she is the purchaser of the property, and whatever the respondent number 2 to 5, they have fraudulently sold the property to me, Means in respects of the property when they sold, before they have mortgaged the property to the,
Bank.
yes.
Ah.
So that is why the civil court has a jurisdiction, my lord. And they have filed order 7 rule 11, and this is dismissed before the lower court. So
We'll see, we'll hear it, madam.
My lord, actually they have granted a stay, and my case is, stage is the evidence as done.
We'll
For-
list the matter on 10th October. Yes.
Till then.
Until no interim order should not be extended, my lord, because
That
otherwise.
interim order will be vacated only after hearing, madam. List on 10th. IO.
Oblige, madam.
Yes.
20. Interim order.
Where for petitioner in this
Sunil Kumar.
course?
Ah.
20.
Dispensation.
Course of the day.
Course of the day. Marco Hotilva. Learned counsel,
ಕೊಟ್ಟಿದ್ದೀವಿ.
learned counsel seeks a week's time to do the needful. List the matter.
ಅಯ್ಯೋ
After 2 weeks. ಅದು ಮಾತ್ರ ಕೇಳ್ತೀರಾ. In the course of the day, I will extend. ಮಾಡ್ಬಿಟ್ಟು ಬನ್ನಿ. Yes.
21. Interim order.
2 weeks time, my lords.
2 months time.
2 weeks, my
2
lords.
weeks time. Yes.
Because 42 members are there. Trial court.
ಹಂಗಾರೆ 2
they are
months
not-
ತಗೊಳ್ಳಿ. Yes.
No, my lord. Few have appeared and few remained ex parte. So I may be permitted to take through registered post, my lord.
ಆಯ್ತು. AV IOC.
22.
After vacation, interim order continues. Yes.
22. Interim order.
Same AV IOC.
23.
Post immediately after service of notice upon the respondents, AV IOC.
Interim order.
Interim order. Madam, interim order ಹೇಳ್ದೆ ಹೋದ್ರೆ ಒಂದ್ಸರಿ ನೋಡ್ಬಿಡಿ ಇದ್ರೆ extend ಮಾಡಿ. Yes.
24.
In this paper, I have the respondent.
ನೀವು
They have said I received the copy of the petition.
ಹಾ
ಆಮೇಲೆ ಕೇವಟ್ಟು WPL ಹಾಕ್ಬಿಟ್ಟಿದ್ವಿ. So I will file wakalat during the course of the day.
Suit for partition.
All
4 properties are self-acquired. The amendment in the plaint itself declare, not shows.
all properties self-acquired.
Self-acquired,
Where is it?
not,
There is no interim order?
there is no interim order.
Where do you get that? All properties are
Paragraph 6.
self-acquired?
Already it is
Page
posted
29,
for
in page.
examination of the plaintiff,
ಆಯ್ತು.
PW1.
ಅಲ್ಲ self-acquired property
Page-
partition.
page-
Partition ಯಾವ್ದು?
Suit schedule property ಎಷ್ಟಿದೆ?
4 ಇದೆ.
4 self-acquired ಅಂತ
4.
ಎಲ್ಲಿದೆ?
Page 29, not in page 29.
Plaint government?
Plaint amendment, only the plaint, I'm only reading the plaint.
Yes.
Para 6, in page 29, my lord. The plaintiff further submits one late G. Rajappa, the husband and father of defendants and grandfather of plaintiff herein, and the said Rajappa during his lifetime acquired property bearing number 1319 situated at Saraki second phase, Bangalore now so and so. Lord, next page, the next paragraph. Presently getting rental income of so and so. Late Rajappa died on 10/6/2014, leaving behind the defendants herein to succeed to his estate. This is first property. The BD allotment. Second one, para 7, the second property.
ಆಯ್ತು para 6, 7, 8, 9 ಎಲ್ಲ ಅದೇನಾ?
Para 7 ಅಲ್ಲಿ, the defendants are co-owners. They have acquired a property by themselves. They have bought.
Mohan sir, if it is self-acquired property, where is partition?
No, your lordship, Rajappa died intestate, your lordship. They are claiming to 3 properties, ಒಂದು ಮಾತ್ರ ಅವರು ಇದು ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
Rajappa died
That is the
intestate.
reason finding of the court, it cannot be impartial. Let the
So
evidence.
who are
go.
the others?
It is let the evidence go.
The wife
Because
and-
they can
wife
prove
and
it
two
if it is
sons.
self.
You file your objections.
Para 7, they have acquired property themselves. They purchased.
What's the next dates?
In November. Yesterday it was there. now
Finding
it's
your
11.
lordship, will kindly see
I-
at para 12.
Learned counsel J.R. Mohan submits that he has entered or you will enter. ವಕಾಲತ್ ಹಾಕಿದ್ದೀರಾ ಹಾಕಿಲ್ವಾ ಸರ್?
Pardon?
ವಕಾಲತ್ ಹಾಕಿದ್ದೀರಾ?
ಇವತ್ತು ಹಾಕ್ತೀವಿ today.
Learned counsel submits that he would enter, undertakes to enter appearance for the respondent, registry to print the name of so and so is appearing for the respondent. List the matter on 10th October.
It is posted for cross-examination PW1.
ಅದು ಯಾವತ್ತು?
5/11.
No problem. 10th October. Yes.
What I suggest, they let the suit be disposed of early as pointed to, if they are able to prove more can be done ಅಷ್ಟೇ. Suit can be disposed of.
ಅವತ್ತು ಮಾಡೋಣ. 10th October will pass.
Inspection ಕೊಟ್ರೆ
Will pass the
ಟೈಮ್
torrent.
ಫಿಕ್ಸ್ ಮಾಡಿ because evidence ಬಂದಿದೆ ಈಗ. So keeping this matter ಇದೆ ಯಾಕಂದ್ರೆ there are 4 properties ಅಲ್ಲಿ ಅವರು ಒಂದು ಪ್ರಾಪರ್ಟಿ ನಂಬರ್ 3 ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಅವರು. So next time
ಈಗ
let them submit it.
ಡಿಫೆಂಡೆಂಟ್ ಯಾರು ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ?
3 ಜನ.
ಅಲ್ಲಿ ಇವರು ಪ್ಲೇಂಟಿಫ್ ಅಲ್ಲ ಸಾರಿ.
ಒಬ್ರೇ.
ಪ್ಲೇಂಟಿಫ್ ಒಬ್ರೇನಾ?
Son of one of the, there's a matrimonial dispute
Settle it, sir.
between the plaintiff's mother and one of the defendants.
Solve ಆಗಿದೆ ಅದು. That has been solved in 2019.
Settle ಮಾಡಕ್ಕಾಗಲ್ವಾ?
ಇದು 18 ಅಲ್ಲಿ suit has been filed.
No,
Then
sir.
he died.
Can't be settled?
ಅವ್ರಿಗೆ ಇದಕ್ಕೆ claim, ಅವ್ರದ್ದು ಏನ್ claim against each other ಯಾವ್ದು ಇಲ್ಲ.
Dispute is beyond
As per
what,
the-
10th October ಬರ್ಲಿ.
ಅದೇ.
25.
Yes, case appear for the petitioner, my lord. My last occasion, your lordship had direct to file affidavit, my lord. A trial court advocate has refused to take notice, my lord.
Registry file ಮಾಡಿ ಇಂಟರ್ ಮಾಡಿದ್ಯಾ?
No interment.
ಏನ್ ಮ್ಯಾಟ್ರ್ ಏನು?
There is a against him, my lord.
Suit for?
Suit for declaration and position and injection filed by the village.
Why 711?
My lord, there is no cause of action.
Why no cause of action?
My lord, there is a mud property, my lord.
Mud property?
The property was sold by the
Oh,
petitioner
this
Swamiji.
that Swamiji, sir.
Yes, my lord.
List on 10th October.
My lord, entry, my lord.
10th October, yes. Next.
26. Interim order.
Petitioner.
AV,
Lordship,
IOC.
Copies and summons served through the trial court advocate.
Ah.
I am going to undertake the file wakalat for R1 and R2, my lordship.
The learned
Ragha-
counsel so and
Raghavendra
so
V.
undertakes to enter appearance for the
Raghavendra V.
R1, for R1 and R2, registry to print the name of so and so, R1 and R2, AV, IOC. Yes.
Interim order.
Yes.
Much obliged, sir.
27.
My lord, I seek my lordship permission to appear on 27.3. I am 14%, my lord.
14% na?
Yes, my lord, 27%. That is a Puliani matter where the 48 advocates are
Oh,
residing.
yes, yes, all right. Let
Yes,
it
my lord,
come.
my lord. Today, what happened, my lord, yesterday I got discharged.
After vacation, sir. Yes.
Interim order will expect today, my lord.
This matter has been pending for some time. A date be fixed kindly, your lord.
10th October.
10th of
Yes.
Interim order will expect today, my lord.
ಅದು ಆಯ್ತು ಸರ್. ಎಸ್.
My lord, meanwhile, I seek my lordship permission, my lord.
ಮೇಡಮ್ ಡೇಟ್ ಬೇಡ, AV IOC ಸಾಕು. ಎಸ್.
My lord, meanwhile, I seek, my lord, meanwhile, I am seeking lordship permission. Whole office is immersed with water. With lordship permission, my lord.
ನಾನೇನ್ ಮಾಡ್ಲಿ ಅದಕ್ಕೆ?
We will get it repaired because other side may object that without the permission of the court.
ಅದು
Because
ನಿಮಗ್ ಬಿಟ್ಟಿದ್ದು ಸರ್. ಎಸ್.
interim order expect, my lord.
ಅದು ಮಾಡ್ತೀನಿ.
Yes.
ನೀರ್ ಆಗ್ಬಿಟ್ಟಿದ್ರೆ ನಾನೇನ್ ಮಾಡಕ್ಕಾಗ?
ಇಲ್ಲ, because of the heavy rain that has whole office has been immersed.
All right, sir. Yes.
28. Interim order.
For the petitioner, your lordship.
Oh, 28 AV IOC.
My lords, I appear for the petitioner, my lords. I'll have the acknowledgements filed on Monday, my lords. The matter.
Learned ನಾರಾಯಣ ಸ್ವಾಮಿ ನೀವೇನಾ?
Please.
ಬೇರೆ ಯಾರಿಗೆ ಸರ್ವ್ ಮಾಡ್ಬೇಕಾಗಿತ್ತು?
My lords, the matter is listed before the trial.
The petitioner, my lord, they are not a
ಹೌದಾ?
contesting before that court. But they filed, the petitioner filed application 7 rule 11. I am the plaintiff there.
Suit for?
Respondent is contesting the. Suit for partition and separate position.
ಸ್ಟೇ ಕೊಟ್ಟಿದೀವಾ?
ಇದ್ರಲ್ಲಿ
Interim order is operative, my lords.
ಪಾರ್ಟಿಷನ್ ಸೂಟ್ ಅಲ್ಲಿ ಯಾಕೆ?
My lords, because these are self-acquired properties, my lords, as such, because.
Only contention, my lord, that there, the properties are the self-acquired property. There are several documents to substantiate ancestral property and co-personal property. I substantiated and produced the documents before the trial court, my lord. In the para number 18, it's clearly stated that.
ನೀವು ಇರ್ಲಿಲ್ಲ ಅವತ್ತು, ಅದಕ್ಕೆ ಕೊಟ್ಟಿರೋದು. ನೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಆನ್ ಬಿಹಾಫ್ ದ ಕೇವೇಟರ್. ಇಲ್ಲರ ಕೊಡ್ತಿರ್ಲಿಲ್ವೇನೋ?
Please, my lord.
ಮತ್ತೆ
ತೋರಿಸಿರ್ಲಿಲ್ಲ, my name has not been.
ನೇಮ್ ತೋರಿಸಿತ್ತು, ಇಲ್ಲ ನಾನೇ ಬರೀತೀನಿ. Yes, the learned counsel for the petitioner, the learned counsel for the caveator submits that the other respondents may not be necessary parties as they are sailing with the petitioner. The contesting respondent is the first respondent alone. The learned counsel for the petitioner therefore seeks time to file a memo seeking dispensation of issuance of notice to the other respondents. The learned counsel for the respondent submits that the self-acquired property, na?
No, their contention.
The learned counsel for the respondent submits the contention of the petitioners is that the property, suit schedule properties in a partition suit are all self-acquired properties. Is the contention of the present petitioner. The matter would require consideration. The interim order subsisting shall continue till the next date of hearing, list the matter on 10th October.
And they filed this petition against the death person, second respondent died on 19/6.
ಈಗ ಮೆಮೊ
They
ಹಾಕಕ್
filed on
ಹೇಳಿದ್ದೀನಲ್ಲ
17.
ಬಿಡಿ. ಮೆಮೊ ಹಾಕಕ್ ಹೇಳಿದ್ದೀನಿ.
Matter is listed before the trial court tomorrow, my lord.
Next, 10th, yes.
Grateful, my lord.
30, interim order.
Serial number 30, 1 to 4, I have served on the council.
AVI was
Trial
next.
court. They would dispense the notice, my lord. I have filed
ಆಮೇಲೆ,
a memo.
yes, next.
Petitioner in this case.
31,
7 rule 11 was rejected by the trial court. Madam.
You petitioner ga?
Yes.
Yes.
Can it be had on? Can it be had on first week of October or second week of October? So that,
What's the matter, sir?
Suit was filed for cancellation of the sale deed, Your Honor. Grounds for cancellation is the defendant has paid excess amount instead of 23 lakh and add. She has paid 40 lakh.
ಈಗ ಎಕ್ಸ್ಟ್ರಾ ಕೊಟ್ಟಿದ್ದಾರಾ?
Extra ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ.
ವಾಪಸ್ ಕೊಡಿ.
ಅಲ್ಲ ಅವ್ರು ನಮಗೆ ನಾನು ಎಕ್ಸ್ಟ್ರಾ ಕೊಟ್ಟಿದ್ದೀನಿ.
ಅವರು ಕೊಡಬೇಕು ಅಂತ ಕೇಳ್ತಾ ಇದ್ದಾರೆ. That's what I want to ascertain what is.
Plaintiff ಹೇಳ್ತಿದ್ದಾರೆ ಎಕ್ಸೆಸ್ ಅಮೌಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅದಕ್ಕೋಸ್ಕರ ಟೈಮ್.
List the matter on 10th October.
Yes, grateful.
32,
In this, I appear for the petitioner, my lord. Officer has raised an objection, CRP is not maintainable under, against an order passed in the order 22, rule 10, my lord, for impeding, my lord. This is one judgment of
Impleading application.
impeding application.
Office objections, maintainability stands overruled.
Office objection.
Emergent notice to the respondent. Yes. Next.
33, same lodge.
Same, yes.
34,
Lord, I'm just handing over the valuation slip.
Petitioner, my
With last time I gave it as it is, this time it's with a memo, just to show, my lord. They say that, my lord, it's a suit for partition. They say that they valued it under 35 subclause 2, and then, my lord, the honorable court has said, no, 35 subclause 1 and ಮಾಡಬೇಕು. Valuation ಮಾಡೇ ಇಲ್ಲ. They have not even done it under, so it will come under section 7 if my lords were to kindly see. They have not, and deliberately they don't produce a valuation slip. They file the
I
plain.
apply for the certified copy, my lord. I have gone and checked it,
This
my
is
lord.
it.
We have,
ಆಯ್ತು, look at Monday.
my lords, this is the suit for partition.
ಏನದು? Still file ಮಾಡಿ. Monday.
Grateful.
Please.
45,
Government review. Where is government? Oh, that gun license. List on 31st October. Next.
36,
I'm appearing for the petitioner, my lord. My lord, this matter pertains to the civic, basic amenities to be provided to economically weaker section.
Last time what happened? 1 minute, madam.
Complete the road works, my lord.
Hello, you had undertaken,
Yes, my lord.
what stage it is?
My lord, now, even we have that financial, last time, my lord, that bid was cancelled. Now again, we have opened, and within 1 week, my lord, we are opening the bid, and we will definitely comply the order, my lord. Even my officer is also present,
Who is that officer who is present?
executive engineer now.
Why, what's the problem in doing it now?
My lord, that finance,
Last, this
there was
is
some.
19/8/2025. 1 month ಆಗಿದೆ. ಏನ್ ಮಾಡಿದ್ದೀರಾ
The
ಅವತ್ತಿಂದ
bid,
ಇವತ್ತು?
bid which was, there was some difficulty in the
What
technical.
difficulty?
Only one bidder had participated, my lord. So we
Where,
cancelled.
where are the details?
I'll furnish the details, my lord. I'll
List the
kindly-
matter on Wednesday. The learned counsel for the petitioner to, respondent to place the details about the tender being called and the tender being shelved. Yes.
I'll
SHELV. Next.
Obliged.
Much obliged.
47,
ಎಲ್ಲ ಬಿಡಿ.
I appear for respondent number 33.
After vacation, yes.
Lord, this was, my lord, the entire dispute has been
I will hear it
decided
after
by the
vacation,
Honorable
sir.
Supreme
Yes.
Court.
List
All-
them.
Nothing to be
ಒಂದು
decided.
ನಿಮಿಷ sir.
Honorable Supreme Court in its order has already declared that the
Then what is-
agreements upon which they are claiming before this.
What
order-
remains here?
Nothing, my lord.
That is what.
Nothing remains.
This
Yes,
entire
madam.
exercise is futile, my lord.
I mean, with the connected matter, with 37.1.
Pass over, get the senior. Yes. The Supreme Court has concluded, why should we keep quiet?
Yes.
Office objections?
38,
Infructuous, huh?
no, it's not infructuous, my lord.
ಶಿವಕುಮಾರ್ ಸರ್, ಈ ಕಡೆ ಬನ್ನಿ.
38. I mean, If he's saying that his suit is infructuous, that is correct. Because that's my contention. My lords, kindly see, I'm the defendant in the suit. I'm the landowner. Respondent is the tenant. They filed a suit for injunction against me. Thereafter, I've started an eviction proceeding which has been decreed, my lords. I have a copy of the judgment and decree. I filed a memo for dismissal of the suit. The memo was rejected on the ground at page 19 that my eviction suit is pending and it's not yet decreed. Now, my lords, that it has been decreed, he's been asked to vacate in 45 days. The suit will not survive, my lords.
The subject to appeal, my lord, there is appeal.
ಮಾಡ್ಕೊಳ್ಳಿ.
No,
Injunction
he
suit.
wants to appeal.
Injunction suit, my lord, it
Kindly
can't
see,
be.
my lord.
Is this what commercial law is ante ಇದೆ?
These fellows is a commercial property. It should have been filed in the commercial court.
No, no.
His OS is
Bare
filed in
injunction
the
suit, commercial
civil
court has no jurisdiction. It is filed before the regular.
Anyway,
court.
there's an interim order here.
Please, my lord.
What happens to the interim order now?
My
But
lord,
this is
please-
regular OS.
Please, my lord, if your
It
lordship
will continue.
to allow the rate, then the suit, the memo will have to be accepted. His suit will be dismissed. My memo is for, kindly see, my lord, page 43, 42 is my memo.
Yes.
I filed a memo to dismiss his suit for injunction against me because I am the landowner. There can't be an injunction against the true owner. After
Yes.
I have started a suit for eviction, the trial court rejected my memo only on the ground that there's no eviction decree as yet at page 19. Para 6 admitted.
Now there is a decree.
eviction decree.
Then it's fine. Over.
There is an eviction decree, the appeal period is still there.
Appeal ಹಾಕೊಳ್ಳಿ.
ಹಾಕ್ಕೋತಾರೆ. The only thing is whether he has.
No,
to
if the memo that is filed is rejected on the ground that there is no decree, now there is a decree. As simple as that.
But the suit cannot be dismissed is what I'm saying.
Why?
Suit cannot be dismissed on that ground.
On which ground?
On the ground.
ಈಗ memo, where is the order on memo, madam?
Page 19 is the operative portion. It starts at page 16. Page 19, paragraph 6. Admittedly,
Suit for eviction, subsequent landlord, still pending consideration. The court has not yet passed any decree. We will record this and direct the court to pass necessary orders.
That's all could be done.
Yes. The petitioner is before this court calling in question an order of the concerned court which declines to pass an order on the application filed, order 7 rule 11,
no, my lords, I filed a memo.
Just
for
a
this.
memo.
filed a memo for dismissal of this suit on the score that there is another commercial OS in commercial OS 299 of 2023 pending consideration. The concerned court rejects the memo on by the following reason, comma, inter-alia, page 12, page 19. The learned counsel for the petitioner now submits that the suit that the aforesaid paragraph referred to in the order impugned has now been dismissed.
Suit is decreed.
Suit is decreed.
Has now been decreed, and the direction is to deliver vacant possession of the suit schedule property to the hands of the petitioner. In that light, the order of the concerned court, which did not consider the memo on the ground that the suit, there was no decree in the suit, is no longer in existence, is no longer valid. In that light, I deem it appropriate to direct the concerned court to pass necessary orders bearing in mind the decree of the suit in commercial OS 299 of 2023 within an outer limit of 4 weeks from the date of receipt of the copy of the order, ordered accordingly.
39, interim.
Heavy IOC. 40 withdrawal.
41.
41 also withdrawal. Alla, sorry.
That's for respondent in 51. Small submission.
ಯಾವ್ದ್ರಲ್ಲಿ madam?
Serial number 34. Interim order may be extended.
Don't worry. Yes.
39. IP for respondent in 41. 41, sorry.
41.
I have withdrawn the original documents, my lords.
You?
I have taken the original documents.
This ತಗೊಂಡಿದ್ದೀರಾ?
Yes, my lords.
Learned counsel for the petitioner submit, respondent submits that all the original documents have been taken from the registry by the respondent. Therefore, the application in IA2 of 2025 does not survive for any further orders disposed as having been complied with. Next.
42
Withdrawal.
43.
43, my lord, needful has been done because they are not ready to receive the summons. my lord.
Learned counsel submits needful has been done. AV, IOs. Next.
My lord, one submission, my lord. Your lordship is granted an interim order for stay the further proceedings, my lord. It is a plaintiff suit, my lord. We have challenged the partial rejection of the plaint by the application filed by the defendant 7 and 14.
An application?
IF4 ಅಷ್ಟೇ
An application.
rejection of plaint. Suit is partially dismissed by the trial court. Your lordship is observed that partial is not permissible, my lord. As IA number 4, annexure E ಅಷ್ಟೇ stay ಆದ್ರೆ ಸಾಕು.
List on 10th October.
Interim order continue.
Interim order subsisting would continue to the next. Yes.
44, interim order.
Owner developer lessee matter.
Oh, ಅದಾಯ್ತಾ ಇನ್ನೊಂದು ಇದೇನಿದು ಪೆಂಡಿಂಗ್ ಇದೆಯಾ?
Usually there is some because he has never asked for withdrawal. His main prayer is that I should deposit in terms of justice.
Whatever it is, he is entitled to that.
No, all I'm submitting is that's not the prayer.
May I
Lordships have to
start
see the main
what I
prayer.
have asked for. May I only start what I
ಅಲ್ಲ
have asked for.
ಈಗ prayer ಏನಾದ್ರು ಇರಲಿ. Is he
But in all
is
fairness-
entitled to receive rent or
But in all fairness, though he has not asked for it, in terms of what Maunesh had said about GST being deposited, if he wants to withdraw, let him do.
Might I only ask what I have asked for.
ಏನ್ ಕೇಳಿದೆ?
I have said, deposit the rents in terms of the lease deed. In terms of the lease deed, the rents would start on and with effect from April 2023. I just point out why and so. That is all. Now, the lease deeds have been executed in the month of September 2022 and so on. The learned trial judge comes to the conclusion, deposit the rents on and with effect from 1/3/2024. In the lease deed, there is a rent-free period which the developer has given. Now, I'm not getting into the nitty-gritties or intricacies of whether he could have or not. I'm only saying that.
ಮುನೀಶ್ ಅಲ್ಲೇ ಇದ್ದಾರೆ? Why have you pushed him to the oblivion?
So let him come.
ಹೇಳಿ ಸುನಿಲ್. Yes.
That's now 6 months was 7 months was the rent-free period. Now that excluded from September. Subject to all understandings, from with on and with effect from April 2023. Rents will have to be deposited. Learned trial judge has only said deposit from 1/4/2024.
You have challenged that?
This is the only limited challenge. Nothing else for the moment.
ಈಗ ನಿಮ್ ಪ್ರಕಾರ ಎಲ್ಲಿಂದ ಬರಬೇಕು?
As per the lease deed, it starts from 7 months from the lease free period. That is, it starts from April 2023. 1 year rent is what they will have to deposit. Beyond this,
Then the entire dispute will be over. I mean, ಅವ್ರು ತಗೊಂಡು
ಈಗ tenant ಯಾರು? Your client is a tenant?
Yes, I'm the tenant.
It has nothing to do with
The short answer is twofold. One, that there is a rent-free period. Second, that it is from this is an interpleader suit originally as filed. Now, of course, amended for specific performance also. From the date of the suit, my lord, I have been depositing, and there was no occasion for me to deposit for a period prior to that. In fact, no, it is not just.
No, we will only direct that after the rent-free period is over.
Yes.
Whatever rent you have to deposit,
I
please
have
deposit.
deposited everything. There is nothing.
No, if not deposited, that's all.
That's all.
That's all the order.
In fact, can I make one submission?
That is all.
I'm sorry. Can I just make one submission? This has been considered by the learned trial judge and accepted. My memo of calculation is, my lord, already on record. There's nothing
That is why, if not already deposited.
I want to make one further submission. There is the reason I want to just be clear is there is another application made saying deposit 130 crores. That's been dismissed. So I will not.
We're not on that.
That's all. I just want.
You also accept that there was a rent-free period for a particular period.
Absolutely.
After the expiry of the rent-free period, you are bound to deposit the rent.
Absolutely.
No problem about it. I will only direct that after the expiry of the rent-free period, you will deposit the rent that began from that day. That's
Not
all.
from 2024.
I will not say anything.
Very well. I think I can urge it before the learned trial judge. That is all. I'm grateful.
We'll dispose it.
Please, not. That's enough.
The petitioner is before this court calling in question an order dated
Can I just make, sorry. What I'm instructed is from the date of the suit we have been depositing. If there is something else, I can deposit. Absolutely no quarrel. Deposit in court.
The petitioner, ನೀವು ಯಾರು ಡಿಫೆಂಡೆಂಟ್ ಯಾವುದ್ರಲ್ಲಿ?
Different number 4. I'll be for
ಅಲ್ಲ ಹೆಸರೇನು?
Nagaraj Reddy.
The petitioner is defendant number 4. Only 4, is it?
Yes, Pradhan.
Defendant number 4. Claiming to be aggrieved by the order of the concerned court that the concerned court directs deposit of rent from the date of the suit, the petitioner is before this court. The concerned court has passed the following order, page 65, 66.
Please.
The learned counsel for the petitioner would, to cut short the entire issue, submits that if a direction is issued to the concerned court to direct the respondent to deposit the rent in terms of the lease deed, it would suffice. According to the parties to the list, the lease deed contains a rent-free period.
7
Post 7 months, is it? 7 months of rent-free period. Post the rent-free period, rent had to be deposited, but the court has ignored the same. The learned senior counsel for the respondent submits that from the date of filing of the suit, the entire rent has been deposited month on month. Therefore, if there is anything else to be deposited, they would do it.
Can I just put out one? Insofar as petitioner, the only lease deed he is concerned with is lease deed dated 15/7/22. That Milord.
I'll clarify. Therefore, I deem it appropriate to dispose the dispute qua the present defendant number 4 and the respondent tenant, directing deposit of rent in terms of the lease deed dated 15/7/2022, if not already deposited before the concerned court.
Please.
Yes. The concerned court is to regulate its procedure in terms of the said direction.
Many applications are filed for withdrawal of.
Alli.
That.
All other reliefs would be
There's only one.
to be urged and considered before the concerned.
There's only one request. The other day in Monish matter, I could not mention. In respect of these rents, Lord, we have raised a certain claim before the arbitrator. Lordships may say all contentions before the arbitrators are left open.
Rent ಕೊಡಬಾರದು ಅಂತನಾ?
No. GST amount, okay. Nothing to do with that. Questions raised before. Questions, Lordships may specify questions relating to GST liability raised before the arbitrator are kept open.
All other contentions of both the parties urged in the subject petition shall remain open to be urged before the concerned court.
Arbitrator.
Concerned court or arbitrator as the case would be.
Please, great.
ಅದರಿಂದ ಏನ್ ತೊಂದರೆ ಆಗಲ್ಲ ಅಲ್ವಾ?
ಏನು ಆಗಲ್ಲ ಸ್ವಾಮಿ. Arbitrator ಇರೋದು ಏನಕ್ಕೆ? They have been appointed, not signed. Why should we tie their hands? We are jumping the guns, getting into all those nitty-gritty.
Yes. ಈಗ ಎಲ್ಲ ಆಯ್ತಾ ಇದು?
ಇನ್ನೊಂದಿದೆ ಅನ್ಸುತ್ತೆ.
ಇನ್ನೊಂದಾ?
ಇನ್ನೊಂದು ಮನೀಶ್ ಅವ್ರದ್ದೊಂದಿದೆ.
ನಾಳೆ
45.
Petitioner by plus lands which have been granted.
Just received a copy, my lord. Undertake to file wakal.
File, sir. The learned counsel Nitin Prasad submits that he has received the copy of the petition now,
A day ago, my lord.
2 days ago, and would seek time to file statement of objections. Objections, if any, in the next 2 weeks, list the matter immediately after vacation.
Much less interim order.
Interim order idea. Interim order subsisting would continue till the next date of hearing.
46.
My lord, I am for the petitioner. This is regarding a vehicle loan. Vehicle loan was completely paid, and subsequently they filed execution proceedings before one court. Then vehicle was handed over also. Subsequently, the arbitration, they referred the matter to the arbitration. Arbitration on a plain paper. Then subsequently, the arbitration, arbitration award expert by a cooperative bank chairman, manager. Then subsequently, the same arbitration award has been impounded annexed to Dean Ali Swami, 21 page number. Under 33-34, they have to pay 9,16,000 as against the recovery of 8,21,000.
1 minute. Emergent notice to the respondent, petitioner.
One more submission. They again refer the matter to. I'm sorry.
Yes. The petitioner is before this court calling in question proceedings in execution petition 2377 of 2021. The reason for knocking at the doors of this court is impounding of the award of the arbitrator for imposition of penalty and stamp duty. in the light of the said order being on the face of it contrary to law, further proceedings before the concerned court shall remain stayed. Office objections to be complied with in the meantime. Next.
One more submission, sir. They have made in two courts the same submission.
ಈಗ ಏನ್ ಚಾಲೆಂಜ್
Exhibition
ಮಾಡಿದ್ದೀರಾ?
2040, that's okay.
47.
I appear for the respondent, my lord. I'll file wakalat, my lord, and as well as this matter will become infractious for the simple reason, my lord.
Infractious,
Because, my lord, they have sought for the handing over of the equipments, my lord, in the presence of the court commissioner appointed by the trial court, my lord. The equipments have been handed over, my lord. There is a report of this one.
We have no instructions regarding the same, my lord. I'll shortly
And,
maybe
as
fix
well
my
as
lord and
my-
I'll submit on the same, my lords.
List the matter on 10th October.
Much obliged.
The interim arrangement may kindly stand extended.
The interim order subsisting would continue.
My lord,
to the-
the amount has been withdrawn, my lord, even if the
Whatever.
interim order
Yes,
is
next.
continuing, my lord.
Much obliged.
Much obliged.
48 appearing for sole respondents counsel.
My lord, it's a suit for permanent injunction where I am for defendant 1 to 3.
Vacation ಆದ್ಮೇಲೆ ಕೇಳುವ.
No, one submission. It may be, suit itself may be closed.
ಅಂದ್ರೆ
Order of injunction can be discharged because it is
Oh,
not
expert
maintained.
ಇದೆ. We'll take the
It is. it
suit
is-
ಯಾವ ವರ್ಷದ್ದು?
Alla, 1 minute.
This year,
Suit itself is not maintainable. I am the plaintiff. Arbitration clause is there.
ಇವರೇ ಹೇಳ್ತಾರೆ not
Automobile is there. Therefore, suit itself may be closed and injunction order may be discharged. I will go before the commercial court. I am helping my learned friend even without claiming the bill also.
Yes.
There is an arbitration clause, my lord.
Then
My lord, there is only one submission I would like to make. My lords were pleased to grant me an interim order on the previous date, saying that parties to the list, they will be restrained from interfering with carrying on the business, and it should carry on prior to how it was being done prior to the temporary
Usage of the
injunction.
shop.
Please, my lord.
What happened? ಬಿಡ್ತಾ
Now
ಇಲ್ವಾ?
what
They have
happened?
locked.
Both of them have locked.
There are two locks for a single door. One from the plaintiff side, another from the defendant.
Neither do they go to the shop, neither do they allow me to go to the shop.
ಅದಕ್ಕೆ ಸೂಟೇ ಕ್ಲೋಸ್ ಮಾಡ್ಬೇಡ ಬೆಟರ್.
The suit may be closed. We will file a memo before the trial court. Order passed by the trial court may kindly be discharged. We will avail the remedy in terms of the
Petitioner is before this court seeking the following prayer heard so and so. Owing to the prayer of the petitioner, this court on 9/9/2025 had passed the following order. The learned senior counsel M.R. Rajgopal, appearing for the respondent, would submit that the suit is not maintainable in the teeth of the subsistence of an arbitration clause, and the plaintiff be permitted to file a suit before the appropriate forum, and the interim and the order granted by the concerned court be discharged. In the light of the said submission and the admission of the counsel for the petitioner that there exists an arbitration clause, the suit is held to be the suit is withdrawn ಮಾಡ್ಬಿಡ್ಲಾ?
not maintainable.
The suit is not maintainable. It is open for the respondent to file a appropriate memo before the concerned court for a needful action. In the light of the said submission, the order of the concerned court and the proceedings before the concerned court and the order so passed shall all be discharged. Yes.
One word between fair submission.
Correct. Then senior counsel, in his usual way.
Very rarely we are getting such occasion.
Correct, sir. Yes. In his usual way makes a fair submission antane ಮಾಡಿ. Yes, sir.
Preliminary hearing 49.
Grateful, my lord.
No, this is a matter which was covered. My lords had directed me to file a synopsis.
After vacation, yes.
It's covered, my lords.
Will
The Honorable Supreme Court as well.
List the matter immediately after vacation. Date 9th ಹಾಕ್ಬೇಡ. Yes. 9th October.
Please.
Next. No, 14th, sorry, Siddharth, 14th October.
Please.
Yes.
50.
For the petitioner in this matter.
Dispose ಮಾಡೋ ಅಂತ ಇದ್ರೆ ಹೇಳಿ.
Dispose ಆಗ್ಬೋದು ಅಂತ ಹೇಳಿ.
But we have questioned the award notice issued. It requires hearing because we are
14th October. Yes. Enter ಮಾಡಿದ್ಯಾ? Subsist. Yes.
Suppress the matter and my lord, they obtain the award amount. That is
Aye.
last time your lordship said.
14th.
51.
Lord,
May I request for a Milord short accommodation?
Intermodal,
till
madam.
Tuesday, Milord.
Tuesday after vacation. AVIOC, heard the land council sounds.
Because the intermodal may kind.
AVIOC, after vacation, intermodal continues.
Sorry,
Yes.
date may be fixed, Milord.
Date, move ಮಾಡಿ, yes. ನೀವೇ move ಮಾಡಿ, ತಗೊಂತೀರಿ.
And we.
I have not heard that abbreviation anywhere, my lord.
Sir?
I had not heard your lordship's innovative abbreviation. What? AVIOC and the.
AVIOC, after vacation, intermodal continues.
I'm grateful.
Yes, sir.
52?
Kindly pass over, Your Honor.
Passover, ivattu, no Passover.
The
Lordship has heard this
Karana?
matter on the last date of hearing,
Yenidu?
Lord. This is regarding, they have accepted the compensation under consent. Now they are asking for higher compensation. Their writ petition came to be dismissed. Writ appeal also disposed. And if they are asking for interest, the Sakayama case is applied, 9%.
Some citation is there, ma'am.
Some citation is there.
Please, ma'am.
And some orders are also there, coordinate bench after vacation.
Date.
No dates, after vacation, yes. Next.
53?
But I appear, my lord, for the petition as in 53.
Yes,
Matter
sir.
has to be heard, my lord. Your
Yes,
lordship shall
after
take
vacation.
this today. Please.
Immediately after vacation, that's all.
Intermodal ಇದೆಯಾ?
ಇದೆ,
ಇದೆ.
last time ತಾವು ಕೊಟ್ಟಿದ್ರಿ.
ಇದರಲ್ಲಿ ಒಂದು ಆಡ್ ಮಾಡೋಣ. IAV, IOC. Immediately after vacation,
Yes,
intermodal
immediately after
continues.
vacation.
Yes,
Grateful, my lord.
yes, sir.
Okay.
Appear for the petitioners.
54.
54.
Ah.
Because in the connected matter, if I may pass on the, in a connected matter, there is a status quo order. Because what happened was there
ಇದೇನ್
are
ಹೇಳಿ? What is this?
because this is Indranagar, 54 is Indranagar Resident Welfare Association. 54.1 is Kormangla Resident Welfare Association. There was a project, Malod's.
Oh, this,
scheme.
BDA has let it off.
Yes,
Ah,
no,
yes.
no, no.
Yes.
So it is not, Malod's, if I may submit.
And the residents are being troubled, is that the one?
No, Malod's, no, residents are not being troubled, Malod's. We are challenging the scheme that the BDA promulgated to develop about 7 markets across the city. In one of them, Malod's, in Sadashinagar Resident Welfare Association, there is a status quo order by coordinate bench, and now that matter is also before your lordship. That matter is now gone to 2310. I'm passing on the order sheet, Malod's. Kindly take a look. 2310, Malod's, the number is WP 33-555 of 24.
ಯಾವುದು ಸದಾಶಿವನಗರ ಅಂತ ಇದೆ ಅದಾ?
Sadashinagar Association. Now, if your lordships look at page
In
4.
every ಇದು ಇಂದಿರಾನಗರ ಸದಾಶಿವನಗರ connected ಯಾವುದು ಕೋರಮಂಗಲ everywhere it is, isn't it?
Malod, this is the same scheme. The concession was granted in 2018. The no work order was issued until 24.
2018 ಇವಾಗ ಚಾಲೆಂಜ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
But 24 no work order was issued because there were protests by citizens across the city.
All right.
Everybody thought it was gone. Then in 2024 February, they issue work orders, separate work orders for some of the different projects. In respect of Kormangla, Malod's, we had filed a 54.1. We had filed. No urgency was there, Malod's. We did not ask for any stay in that matter. In respect of Indranagar, Malod's, which is the latest of the writ petitions, there is some work going on, so we are seeking a stay in that, Malod's. That has not been heard fully. Last time they said they were going to file some procedural documents before your lordship. Then, Malod's, in Sadashivnagar, the coordinate bench has granted a stay because work had started. So the coordinate bench said maintain status quo. After that, they have modified the status quo order to allow construction of the compound walls because of rains. So we are seeking, Malod's, and that matter, Malod's, is posted on 2310. All the issues are the same, Malod's, which is KTCP provisions being
Who
followed
appears
or
for the
not.
respondents?
IP for the respondent Bangalore Development Authority.
ಈಗೇನ್ ವರ್ಕ್ ನಡೀತಾ ಇದೆ ಇದರಲ್ಲಿ?
ಇಲ್ಲ, ವರ್ಕ್ ಇದನ್ನ ಅವ್ರನ್ನೆಲ್ಲ ಖಾಲಿ ಮಾಡಿಸಿ, then that is how the concession agreement says. The earlier who were there, they were to be accommodated and rehabilitated again once again thereafter. But there is a distinction between Sadashivnagar and Indranagar and Kormangla. But they are all they stand on two different footings. But that is why, Lord, on an earlier occasion also.
ಸದಾಶಿವನಗರ ಸ್ಟೇಟಸ್ ಕೋ ಇದೆಯಾ?
ಸದಾಶಿವನಗರದಲ್ಲಿ ಅಲ್ಲಿ
ಆಯ್ತಾಯ್ತು ಹೇಳಿ.
there, Lord, what had happened is that property where it was coming up was sought to be said as a civic amenity site.
You said you will produce something on the last.
Yes,
what is that?
Lord, the last occasion we had got it. There are two more matters, Lord, which have been clubbed. That is why, my lord, we two more matters which have come up. That's why, my lord, we seek for a week's accommodation. to
You,
produce
I'll
everything.
take this on Tuesday. We'll consider their application for stay or whatever it is on Tuesday. If,
Yes.
if somebody is, some citizen is being hurt, then we'll
Lord,
see.
citizens are not being, Lord, this is where, my lord,
Troubled, we'll see.
Indiranagar, my lord, no citizen, Indiranagar and Kormangala, my lord, where the CAT was there. Apart from that.
Oh, that
from
KAT
that
building.
Building, my lord, they are talking about.
It's not.
Lord, it is, your lordships have heard it on the last
Yes,
occasion.
yes,
I
I've
showed
heard it, yes.
I showed it that this was
We'll
a
take it on
commercially
Tuesday, sir.
demarcated area.
List
Please.
on,
Also, it is
ಅದನ್ನು
civic
ಟ್ಯಾಗ್
community.
ಮಾಡ್ಬೋಣ ಹಾಗಾದ್ರೆ ಎಲ್ಲ if the issue is similar, ಸದಾಶಿವನಗರ ಟ್ಯಾಗ್ ಮಾಡೋದು ಬೇಡವಾ?
Sadashivanagar, there are
According
some
to me, my
different
lords, if
issues.
your lordships look at page 6 of the memo I submitted, the prayers are the same, identical prayers.
Prayer may-
And we are also alleging the same provisions that are being
With
challenged.
a
under
list on Tuesday in preliminary hearing. We'll tag this or not?
My lords, tagging is best.
ಇಲ್ಲ ಬೇರೆ ಅಂದ್ರೆ ಬೇಡ.
Contention, my lord, there was that there is no sanction plan. for
All,
carrying out the construction.
all right, we'll see. Let that come on 2310.
I'm also asking the same thing. Anyway, my lords.
Yes, these two will take on Tuesday. 54 and 54.1 Tuesday.
Please.
Intermodal ಇಲ್ಲ ಅಲ್ಲ ಅವತ್ತು ಕೊಡೋಣ.
There is no interview.
Yes, we'll hear on that.
55.
My name may be deleted, my lords. Mr. Prasanna
Encroachment.
Kumar has filed NOC Vakalat.
LV.
That encroachment matter, my lords.
ಎಲ್ಲಿ ಪ್ರಸನ್ನ ಕುಮಾರ್?
It
ಪ್ರಸನ್ನ
will be
ಕುಮಾರ್
passed over,
ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಲ್ವಾ?
Prasanna Kumar, my lords, in one he is the petitioner, in the other main matter, my lords, he is the respondent.
ಇಲ್ಲಿ Ajit Kalyan should be deleted. Registry to delete the name of Ajit Kalyan as appearing for the petitioner. Pass over.
Please.
ನೋಡೋಣ.
56.
ರೀಚ್ ಆದ್ರೆ ಇಲ್ಲ.
56.
Mediation report, what happened?
The matter is before Mr. Prashant Chandra. He's posted the matter on 26th. We are seeking an adjournment to 3rd. My lords, may kindly fix a date.
Test the matter on 10th October.
Please, great for my lords.
Interim orders to be
Registered for Tuesday, I'll intimate, Mr.
ಆಯ್ತು ಹೇಳಿ ಅವ್ರಿಗೆ.
interim orders to be continued in this.
That will continue.
Interim order is,
Yes,
is in 56.2, my lords, only that's it.
Wherever, in whichever petition interim order is there. Yes,
That's
next.
all.
In all cases, interim.
57.
Nishant.
Sir, I appear for the petitioner. Because the petitioner is challenging the order of compromise, my lords, passed before the reference court, dated 12/7/2025, my lords. My lords, may kindly drag the court attention to the order of the coordinate bench, my lords, at annexure K, page 186.
Annexure K, page.
186, my lords. My lords, this is where, my lords, I filed an application.
Suit
under
for what, sir?
My lords, this is before a reference court, my lords, LSC proceedings.
LAC proceeding. Yes, sir.
My lords, may kindly take page number 194, my lords.
Where is the settlement?
My lords, I was not a party before the reference.
Where is the settlement?
My lords, settlement, my lords, is at annexure A, page 136, my lords.
130?
136, my lords. It's a compromise. Plus, there was a temporary injunction, my lords.
ನೀವ್ ಯಾರು?
I was not a party before the reference.
Who are you?
My lords,
You are 3 in number. ಯಾರ್ ನೀವೆಲ್ಲ?
I am assailing my rights with from FDP 1 of 2001, my lords. I was allocated 3/4 guntas of land in 20 guntas of land, which is a subject, which is a scheduled property, my lords. My lords, thereafter the land came to be acquired for formation of drainage. Thereafter, my lords, this entire extent of 20 guntas was a property before money recovery suit, and a successful bidder purchased the property. My lords, that is the caveat hearing. Thereafter, my lords, I came to know.
Where is the FDP cost rate ಇದೆ?
FDP is at, my lords, annexure
Page
B,
140 ಇಲ್ಲಿ where are, what's your name?
My lords, the plaintiff.
Jayamma Deepu Santosh.
Please, my lords.
Jayamma Deepu Santosh, plaintiffs.
Please, my lords.
Yes, madam.
That's only 194 page, my lords. I'll only read this, the order of the coordinate bench, my lords.
Page.
My application.
Page.
Page 194, my lords.
194.
Please, my lords. The petitioner no doubt have got valid right title in the petition land, which is a subject matter before the reference court.
ಯಾಕೆ ಮೈಕ್ ತಗೊಳ್ಳಿ?
Which is a subject matter before the reference court, as rightly stated by the learned counsel for the petitioners. Petition number 1 was a party to the final decree proceedings in FPP number 1 of 2001. It is evident that she was allotted 5/3/4 guntas of land. This would clearly indicate that any compensation amount that would be determined by the reference court, the petitioner will be entitled to lay her claim in terms of the compensation determined in final proceedings in FDP number so and so. It is also evident that the present petitioners to safeguard and protect their interest sought for interim orders in a partition suit filed by them in OS number 415/2011. In the said suit, the present
ಅಷ್ಟೊತ್ತಿಗೆ ಕಾಂಪ್ರಮೈಸ್ ಆಗೋಗಿತ್ತಾ?
no, my lords.
ಈ ಆರ್ಡರ್ ಬರಬೇಕಾದ್ರೆ ಆಗಿರ್ಲಿಲ್ಲ ಇನ್ನು.
ಆಗಿಲ್ಲ, my lord. My only request is that, my lords, the present petition may be disposed of, protecting my right with respect to 5/3/5.
What is your share?
5/3/4 guntas, my lords.
Yes.
Let them take compensation with respect to the remaining extent.
Lord, already the order in terms of the order compensation has been released, my lord.
ವಾಪಸ್ ಕೊಡಿ.
Lord, I'll also point out what they've suppressed. If I may pass on this.
What
order.
suppressed? There is an order of this court. You are not a party here?
My lord, here, what has happened, my lord?
You are not a party here?
Lord, I was a party.
Served unrepresented.
But subsequently, my lord, there is a suit for partition filed by them in respect of the very same property. They are banking on the order of injunction in OS 415.
You forget about that. Now, in this OS of 2011, 415 of 2011, ಅದೇನು?
Adraliga injunction has been rejected, their application. They sought for an order of injunction.
Injuncting what?
Seeking an order of injunction restraining the municipality from releasing compensation in my favor, my lord. That application has been rejected, my lord, on 11/9/2024. So their very same relief in their suit for partition in respect of this property. This order, my lord, has been suppressed by them. They have not mentioned about this. They have
Interim
mentioned
orders in a partition. No, madam, it is also evident present petitioners to safeguard, they protect their rights sought for interim order in the partition suit filed by them in 415. What their injunction ಕೇಳಿದ್ರ ಅಲ್ಲಿ?
ಅಲ್ಲಿ ಕೇಳಿದ್ರು first ಇತ್ತು, my lord. First initially there was an ex parte order. Subsequently on merits their application has been rejected on 11/9/2024.
In OS 415 of 2011.
In OS 415 after this order is passed. This
That
is
is not-
passed in 2021.
That's not divulged here?
That is not mentioned here. That is what I'm producing.
That's the order of temporary injunction, not to enter
No,
into compensation.
that would not have assumed significance, but for its reference by the coordinate bench. The coordinate bench refers that your rights are protected by grant of an injunction in OS 415 of 2011, correct?
Please,
Now that injunction has been rejected.
The order of injunction, my lords, was extended until further orders.
Where?
11/6/2012, page number 19.
ಈಗ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ರಿಜೆಕ್ಟ್ ಆಗಿದೆ ಅಂತ ಹೇಳ್ತಿದಾರಲ್ಲ.
Just pass on, your lordship.
ಅವರು ಕಾಪಿ ಕೊಡಿ, ಅವರಿಗೆ ಗೊತ್ತಿರಲ್ಲ. The petitioner submits that the semblance of his rights stems from the order passed by the coordinate bench of this court in paragraph 8 quote madi, page 194-195. The learned counsel submits that this court had observed that the rights of the present petitioners are adequately protected in the light of the injunction, granted and the suit pending in OS 415 of 2011. The learned counsel for the petitioner would now submit that the injunction was extended until further orders, but the respondent's counsel weaves a different story, that the court concerned, which was hearing the application for injunction, has rejected the injunction as on the date of filing of the petition itself. The fact is not divulged by the petitioner. In that light, the matter would require consideration. The respondent shall file their statement of objections by the next date. The learned counsel, Srimati Rakshita DJ, would submit that entire compensation is all pay ಆಗಿದೆಯಾ?
1,50,00,000 has been released.
The entire compensation that the respondents are entitled is already paid. They list the matter on 10th.
Also, my lord, they also preferred questioning my sale auction.
10th.
They preferred a miscellaneous petition.
Adu
That is
dismiss.
also rejected. That is also suppressed by them, my lord. And a detailed order is
May have
passed.
to be issued, my lords. Notice may have to be issued, my lords.
Others,
Please, my lords.
emergent notice to the remaining respondents returnable by the 10th of October.
This is why your lordship initially didn't grant an order of injunction.
Even now I have not granted.
And compensation is released. If I may place this on record, my lord.
Registry.
Please.
Office objection may be over.
Objection ಏನಿದೆ? Accepting the submission of the council, office objection stands overruled. Next.
Obliged.
58, interview.
Tender.
See, it is that KSRTC matter, where we got that commercial space on lease with
Your Lordship's,
Oh, this matter, yes.
They have to file their objection, KSRTC, not
The
this.
special order matter.
KSRTC will file its
Early the
objection.
KSRTC.
Last time.
Madam is here.
My lord, the matter, I have some instructions, my lord, can it be posted on Monday, my lord?
Monday ಇಲ್ಲ, Tuesday.
Yes.
Let's 20. Where Suran ಅವ್ರು ಇಲ್ವಾ? ನಿಮ್ಮ ಹೆಸರು ಹಾಕದ?
ಬೇಡ ಬೇಡ, I'll appear along with him, my lord. on Tuesday.
ಆಯ್ತು. Along with him ಅಂತ ಹಾಕದ?
ಬೇಡ, Tuesdayನೇ.
ಆಯ್ತು, Tuesday. Yes. Intermodal subsisting will continue to the next.
59 14%.
ಮೋಹನ್ ಚಂದ್ರ. ಸೆಟಲ್ಮೆಂಟ್ ಅಫಿಡವಿಟ್ ಹಾಕ್ತೀರಾ? ಅದು ಗೊತ್ತಾಯ್ತು, ಹೇಳಿ.
ಅದರಲ್ಲಿ ಏನಾದ್ರು ಅಫಿಡವಿಟ್ ಹಾಕ್ಲಿಕ್ಕೆ ಹೇಳಿದ್ರೆ ಅದ್ರಲ್ಲಿ ಅಫಿಡವಿಟ್ 25ಕ್ಕೆ ಉಂಟು, ಅದ್ರಲ್ಲಿ ಹಾಕಿದ್ರೆ ಇದು 26ಕ್ಕೆ ಇಟ್ಟರೆ ಅದರಲ್ಲಿ ಏನು ಇದು ಮಾಡ್ತಾರೆ ಕಂಡೀಷನ್ ನೋಡಿ ಇಲ್ಲಿ ಮಾಡ್ತೀವಿ 20.
ಆಯ್ತು, he will vacate, don't worry.
ಮತ್ತೆ ಇದು ಇಂಡಿಪೆಂಡೆನ್ಸ್ ಅಪ್ರೂವ್ ಇದು ಕಂಟಿನ್ಯೂ ಆಗಲಿ.
ಆಯ್ತು, ಅಲ್ಲಿ ಹಾಕೊಳ್ಳಿ ಅಫಿಡವಿಟ್.
ಎಸ್
ಅಲ್ಲ, ಇದನ್ನ ಅದ್ರ ಜೊತೆಗೆ ಕನೆಕ್ಟ್ ಮಾಡಬೇಡಿ.
ಇಲ್ಲ ಇಲ್ಲೇ ಇರ್ಲಿ, ಅಲ್ಲಿ ಹಾಕಿದ್ ಇಲ್ಲಿ ಬೈಂಡಿಂಗ್ ಆಗುತ್ತೆ ಬಿಡಿ. The learned counsel for the petitioner in person Mohan Chandra submits that in the RFA he is filing an affidavit as is directed. In the light of the said submission, list the matter on 26th.
60.
Appeared for the petitioner's counsel. In WS at page 112.
Yes.
I have specifically raised the contention that simple suit for injunction is not maintainable.
Declaration.
Kindly turn to page 113, paragraph C.
Yes.
I had raised that contention in WS. Injunction application was temporary injunction matter had come up before the court in an MFA before this honorable court. In that, I had raised this contention also as one of the contentions for non-granting of injunction, etc. Kindly see, para 36 may kindly be seen, page 23. Page 23, para 36. Para 35. Reading the full judgment in so and so, refer to supra shows that merely because defendant challenged the title of the plaintiffs need not seek declaration in all cases, and only if there is cloud on title of the plaintiff, she or he has to seek declaration. In the case on hand, Parvati Chattur during her life did not challenge the title of the vendors of the plaintiffs. The properties in question are vacant sites except few temporary structures. Therefore, this court is not persuaded to accept the contention that the suit was prima facie not maintainable for not seeking the declaration of title. This is the observation made. I made an application. During when the evidence was being led, I wanted to speak about this aspect. Other side objected, and I was not allowed to lead evidence on that point. On the ground, there is no issue or anything. Then I pointed out in the WS, I have raised this contention. Please frame an issue on this. That is now rejected on 2 grounds, my lord. Kindly see the order.
Page.
It starts at page 18.
I think page para 13.
Para 13. A perusal of the order sheet shows that defendant took sufficient time to subject PW1 for cross-examination. When the adjournment was given to take further adjournment and protract the proceedings, defendant has filed the instant application for framing additional issue which are not at all relevant to decide the real disputes in controversy between the parties. In this case, suit is filed for injunction and the trial is already completed. This is factual error. Trial is already completed. Plaintiff side evidence is closed and also defendant side evidence is closed, and the case is posted for arguments at arguments. And at belated stage, IA is filed. Therefore, the application deserves to be dismissed with cause. I have perused the above rulings of the advocate. Then your lordship may kindly come to last 3 lines. In view of the order passed by the Honorable High Court of Karnataka, and the framing of issue seeking declaration does not arise. Accordingly, I answer the point in the negative. I would say, even with the observation at an interim stage, that will not preclude the defendant from raising that contention. Whatever might be the view that court takes is different. But to say that it is concluded in the at interim stage in considering the injunction application is wrong. Then as regards the first point that trial is already over, your lordship may kindly see the order sheet, page 35. It starts at page 35. Kindly go to page 60, 62.
Yes.
An application, plaintiff's PW1 examination and cross-examination was closed. Application was filed for recalling this order.
So trial is still pending.
Trial is still pending. It is for cross-examination of PW1. Factually, that's a error.
Yeah, factual error.
Please, and that was given as a reason. Therefore, I pointed out.
Yes, Vikram sir.
Yes, my lords. Now, issues were framed, my lords, way back on 24th of May 2021. Now, I have filed a suit, my lords, for bare injunction. The defendants, my lords, are not my vendors. The vendors, my lords, are different parties who have also filed a suit against these plaintiffs.
Now, what is the issue that is sought to be framed?
That is, kindly see that also, my lords. Kindly see IA 9, which is at page 124, page 125. They have not said what issue. They have just, kindly see paragraphs 3 and 4. Vaguely, my lords, they want to raise a dispute regarding title. Now, title was never in dispute, and in any event, my lords, I am the dominus litis. I want to. There is no question as regards title as
We
far as
are
I am
not
concerned.
asking him to seek declaration.
Counterclaim hakidira.
We are not asking him to seek declaration. We are contending simple suit for injunction in the facts of the case is not maintainable. That is what our contention is.
This honorable court has said is not in the MFA at para 36.
It's not necessary to seek declaration.
Correct, my lords. And that is ordered dated 9th November 21.
Interim order nalli observe ಮಾಡಿದ್ದು, it has closed the issue ಅಂತ ಬರೆಯೋದಾದ್ರೆ I have no objection if that is the legal position. That is what the contention they advanced, and the court below says in the interim order this is observed, therefore it is not necessary. That's not the legal position.
As far as framing of an issue is concerned, our concern is 9th of November 21 is this honorable court's order. This application is filed in 2024. After the evidence came to be closed because they constantly kept seeking time, they want to protract the proceedings, what our concern is. And now this additional issue in my suit, my lords, to raise questions about title and everything, my lords, would not be appropriate, would be my respectful submission.
And in that injunction MFA, your lordship may kindly see para 37. How that very contention is used against me. Para 37. So far as the balance of convenience, the very fact that defendants are disputing the title and possession of the plaintiff shows their interference.
You are the tenant, is it?
No. They were the original owners who had sold it. I have purchased the sites that were developed from other vendors. So in fact, those vendors also, there's an OS pending
And the
against
daughter of the original owner. They claim purchasing through several persons.
But our suit ಅಲ್ಲಿ ನೀವು additional issue ಹೆಂಗ?
That's the only.
Additional issue, maintainability question ಮಾಡೋದು ನನಗೆ ಓಪನ್ ಇದೆ ಅಂತ ತಾವು ಹೇಳಿದ್ರೆ ಸಾಕು. ಅವ್ರ ಇಶ್ಯೂ ಫ್ರೇಮ್ ಮಾಡದೆ ಹೋದ್ರು ಇಲ್ಲ. Now they say it is concluded in MFA.
You argue that, no problem.
That's not being allowed. I was not allowed to put question. Otherwise, I would not have filed
Let
this
that be
application.
argued. Why issue for that?
I was not allowed to put question to him that I am disputing his title.
Fair enough. If they want to argue it, when
Court will consider on its merit.
Finding by this honorable court, but this, since we are on the limited
No,
issue as to whether
court will consider the entire circumstance and then pass orders. The petitioner is before this court calling in question an order dated 11th June 2025 rejecting the application filed by the petitioner under Order 14 Rule 5 seeking amendment of seeking additional issues to be issue to be framed. The learned heard the learned senior counsel Jaykumar S. Patil appearing for the petitioner and the learned senior counsel Vikram Hooligold appearing for the petitioner. Response. The petitioner is the defendant, the respondent, the plaintiff. The plaintiff institutes a suit for injunction, is it?
Bare injunction.
For bare injunction. In the said suit, several proceedings sprang. Against an order of injunction being granted, the present petitioner approaches this court in MFA 2033 of 2021 and connected cases, which comes to be disposed by an order of the coordinate bench dated 9th November 2021 by observing as follows, para 36-37. The suit progresses then. During the progression of the suit and about 3.5 years after the framing of the issues, it transpires that the petitioner files an application.
I wanted to put these questions to PW1 in the cross-examination.
During the evidence, it is the case of the petitioner that questions that were sought to be put to ask in the cross-examination to PW1 were not permitted to be put.
On the ground, such an issue is not.
And therefore, on the score that there is no issue of the kind that is framed for the petitioner to put those questions to PW1. It is at that juncture the petitioner prefers an application seeking framing of an issue with regard to maintainability on an application in Order 14 Rule 5. That comes to be rejected. The learned counsel for the petitioner, learned senior counsel for the petitioner now submits that if a direction is issued to the concerned court to permit the petitioner to raise the issue of maintainability without the issue being framed at the stage of arguments, it would evidence in the trial at the appropriate stage, it would suffice. The learned senior counsel for the respondent submits that he can raise the issue that the plaintiff is the dominus litis. The defendant cannot seek additional framing of an additional issue without the petitioner wanting to frame it. Be that as it may, will permit that. Be that as it may, the
cross-examination, you'll have to reopen everything. Let them argue. Let them argue.
The petitioner.
My only concern, I leave it to my lords. My only concern is now is taking a cue from your lordship's observations. Again, they will reopen questions of title and everything. Then the trial court, my lord, should not be misled is what my apprehension is. I understand what your lordship's.
No, correct. But what you say is also right.
Because then, my lord, taking a cue from these
I
observations.
have raised this contention in the written statement. Whether I should be allowed to put those questions, it's very
if they convert into a suit for title, then, my lord, in
I
my
am
suit,
not
they'll hijack
converting
it.
We will observe this. In the light of the submission and contra submission, I deem it appropriate to dispose the petition with the following directions. The impugned order is sustained. The petitioner is at liberty to urge the contentions with regard to maintainability of the suit at the appropriate stage before the concerned court. The concerned court shall oversee that on the plea that the petitioner is wanting to raise the issue with maintainability, the suit does not get metamorphosed into a title suit. With the said observation, reserving such liberty, the petition stands liberty to the petitioner as observed herein above, the petition stands disposed.
specifically.
ಹಂಗಾರೆ ಅದೇ ಮಾಡ್ಬೇಕು ಅಂತಿದ್ದೀರಾ?
ಅಲ್ಲಲ್ಲ ಅದನ್ನ ಮಾಡ್ಬೇಕು ಅಂತಿಲ್ಲ.
Yes.
But if I am not allowed to put that question.
ಹೇಳಿದ್ನಲ್ಲ ಬಿಟ್ಟು I have permitted. Yes.
61.
For the respondents counsel.
My lord, it may be taken up. We've engaged senior counsel.
So he should be here.
Maybe
What is the
taken up-
matter?
Matter relates to, I am the plaintiff in a commercial suit. Lord, there is a second production application. That is the subject matter of the issue. What had happened was that
You have filed an application.
That's quite right.
Yes, sir.
But what had happened was that after the suit was filed, I did enter one application for production that was disallowed. I came to this honorable court. This honorable court favored me, my lord, and I was permitted to place those documents. There's been one important development thereafter, which is that there was an amendment to the plaint.
Amendment to?
To the plaint.
Who permitted the amendment?
The trial court permitted it. And thereafter, the plea relating to, and an additional issue has also been framed, relating to passing off. Originally, the suit was only for infringement. Passing off pleas were there. Therefore, to that extent, when it comes to passing off, I have to establish prior user. The documents ought to be produced are in that light.
This is the problem with the commercial code.
But I bow down.
It treats it as if it is a regular suit.
But I bow down.
And goes on allowing applications, additional issues.
I bow down. It is something that I must bring. But can I
ನೀವೇ
just?
ಕೇಳಿರೋದೆಲ್ಲ.
I'm sorry.
ಅವ್ರು ಕೇಳಿರೋದು. Yes, then we'll hear it. 10th.
Very well, ma'am.
10th or 9th.
No, great.
Heard the learned counsel appearing for the petition. Heard the learned, wait, madam. Heard the learned counsel appearing for the petition of the learned senior counsel, C.K. Nandakumar, representing the respondent. List on 13th.
I'm ready.
List on 13th October. Interim order subsisting would continue to the next date of hearing.
Sorry, my lord. 13th, some difficulty, my lord.
15th?
15th.
Or 15th, yes.
62.
Hearing for the petitioner, my lord. Kindly grant 2 weeks time to file rejoinder.
ಯಾರ್ petitioner respond ನೀವು?
2 weeks time may be granted to file rejoinder.
AVIOC. Yes.
63.
IOC ಇಲ್ಲ, sorry. Intermodal ಅಲ್ಲ? Petitioner seeks 2 weeks time to file a rejoinder statement, list the matter after vacation, rejoinder if any by the next date. Yes.
Summary suit. Well, that's the summons to judgment is served upon me, my lords. I was supposed to file the leave to defend within 10 days.
ಯಾವ ಫಾರ್ಮಲ್ ಇಶ್ಯೂ ಮಾಡೋದು ಸರ್ summons?
Form for an issue agide, my lords. It was issued, my lords, in the right form. I received it in court. My lords, the difficulty is, my lords, I filed 2 applications.
Oh, leave to defend.
Leave to defend.
Leave to defend is rejected now.
My lords, no, my lords. What has happened is there was 6 days delays in filing the leave to defend. I filed condemnation of delay under 37 Rule 7 and leave to defend. The court heard the condemnation application but rejected my leave to defend. Well, that is page 44 if I'm not
Urgent
mistaken.
notice to the respondent. ಯಾರಿದ್ದಾರೆ? ಒಬ್ರೇನಾ?
ಒಬ್ರೇ ಸ್ವಾಮಿ.
Respondent,
sole respondent.
Plaintiff. Petitioner is at liberty to serve on the counsel who represents the plaintiff. The petitioner is the defendant. In a summary suit, after issuance of summons, files an application seeking leave to defend.
And
condonation of delay as it was 6 days beyond the limitation. The concerned court condones the delay.
It doesn't condone.
Does not condone the delay. Obviously, condone delay agla leave to defend ಹೋಗುತ್ತೆ.
Well, the court says I don't have a leave. I don't have a defense at all. While hearing the condonation of delay application, my lords, he says I have not set up a
The
defense.
concerned court rejects the application seeking condonation of delay on the score that the defendant has no defense to put forth before the concerned court. The said finding is on the face of it contrary to law. Therefore, there shall be an interim order of stay of further proceedings before the concerned court. Next.
So I'll serve the counsel for the wait. I'm good.
64.
Writ itself is not maintainable because they have challenged an interim order, not ex parte interim order. They have filed their objections. They have filed their application for vacating stay. We are hearing the matter out.
After that, you have come
After
here.
that, they come here.
No, my lords, my lords, I had filed my statement of objections on 13th of August. My lords, after that, the court has.
Oh, you are in the court.
Please.
I was incidentally,
Please,
my lord.
My lords, the difficulty here is that the interim order was granted on 25th of July. I was able to file my statement of objection on 13th of August. After that, my lords.
ಈಗ vacating stay application pending ಇದೆಯಾ?
They have done, my
Court
lord. I
will
was
consider
giving my
that.
reply.
Yes.
Lords, my only difficulty is this, that for the past 1.5 to almost
Settlement
2
talks
months-
ಇಲ್ವಾ?
No, my lord.
Settlement avataadmele, because my lord, this was not done in good faith, at least not non-friend, but at least what the parties were doing. Because we spoke outside the court, my lord, we said, yes, we'll try. If it's really troubling you to that extent, we'll have certain boundaries where you do not do certain businesses or you do not do certain things or do not touch my clients. That we said, my lord. Now, because they said, though, the picture they projected before court is that they've shut the factory, they can't do anything at all.
Yes.
I said, fine, fair enough. I don't want to hit somebody's stomach and probably try to deprive him of his livelihood. I said, fine, fair enough. Let's see. As long as you say, boss, these are your clients, I'm not going to touch them. I said, I was
What
fine.
should you say, boss?
No, not saying. With them or again.
My lords, my
Sorry.
only submission on this is that even if there were any settlement talks to be conducted, let there actually be conversation between the parties, because what has happened is on the last date of hearing.
No. If application is pending there, court will consider that.
My only difficulty is that.
No difficulty. You have filed an application there and come here, no?
Because it has been beyond 30 days.
I will direct him to consider it.
Please, my lords, and the time frame may be fixed.
2 weeks.
I matter itself, my lords is disposed of a very similar writ petition.
Then a time
Andrella
frame
ಇದೆ.
may be
ಅಂದ್ರೆ
fixed.
ನನ್ನ ಮ್ಯಾಟ್ರೇ ಡಿಸ್ಪೋಸ್ ಮಾಡಿದ್ಮೇಲೆ ಇದೇನು ಅಂತ.
Tom order ಇದೆ. I'm relying on the same thing itself.
The petitioner is before this court seeking the following prayer. This court, owing to the submission of the counsel for the petitioner in order to protect the interest, had granted the order, passed the following order on 16/9/2025. The learned counsel Siddharth Suman, representing the respondent, submits that the petition is not maintainable, petitioner is not entertainable on the score that the petitioner has preferred an application seeking vacation of the interim order as obtaining under Order 39 Rule 4 of the CPC, which is pending adjudication before the concerned court. The learned counsel submits, the petitioner submits that it is filed beyond 30 days. Therefore, the court may not entertain the said application.
My lords, one clarity. The writ petition was filed even within the 30 days. It's just that 30 days has expired.
The learned counsel submits that the subject petition is preferred within the expiry of 30 days of the interim injunction granted, and now it is beyond 30 days and the court may not consider the application under 39(4). In the light of the said submission, I deem it appropriate to direct the concerned court to answer the application under filed under Order 39 Rule 4 by the petitioner seeking vacation of the injunction.
One submission, 39 Rule 4 ಗೆ, my lord, the honorable trial court says I cannot file my objections. That, my lord, for the first time, so that at least may be recorded. That I
By
can
the
file my
respondent.
objections.
ನೀವು ಹಾಕಿರೋದಲ್ವಾ?
ಅವ್ರು ಹಾಕಿರೋದು. So they file an application for vacating stay. The honorable trial court says the vacating stay ಅಲ್ಲಿ ನೀವು objections ಹಾಕಂಗಿಲ್ಲ ಅಂತ. That also,
The learned
File my statement of objections as well because of the urgency involved in
the
the matter.
petition, the parties to the list, the concerned court shall afford such opportunity to both the parties and hear the application so filed by the who has filed it? By the petitioner seeking vacation of the interim injunction that is granted in favor of the respondent, and pass necessary orders in accordance with law within an outer limit of 2 weeks from the date of.
Objections may be recorded, my lord, because I want to file my objections to that also.
2 weeks
I'll permit ಮಾಡಿಲ್ಲ.
2 weeks, within 2 weeks from the date of receipt of the copy of the order.
Before vacation, court vacation, my lords.
Court vacation ಎಲ್ಲಿದೆ?
My lords, from the 27th onwards.
No, I don't know, civil court.
The next date is on 25th.
Yes, my lord.
Next
That's
date
the
will
only
address arguments on 25th.
File your objection by then.
Yes.
Objections
I
record
told
ಮಾಡಿದ್ರೆ,
you,
my lord,
the
because-
learned counsel for the parties would petition, the respondent would submit that the next date before the concerned court is 25th and he should be permitted to file his objections by the said date. The objections, the petitioner respondent is permitted to file his objections to the application seeking vacation of the interim order under interim vacation of the injunction filed under Order 39 Rule 4 of the CPC in the peculiar facts of this case, but before the next date before the concerned court. Yes.
Please, grateful.
With the aforesaid observation, petition stands disposed.
Grateful.
65.
Rera,
Please.
what's the
Yes.
problem?
Blood,
Why is
yeah,
it here?
Blood, by special order it is listed. Blood. Lordship had appeared, it seems.
I had appeared.
No, no. Lordship.
Yes, all right.
Portal number 8. Blood, the petition, Milad, with the joint development agreement of obtaining the Milad license plan.
Again, what is the problem, sir?
Now, they have, Milad, after execution of the sale deed, after taking possession, a complaint is filed saying that we have loaded more than what is permissible in law of the common areas. Milad, kindly come to sale deed, Milad, actually page 81.
That's a question of facts, sir.
Question of fact.
How are you? Appeal, appeal.
Milad, they have appointed.
File an appeal, sir.
Appeal, Milad, there is no sitting of the tribunal. Milad.
Why? It is there.
Only 2 members.
ನಾನು
Just
ಮೊನ್ನೆ
see,
ಹೇಳ್ದೆ ಎಲ್ಲಿ?
Section-
I asked you to get instructions. Where is
Section
it?
73, kindly see section 71(3), Milad.
ಇಲ್ವಾ ಟ್ರೈಬ್ಯುನಲ್?
Milad, I think only 2 members, Milad, there is no this thing. Kindly see, this an application is filed under section 71(3), before the adjudicating authority.
The petitioner is before this court, calling in question an order of the RERA,
Adjudicating officer.
by the adjudicating officer, rather.
How?
Adjudicating officer before the RERA on the score that it is contrary to the facts and law. Ordinarily, an appeal against the said order would be maintainable under 43(8) of the Act. The learned counsel for the petitioner submits that the state government has not appointed a chairman to RERA. This court on plethora of occasions has directed the state government not to frustrate the rights of the parties by not appointing members or chairman to the tribunal. The members pursuant to the direction of this court is said to have been appointed, and the chairman is yet to be appointed despite passage of 2 years, close to 2 years after the retirement of the incumbent chairman, which has undoubtedly frustrated the proceedings before the concerned court. The said action would not behove the status of the state to do so. In the light of that, this court is constrained to entertain the petition and grant an interim order of stay of the order as prayed for till the next date of hearing. Gautam Dev Ullal is directed to accept notice for the respondent RERA. The state government shall secure instructions with regard to the appointment of the chairman to RERA and place it before the court on the next date. List the matter on 24th.
Please.
Yes.
May I request for hand delivery tomorrow?
Yes,
is
sir.
the matter.
Why?
Before the adjudicating officer is
Ivatidya.
tomorrow.
ಅಷ್ಟೊಂದು ಅಪ್ಲೋಡ್ ಆಗುತ್ತೆ.
Please.
66.
For the petition, my lord. My lord, the issuance of TDR is very much pending before this honorable. TDR issuance.
ರಿಜೆಕ್ಟ್ ಮಾಡ್ಬಿಟ್ರಾ?
Petition is very much pending. In meantime, respondent prepared execution petition in which the land ACM has granted direction allowing IN number 2 to execute the sale deed.
You are a judge. You are a judgment debtor, sir. We'll
Yeah,
see.
I am, both are, there is
The
no.
petitioner to serve on the councils representing the decree holders before the concerned court and file an acknowledgement of such service. List the matter on 26th.
Meantime, interim.
No, sir.
Otherwise, sale deed will be
No,
executed.
sale ಯಾವತ್ತಿದೆ?
Sale ಅವರು already issued, lordship.
Correct. ನೀವು judgment debtor ಏನ್ ಮಾಡಕ್ಕಾಗತ್ತೆ?
But only thing is, my submission, my lord, still next date of hearing.
No, sir.
Otherwise, the execution will be sale deed.
No, yes. Next.
Date may be fixed, at least.
See, 26th. Yes.
26th, 10th.
26th of September, next week.
Much of it.
Yes, sir.
67. My lord,
Tax.
the impugned assessment order has been passed against the petitioner, my lord, as a legal representative of her late husband.
Dilip.
Take notice.
Learned counsel M. Dilip is directed to accept notice for the respondent. Petitioner to serve set of papers upon the aforesaid counsel. Ex parte.
My lord, I had received notices, my lord.
ಆಮೇಲೆ participate ಮಾಡಿಲ್ಲ.
ಆಮೇಲೆ ನಾನು participate ಮಾಡಲಿಲ್ಲ. I have given a reply, although.
Why did you not participate?
But she had 2 young minor children, my lord, and pursuant to that, she is faced with various liabilities. An income tax notice will not be the first thing she would deal with. My lord, when they want to tax me in a representative capacity, they should have first established as to what are the estate which has devolved upon me.
Let him file his objections.
If they want to participate, the lordship can.
We'll send it back. You participate in the proceedings now.
My lord, I have already stated that I have not inherited any estate of my late.
I'll ಹೇಳಿ madam.
ಇಲ್ಲ, I'll ಹೇಳಿದ್ರು it cannot be accepted ಅಂತ ಹೇಳ್ತಾರೆ. Penalty proceedings are also.
You have not inherited any estate?
I have not inherited any estate. The definition of a legal representative under the IT Act, my lord, is one who represents the estate. I have to first establish that I have represented.
File your objections. Learned counsel M. Dilip seeks 3 weeks time to file 4 weeks time to file statement of objections. Till the filing of the statement of objections, no precipitative action shall be taken against the petitioner on the strength of the orders impugned.
Annexure A and B.
On the strength of the orders impugned.
My lord, and there are 6 assessment years, my lord. There are 5 other connected petitions, all similar orders. For a 6-year block assessment period, they have passed these orders. 5 petitions.
Move ಮಾಡಿ, we'll take it on 25th.
If they can be connected, 25th.
You move it on 24th or 22nd. We'll take it.
68.
Petitions, my lord. Matter pertains to general award, quashing of general award.
Quashing of general award.
Yes, my lord. It is
General
annexure
Pradeep
D.
Kumar, yes. Next.
And one request, my lord. The
Pradeep
compensation
Kumar,
of.
ಏನು?
It can be.
ಏನು ಹೇಳಿ?
Compensation amount, that package amount was not sent to the KDB, my lord. Direction may be issued to the respondent number 4, BMRCL to disburse the compensation.
In the light of the quashment of the general award, all consequential action shall be taken by the respondents. Yes, ಸಾಕು.
BMRCL.
Yes, next.
Lord, BMRCL, Mr. N. Harish Malad appears for BMRCL.
ಇದರ ಇಲ್ಲಿ your party here?
Please,
Yes, Malad, he is both respondent. Both
It is respondent number 4, my lord. BMRCL is respondent number 4.
Consequential action of deposit of compensation. ಅಲ್ಲಿ ಏನದು?
Disburse the compensation.
Disperse the compensation.
By fourth
consequential action of disbursement of compensation shall happen by the respondents. Yes.
Respondent number 4.
ಯಾರಾದರೂ ಪರವಾಗಿಲ್ಲ. Yes, next.
Please.
69.
It's of mandamus, my lord, to consider the representation.
Yes, Pradeep, consider.
Yes, Malad. Accordance.
Dispose ಮಾಡೋಣ?
ಮಾಡ್ಬೋದು.
The petitioner is before this court. Notice ಆಗಿದೆಯಲ್ಲ? Is before this court seeking the following prayer.
Annexure G and H, my lord.
The land of the petitioner, which is said to have been granted in terms of the averment of the petition, becomes subject matter of acquisition at the hands of the board. The petitioners, after the final notification, have submitted representations to the respondent authorities to disperse compensation of the compensation amount to the acquired land. The representation having gone unheeded is the reason for the petitioner at the doors of this court. The learned counsel appearing for the respondent, H.L. Pradeep Kumar, submits that if reasonable time is granted, the representation of the petitioner would merit consideration and appropriate orders would be passed in accordance with law. In the light of the said submission, I deem it appropriate to dispose the petition with the direction to the respondent to consider the representation of the petitioner and pass necessary orders in accordance with law within 8 weeks from the date of receipt of the copy of the order, if not earlier. Please.
Serial number 68, notice order.
68 notice ಆಗಿಲ್ವಾ?
ಇಲ್ಲ sir.
H.L. Pradeep Kumar is 68 ಅಲ್ಲಿ ಬರ್ಕೊಂಬಿಡಿ. Pradeep Kumar is directed to accept notice for the respondent board. ಅದ ಜನರಲ್ ಅವಾರ್ಡ್ ಮೇಡಮ್ ತೋರಿಸ್ಬೇಕು. Yes, next. ನೆನ್ನೆ ಮ್ಯಾಟರ್ ಕೊಡಿ.
Similar.
Same order. Yes, next.
ಅದು ಆರ್ಡರ್ ಆ ಕೇಸಲ್ಲಿ ಆರ್ಡರ್ ತಗೊಂಬನ್ನಿ ಅಂತ JCB BDA ಪೀಪಲ್ ಅಲ್ಲೇ ಇದ್ದಾರೆ ಸ್ವಾಮಿ. ಆರ್ಡರ್ ಅಪ್ಲೋಡೆಡ್ ಆರ್ಡರ್.
JCB ಪೀಪಲ್ ಅಲ್ಲೇ ಇದ್ದಾರಾ?
JCB BDA ಪೀಪಲ್
ಅಲ್ಲೇ ಇರಕ್ಕೆ ಹೇಳಿ. Yes.
That's asking uploaded order.
ಆಗಿದೆ ನೆನ್ನೆ ಆಗಿದೆ. ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ ಆಗಿದೆ. BDA ಗೊತ್ತು. ಅದರಲ್ಲಿ ಯಾರಿಗೆ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ? ಅವ್ರಿಗೆ ನೋಟ್.
Admission 71.
71, Lord. Charge sheet has been filed for 504, 506, 341.
504, 506.
But in fact, not the FIR was registered for not the other offense 323, 354.
Charge sheet only 504, 506 will close it. The served ಅಲ್ಲ complainant.
ಇವರು ಅವ್ರ ಮೇಲೆ ಒಂದು ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅದೇನಾಯ್ತು?
ಅಲ್ಲ ಆ ಕಂಪ್ಲೇಂಟ್ ಇವ್ರ ಮೇಲಲ್ಲ, ಬೇರೆಯವ್ರ ಮೇಲೆ. ಅದೇನಾಗಿದೆ, ನನ್ನ ಲ್ಯಾಂಡ್ ಅಲ್ಲಿ ಅವ್ರು ಇಂಟರ್ಫಿಯರ್ ಆದ್ರು ಅಂದ್ಬಿಟ್ಟು ನಾನು.
Petitioner is the accused, the first respondent complainant who is served and remains unrepresented. The petitioner, it transpires that between the petitioner and the respondent, certain civil suit in OS 496 of 2023 is pending consideration, and a prior ನಿಮ್ಮ ಪರವಾಗಿದೆ injunction, and the petitioners have the benefit of an order of injunction as in terms of the order dated 27/11/2023. After the grant of injunction, it transpires that the respondent complainant institutes a complaint in crime number 1, registers a complaint in crime number 1 of 2024 for offences punishable under section 427, 341, 506, 323, 504 and 34 of the IPC against making several allegations against the petitioner. The respondent police, after investigation, file a charge sheet against the petitioner, not for the aforesaid offences, but the offences under 504 and 506 of the IPC, dropping every one of the other offences. Therefore, huh?
341.
341 idea and 341, 504 and 506 of the IPC. The learned, it is this that has driven the petitioner to this court and the subject petition. The learned counsel appearing for the petitioner would vehemently contend that there is no ingredient of the offence under section 341 or 501 or 506 of the IPC. It is to wreak vengeance against the petitioner for having secured an order of injunction against the respondent. The criminal law is set into motion, and therefore would submit that in the absence of any ingredient, the further proceedings must not be permitted to be continued. As observed here and above, the complainant, though served, remains unrepresented. The learned additional SPP would refute the submission of the learned counsel for the petitioner in contending that the charge sheet has been filed by the police after investigation. It is for the petitioners to come out clean in a full-blown trial, and this court, in exercise of its jurisdiction under 48 of the CRPC, should not interfere with the findings in the charge sheet and leave it open to the petitioner to avail of such remedy as available in law. I have given my anxious consideration to the submissions made by the respective learned counsel and have perused the material on record. The afore narrated facts are not in dispute. A suit between the parties being subsisting is a matter of record. On 27/11/2023, the concerned court grants an order of injunction in favor of the petitioner, which does not go well with the complainant and seeks to register a complaint for plethora of offences initially. The police register a crime in crime number, 7 of 2024. 7 of 2024 for the said offences. The police conduct investigation, and the product of investigation as found in column number 17
Page
is
28. Page 28.
yes, column number 17 is as follows. A perusal would indicate that the offences initially alleged were all bald and did not have any substance in it. What remains is the offence under section 341, 504 and 506 of the IPC. For an offence punishable under section 341, the ingredients as found in section 399 is required, 339 is required to be present. In the light of none of the ingredients as obtaining under section 339 being present in the case at hand, offence under section 341 cannot be laid, as it is not the case of the complainant that the accused was stopped from all force to section 341 deals with wrongful restraint. Wrongful restraint, as observed here and above, is defined in section 339. If the petitioner has not been able to move around in any way or on a restraint by the accused, it would then become an offence under section 341 of the IPC. The apex court in the case of KV Dhananjay versus State of Karnataka has held as follows. The apex court holds that the offence under section 341 cannot be 353 ಇರಬೇಕದು ಒಂದು ನಿಮಿಷ 353 ಬೇರೆ ಕೊಡ್ತಾರೆ. So in that light, the offence under section 341 is loosely laid against the petitioner. What remains are the offences under section 504 and 506 of the IPC. For an offence under section 504 and 506 of the IPC, the ingredients are found in section 503, which reads as follows. In terms of section 503 and 506 of the IPC, what is the offence of criminal intimidation cannot spring from thin air. The ingredients of offences, what should be the ingredients of offences under section 504 and 506 of the IPC is considered by the apex court in the case of Muhammad Wajid versus State of Bihar, State of UP in a judgment reported in 2023 SCC Online SC page 951, where the apex court has held as follows, quote para 24 to 26. In the light of the judgment of the apex court as to what 24 to 33, as to what is necessary for an offence under section 504 and 506 of the IPC, if the finding of the charge sheet is noticed, it would run foul of what the apex court has held. In the light of none of the offences meeting their basic ingredients, and the entire issue springing in from a civil suit pending between the parties, and the complaint being registered to as a counterblast to the pending civil suit, the permitting further proceedings against the petitioner would become an abuse of the process of the law and result in miscarriage of justice. For the aforesaid reasons, so on. Allowed quashed. Next.
72.
My lord, I appear for the petitioner, my lord.
For the respondent number 2, my lordship.
But so far as I am the husband, my lord, I have been saddled with a number of allegations, my lord. They file a DV Act. She files a petition for restitution of conjugal rights. She goes to an extent of.
What to do, sir? As you sow, so you reap.
My lordship.
My lord,
Yes.
that may be true, my lord, but I did not sow
That is
anything.
in trial. Yes.
I have been virtually sandwiched for no reason whatsoever. And
What
they
kind
only want money. She goes to Netherlands. She is not here in India. She has her own. She does. I hardly stayed for 3-4 months with her.
Oh,
Swami. Swami.
Swami.
Page number.
My lord.
My submission is to this section, my lordship.
2-3 section.
To this extent that.
Yes.
Extent that. Swami, only face of the charge sheet is filed. The
Face
of charge sheet. Swami, page number 29.
Charge sheet is faceless now.
ಅಷ್ಟೇ ಇಂಡೆಕ್ಸು ಹಾಕಿಲ್ಲ ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಏನು ಹಾಕಿಲ್ಲ ಸ್ವಾಮಿ ಯಾವ ಡಾಕ್ಯುಮೆಂಟು ಹಾಕಿಲ್ಲ ಅಂಡ್ ದೇ ಆರ್ ದ ಬೀಟನ್ ಐ ಹ್ಯಾವ್ ಪ್ರೊಡ್ಯೂಸ್ ದ ಮೆಡಿಕಲ್ ರೆಕಾರ್ಡ್ ಮೇಲೆ
Beater.
ಹೌದು ಬೀಟನ್
It is the other way around, my lord. They have registered
Oh,
a
it was beaten you.
producing the charge sheet, my lordship.
Oh,
No, I'm
yes.
producing the charge sheet, my lordship. They are not producing any document. Charge sheet.
ನೀವೇ ಕೊಡಿದ್ರಿ.
ಅಲ್ಲ ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಏನು ಇಲ್ಲ ಸರ್ ಅವ್ರು ಹೊಡೆದಿದ್ದು ಸ್ವಾಮಿ ಅವ್ರು ಹೊಡೆದಿರೋದಕ್ಕೆ ನಾವು ಮೆಡಿಕಲ್ ರೆಕಾರ್ಡ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ವಿ ಸ್ವಾಮಿ ಇನ್ ಚಾರ್ಜ್ ಶೀಟ್ ಐ ಹ್ಯಾವ್ ಇಟ್ ಇಸ್ ದೇರ್ ಮೈ ಲಾರ್ಡ್ಶಿಪ್ ಬಟ್ ಇಟ್ ಇಸ್ ನಾಟ್ ಇನ್ ದ ಪಿಟಿಷನ್ ಪೇಜ್ ನಂಬರ್
ಕೊಡಿ
they are called for mediation, my lordship. On mediation day 31/8/2024 after in mediation also the divorce ಕೊಡು ಇಲ್ಲ 10 ಲಕ್ಷ ರೂಪಾಯಿ ಕ್ಯಾಶ್ ರಾಯಲ್ ಎನ್ಫೀಲ್ಡ್ ಒಂದು ಬೈಕು ಕುಮಾರಸ್ವಾಮಿ ಲೇಔಟ್ ಅಲ್ಲಿ ಒಂದು ಸೈಟ್ ಕೊಡೋದಾದ್ರೆ ಮನೆಗೆ ಬಾ ಇಲ್ಲ ಅಂದ್ರೆ ಹೊರಗೆ ಬಂದ ತಕ್ಷಣನೇ ಅವರು ಮತ್ತೆ ಅವ್ರ ಫ್ರೆಂಡ್ ಹೊಡೆದಿರೋದು ನಮಗೆ
My lord, ನಾನು ನನ್ನ ಹೈಟಿಗೆ ರಾಯಲ್ ಎನ್ಫೀಲ್ಡ್ ಬೇಡ ಸ್ವಾಮಿ ನನಗೆ ಏನು ಬೇಡ I have never, they are all cock and bull stories they have created. On one side they want restitution of conjugal rights. She files a petition, my lord, that I should not get married again, which is against the law. Where is it? My lord.
So you want to get married again? Huh?
No, it is her allegation. Character assassination, my lord.
Character assassination?
Yes, for no reason, attributing some other lady. And moreover, my lord, with great respect, I may say so, she barges into the house along with her father, mother, and everybody, beat me up, throw me out virtually from the house.
ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ
ಏನು ಹೇಳ್ತಾರೆ?
No, my lord, my lord, your
agony of the husband also you should listen. Wait. Yes, sir.
I can only say this much, my lord, that she files a DV Act, she seeks a global maintenance. She is granted maintenance of 20,000, which I am regularly paying, number one. Number two, my lord, she files a petition for his 498A virtually after 1.5-2 years period. Virtually after that period. And she makes, in her complaint, if your lordship may kindly, she makes as many as 8 to 10.
Do, sir? If you drive the woman to the wall, this is what will happen.
I have not driven her, my lord. It is true that I can't live with her. That is no doubt true. I have filed a counterclaim of divorce. She files a restitution. Yes. My lord, I filed a divorce petition in Mysore. She files a petition for restitution. I withdraw that petition and then under 24A, I file a counter prayer that I require divorce. Looking at that, she initiates DV Act. Looking at that again, she initiates 498A. Looking at that, she initiates another suit that I should not get married again.
Looking at this, I will pass the order now.
Yes, sir.
Yes.
No say in that.
Yes, sir.
Some wound certificate I have.
You don't look at him. ಹೇಳಿ order ಮಾಡಿ. ಹೇಳಿ ಸರ್ ನಿಮ್ದೇನ್ ಕೇಸು?
ಸ್ವಾಮಿ wound certificate I have produced,
Page.
my lordship. Page 51, my lordship. In my produce the memo, page number 51. Wound certificate.
Page 51 an order.
51.
That is the case I withdrew, my lord, withdrew. Then on the-
don't worry, yes.
Your lordship.
What I have produced now, my lordship.
ಈಗ ಹಾಕಿದ್ದ.
ಈಗ ಹಾಕಿದ್ರಲ್ಲಿ 51.
ಏನಿದೆ ಇಲ್ಲಿ? ಏನಿದೆ ಇದರಲ್ಲಿ?
ಸ್ವಾಮಿ ಅದರಲ್ಲಿ ಅವರು ಹೊಡೆದಿರೋದು ಮೆಡಿಕಲ್ ರೆಕಾರ್ಡ್ ಸ್ವಾಮಿ. ಆಮೇಲೆ ಅಂತ ಪೇಜ್ ನಂಬರ್ 30 ನಾನು 49 ನಲ್ಲಿ
Injured person was first seen so and so.
31/8/2023 ಮೀಡಿಯೇಷನ್ ಇತ್ತು. ಆ ಮೀಡಿಯೇಷನ್ ನಾನು ಹೇಳಿದ್ನಲ್ಲ ಸ್ವಾಮಿ, ಆ ಮೀಡಿಯೇಷನ್ ಅಲ್ಲೂ ಸದಾ ನಮಗೆ
ಎನಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಟು ದಟ್ ಎಫೆಕ್ಟ್?
ಪೇಜ್ ನಂಬರ್ 30 ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಅವತ್ತು ಮೀಡಿಯೇಷನ್ ಇತ್ತು ಸ್ವಾಮಿ. ರಿಸೈಡಿಂಗ್ ಇನ್ so and so. Counseling session was scheduled on 31/8/2020.
Page 13.
30. 30.
ಏನಿದೆ ಇಲ್ಲಿ?
ಸ್ವಾಮಿ ಆ ದಿನ ಮೀಡಿಯೇಷನ್ ಇತ್ತು. ಆ ಮೀಡಿಯೇಷನ್ ಮುಗಿದ ತಕ್ಷಣ ಇಮಿಡಿಯೇಟ್ ಆಗಿ ನಮಗೆ ಅವರು ಹೊಡೆದಿರೋದಕ್ಕೆ ನಾವು ಹೊಡೆಸ್ಕೊಂಡು.
ಅಲ್ಲ ಏನ್ ಮಾಡಿದ್ರಿ ಆಮೇಲೆ?
ಆಮೇಲೆ ನಾವು ಹಾಸ್ಪಿಟಲ್ ಹೋದ್ವಿ, ಕೆ ಜನರಲ್ ಹಾಸ್ಪಿಟಲ್.
4/9/2023. What is the date?
ಆಮೇಲೆ 4/9/2023 ಇದು ಡೇಟ್ 31/8/2023 ಮೀಡಿಯೇಷನ್ ಕೌನ್ಸಿಲ್ ಇದು, ಕೌನ್ಸಿಲಿಂಗ್ ಡೇ.
Wound certificate 11/9/23.
ಅಲ್ಲ ಸಬ್ಸಿಕ್ವೆಂಟ್ ಒಂದು 10 days ಅಷ್ಟೇ.
Have been caused on 345 at 31/8 alleged assault by her husband near Basangudi police station.
ಮೀಡಿಯೇಷನ್ ಹೇಳ್ತಾರೆ, ಬಸವನಗುಡಿ ಪೊಲೀಸ್ ನಾನು ಕೊಟ್ಟಿರೋ ಕಂಪ್ಲೇಂಟ್.
ಸುಮ್ಮನೆ ಇರಿ ಸರ್ ಸ್ವಲ್ಪ. ಎಸ್.
ಆಮೇಲೆ ಇನ್ನೊಂದು ಅವ್ರು ಹೇಳಿದ್ರು ಸ್ವಾಮಿ ಟ್ರೆಸ್ ಪಾಸ್ ಕೇಸು ಅಂತ. ಸ್ವಾಮಿ
ನೀವು ಟ್ರೆಸ್ ಪಾಸ್ ಅಲ್ಲ ಬಿಡಿ.
ಅಲ್ಲ ಇವರು
ವೋಂಡ್ ಸರ್ಟಿಫಿಕೇಟ್ ಅಲ್ಲಿ ಏನಿದೆ?
But
that is first of all 31/8 ಆಗಿರೋದು ಅಂತೀರಾ? The examination certificate is issued on 11/9. It can be issued. I'm not saying so. But where is the entry in the registry on that day? 31/8 ಯಾವತ್ತು ತೋರಿಸಿದ್ರಿ?
ನಾವು
examined because examined on 31/8 ಅಂತ ಇದೆ.
ಪ್ರೈವೇಟ್ ಕ್ಲಿನಿಕ್ ಗೆ ಹೋದ್ವಿ ಸ್ವಾಮಿ.
Examined on 11.
Examined on 11. First seen at casualty on 11/9. 10 days ಆದ್ಮೇಲೆ 10 days ಆದ್ಮೇಲೆ ಟೆಂಡರ್ನೆಸ್ ಎಲ್ಲಿರುತ್ತೆ?
ಅಲ್ಲ ಫಸ್ಟ್ ನಾವು ಪ್ರೈವೇಟ್ ಹಾಸ್ಪಿಟಲ್ ತೋರಿಸಿದ್ವಿ.
ಅದೆಲ್ಲಿದೆ
ಸ್ವಾಮಿ? ಅದನ್ನ ನಾವು ಕೊಟ್ಟಿದ್ದಾಗ ಅವ್ರು ತಗೊಳ್ಳಿಲ್ಲ. ಆಮೇಲೆ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಇದೆ. ಇಟ್ ಇಸ್ ಮೆನ್ಷನ್ಡ್ ಇನ್ ಮೈ ಕಂಪ್ಲೇಂಟ್. ನಾನು ಯಾಕೆ ತಕ್ಷಣ ಕೇಸಿನ ಹಾಸ್ಪಿಟಲ್ ಹೋಗ್ಲಿಲ್ಲ ಅಂತ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಇದೆ. ಅಲ್ಲಿ ಅವಾಗ್ಲೇ ಬರ್ದಿದ್ದಾರೆ.
ಸೆಟಲ್ ಮಾಡ್ಕೊಂತೀರಾ
ಸ್ವಾಮಿ? ಅವ್ರು ಇವಾಗ್ಲೂ ನಮ್ಮ ಮನೆ ಕರ್ಕೊಂಡು ಹೋಗ್ತೀನಿ ಅಂದ್ರೆ ಹೋಗಕ್ ರೆಡಿ ಇದೀವಿ ಸ್ವಾಮಿ. ಅವರು ಯಾವುದೇ ಕಾರಣಕ್ಕೂ ಒಪ್ತಾ ಇಲ್ಲ ಸ್ವಾಮಿ. ಮಗು ಇದೆ, ಮಗು ಹೆಸರು ಸದಾ ಅವ್ರಿಗೆ ಗೊತ್ತಿಲ್ಲ. ಅವ್ರು ಇಷ್ಟೊಂದೆಲ್ಲ ಮಾತಾಡ್ತಾರೆ. ಒಂದೇ ಮಗು ಹೆಸರು ಅಸರ್ಷನ್ ಲಯಬಿಲಿಟೀಸ್ ಅಲ್ಲಿ ಮಗು ಹೆಸರು ನಾಟ್ ನೋನ್.
Yes, petition.
This is the situation I am facing.
My lord, so far as the child is concerned, I am willing to take care. But child is my family, my lord. I have to take care, come what may. There is no compromise. My lord, if she is keeping the child for a limited period because she is the mother, my lord, let she put in an educational institution, residential at a later stage. I don't mind taking care all the expenses. But the question is to make me live with my wife.
We'll take it on 31st. Yes.
Please.
Petitions ಹಾಕಿದೀರಾ?
ಇಲ್ಲ.
ಸ್ಟೇ ಕೊಟ್ಟಿದ್ದೀವಿ ಇಲ್ಲಲ್ಲ?
ಇಲ್ಲ.
Lest the matter heard the learned counsel appearing for the petition and the respondent. The respondent shall file the statement of objections, if any, by the next date. List the matter on 31st.
My lord, the document which my friend has submitted, let him serve a copy of me, my lord.
Next.
73.
Appearing for petitioner in this matter, my lord. I'm the complainant, my lordship.
You are the complainant.
Please, my lordship.
Why are you here?
Filed application for release of the amount, my lord.
Which amount, sir?
Senior citizen, my lordship.
First, which amount ಹೇಳಿ sir, ಆಮೇಲೆ senior citizen.
My amount has been cheated by my nephew, my lordship. The same amount has been seized by the police, my lordship. Freeze. So that amount I'm seeking, 52 lakhs he has cheated me.
Cheated amount ಬರೋದು ಟ್ರಯಲ್ ಆದ್ಮೇಲೆ, ಮಧ್ಯದಲ್ಲಿ ಎಲ್ಲೂ ಇಲ್ಲ.
my lord.
Correct ಆಗಿ
Because,
dismiss ಮಾಡಿದ್ದಾರೆ.
my lord, she is very old lady, my lord. She is
ಯಾರಿಗೆ
senior
ಗೊತ್ತು? It
senior
should be proved,
citizen.
sir. No, no.
My lord, I will prove, my lord.
So
any
you have
condition-
registered crime for the purpose of recovery of money?
No, my lordship.
ಮತ್ತೆ ಇನ್ನೇನಕ್ಕೆ?
Subsequently, my lord, kindly see, my lord, he is my nephew, my lordship.
She wanted to be taken care of by accused people. What accused
Who
does
is
is,
that? What is the offense for?
420 and
what accused
Who
does
are
is-
you? Accused jothe ನಿಮ್ದೇನ್ relation?
a nephew, my lord. He is my sister's son, my lordship. My mother, my husband died, my lordship. I was alone staying in Hindupura, my lordship.
ಆಯ್ತು,
They
we'll-
called me. They
we'll get them, wait.
please.
they've
It is already served, my lordship.
Served, ah?
Served, my lordship.
ನಿಮಗೆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಹೇಳಿದ್ದೆ ನಾನು.
Maybe entitlement. I think they've taken money. Money has
How
been
much
transferred.
money?
Only now
52
it's left.
lakhs taken, my lordship. Now what the police have freezed is 14 lakh change, my lordship. That is the
ಅದು ಡಿಫ್ರೀಸ್ ಮಾಡಿ ಕೊಟ್ಬಿಡಿ ಅವ್ರಿಗೆ, ಅವಾಗ ಗೊತ್ತಾಗುತ್ತೆ, ಬರ್ತಾರೆ. The petitioner is before this court calling in question an order of the concerned court which rejects an application filed by the petitioner under section 451 and 457 of the CRPC, seeking release of the amount that is involved in the subject matter of the proceedings. The petitioner is a 75-year-old lady, is allegedly cheated by the second respondents by the accused. The petitioner was wanting to be taken care of by the accused. Towards the said promise, the said amount is said to have been paid by the petitioner. Now the petitioner is left in the lurch with no amount being
They've taken money saying that they will buy a property and then all of them can live together.
taken care of. The learned, the petitioner is now left in the lurch as there is neither money nor a shelter to stay, shelter to reside in. The learned additional SPP submits that the money was taken by the accused on the promise that they would secure a house to the lady, to the petitioner, and house the petitioner in the said residential place. Since the cheating was writ large, charge sheet is also filed by the police, and have recovered an amount of rupees 14 lakhs that is now lying in the account of
Accused.
different people, my lordship.
different people.
ಹೌದು it has been subsequently transfer ಆಗಿದೆ sir.
Lying in the bank, PF ಮಾಡಿಲ್ವಾ ಅದನ್ನ?
ಆಗಿದೆ.
They reported to court.
Lying in the bank, and a PF to that effect is already registered by the investigating officer. In the peculiar facts of this case, since the respondents are served and unrepresented, I deem it appropriate to direct the investigating officer to get the account defreezed if it is frozen, and hand over the amount of 14 lakhs to the petitioner. That is in the
Per amount is exist in the account.
the amounts that are existing in the accounts to the petitioner without brooking any further delay. List on 31st.
Please.
Next.
74.
For petitioner in this case, my lord. So 376, my lord, consensual sex, my lord.
376.
The petition, 376 consensual sex between the complainant and the petitioner, my lord.
76.
The petition,
76, 74 man.
74. Manjunath.
74. Please, my lord. Consensual sex between the
ಅಯ್ಯೋ,
complainant and the
ಅದು
petitioner.
ಕೇಳಿ
my lord.
ಕೇಳಿ ಆಯ್ತು, ಎಷ್ಟು ವರ್ಷ?
My lord, the petitioner is the teacher, my lord, in the school
Speaker,
where the complaint. Teacher,
School teacher.
school teacher, my lord, where the complainant.
And what is the complainant?
Complainant is the guest teacher in the school where the petitioner was working. my lord. So he used to come to
where,
the
sir?
guest teachers.
ಶಾಲೆ ಮುಗಿದ
was-
ನಂತರ.
She was the guest teacher, my lord. My
You
lord,
are a regular teacher,
I am regular teacher. She was the guest teacher, my lord. On 16/9/2023, lord. So when in the complaint allegation is that, my lord, on 16/9/2023, so when the complaint was the teaching the classes, at that time the petitioner went and so praised her work by saying you are so teaching well and you are necessary to the school and you have to become, and he took her inside the school after the finishing of the school at that day inside the school, and he committed the rape. and the petitioner and the complaint traveled together so many places, my lord. It is herself, she has stated, narrated in the complaint herself. My lord, so
Page
on
39.
9/10/2023, the petitioner and the complainant went to the Malayana Betta village at 11 p.m. As per her own
Huh?
statement, the petitioner and the complaint traveled together so many places.
ಏನೋ
On
ಬೆಟ್ಟ
9/10/20,
ಅಂದ್ರಲ್ಲ ಈಗ.
so they went together Malayana Betta to visit and see the places there. And they met the CW 3 and 4. And
Yes,
after
page
some
20
days,
ಏನು?
It's 23 ನಲ್ಲಿ.
and after some days,
Wait,
they
sir.
went to
ಕರ್ನಾಟಕ ದರ್ಶನ್ ಮಾಡಿಸ್ಬಿಡಿ ಈಗ. Wait. Yes.
It's 23 last 4 lines. Got it. Before that, he's taken photographs and then.
ಟ್ವೆಂಟಿ ಅಲ್ಲ.
ಹೌದು, ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಸೆಕೆಂಡ್ ಪೇಜ್ ಆಫ್
ಟೈಪ್ಡ್ ಕಾಪಿ.
ಹೌದು. ಅದಕ್ಕೆ ಮೇಲ್ಗಡೆ
ದೇವರ ದರ್ಶನ ಪಡೆದು ವಾಪಸ್ ಬರುವಾಗ ಬೈಕ್ ಅಲ್ಲ.
ಅದಕ್ಕೆ ಮೇಲ್ಗಡೆ ಫೋಟೋ ಗಿಟೋ ಎಲ್ಲ ಇಟ್ಕೊಂಡಿದ್ದಾನೆ.
So far as the photos are concerned, in the charge sheet, they have not recovered any photos. That is the only allegation in the complaint.
Yes. The petitioner is the accused. ಬರೀ ನೀವೇನಾ ನಿಮ್ ತಂದೆ ತಾಯಿ ಎಲ್ಲ ಬಂದಿದ್ದಾರಾ?
No, only.
Yes. The petitioner is the accused. The second respondent, complainant. The complainant and the petitioner were teachers in the same school, one regular, the other guest. It transpires that the friendship grew between the petitioner and the complainant, and the said friendship blossomed into consensual relationship. The complaint narrates several escapades between the petitioner and the complainant all over the state. Later, a complaint comes to be registered in crime number 32 of 2024, alleging that the complainant has been cheated by the petitioner and has had sexual relationship with her on the score of promise of marriage. And therefore, the offense of rape has sprung.
Not promise.
Promise alva?
Promise of
And
getting
therefore,
job. Promise of getting job.
on the promise of getting a job, marriage bada, promise of getting a job. A perusal at the complaint would indicate not once but several bouts of instances between the petitioner and the respondent complainant, all of which prima facie indicate those acts being consensual, as the acts are, as the instance is not solitary, but there are several instances. In that light, the permitting further proceedings against the petitioner accused would prima facie run foul of the judgment of the apex court in the case of Dhruvaram Mudaliar Sonar. So it's 2018-19 SCC page 191, as is followed by the apex court in the case of Lalu Yadav versus State of Bihar, reported in 2024 SCC online SC page 2876. There shall be an interim order of stay of further proceedings till the next date of hearing. List the matter on 31st. One additional SPP 2M. Agidya? Sarvagidya? 31st. Yes.
75.
Petitioners are former employees, madam. They have been resigned and resignation by accepted. After a lapse of 7 months, this present complaint can be filed.
And data theft? Data theft?
It is not a question. It is not the case of the data theft. They post the employees.
NDA violation? NDA violation?
No, non-disclosure. Yes, that is the
non-disclosure agreement. NDA and rather. Yes.
Yes, that is the allegation, my lord. Our lordship, can we see they also filed a civil suit.
Petitioners are accused in CC
number
in CC 33429 of 2023 for offences punishable under 408, 420, 380, 66C of the IT Act, first IPC, ML IT Act. The learned counsel for the petitioner takes this court through the documents appended to the petition to demonstrate that the petitioners were employees of the complainant company. They come out after about 8 months after the exit of the petitioners on resignation. The complaint comes to be registered for violation of non-disclosure agreement. You have started a separate company.
Illa.
So prima facie, the offence so alleged is only to arm twist the petitioners. Therefore, till the appearance of the respondent, there shall be an interim order of stay of further proceedings, qua the petitioners till emergent notice to the second respondent complainant returnable by 31st October. List on 31st October. Additional SPP is directed to accept notice for the respondent. First respondent state.
76.
I appear for the petitioner, my lord.
Promise of marriage.
No, my lord, but 2B reports.
Oh, 2B reports. Press time, no grants time. Yes. Why time? ವಕಾಲತ್ ಹಾಕಿದ್ದೀರಾ? ಯಾವತ್ತು ಹಾಕಿದ್ರಿ? ಅದೇ ನಾ ಕಡೆ ಈ ಕಡೆ ನೋಡ್ತಾ ಇದ್ರಿ, ಯಾವತ್ತು ಹಾಕಿದ್ರಿ? Tuesday. We'll take enter ಮಾಡಿದ್ಯಾ?
Yes, my lord.
List the matter on 31st October. Objections, if any, by the second respondent. Interim order subsisting would continue till the next date of hearing.
Much obliged.
Yes, next.
77.
I'm appear for the petitioner in this case, my lords.
Lords, appearing for respondent Lokayukta.
7A na?
7A.
7A and 12 of PC Act, my lords.
My lord, seeking
Maybe
time
partly.
to file a statement of objection.
Okay. Stay idea?
Please, my lords, there is a stay.
Same 31st.
Interim order may be continued.
Continue, yes.
Obliged.
78.
My lords, I'm for the appellant, my lords.
Appearing for the respondent number 14, my lords.
My lords, I'm seeking
sir.
for an adjournment, my lords. Some
Why,
personal
sir?
inconvenience.
Personal inconvenience. 2018 matter, sir.
Sir, ನಾನೇ ಡೇಟ್ ತಗೊಂಡಿದ್ದು, there was some problem at home, that is why I could not come. Next
List on
week, any day,
Tuesday.
Monday or Tuesday.
Tuesday. Yes.
Please.
79.
The 9.5 years delay in filing the appeal, your appeal, and the honorable court, only single admission that has been made.
Yes.
On that basis, your
Right, Stem. All right.
Not, here is a case where on merits, my lord, I have a good case.
Very good case.
Yes, lord.
9 ವರ್ಷ ಯಾಕೆ ತಗೊಂಡ್ರಿ?
My lord, what has happened is that there was a settlement talk going on between the parties.
Talk?
Yes, lordships. That is what is also admitted by the appellant herein. My lord, kindly look at that. And in the meantime, my lord, they sell all other properties during this time. Suit for partition, my lord, against the father, mother and grandmother. And my lord, the case of the defendant and defendant number 4 is that, my lord, it's a self-acquired property of the grandmother. Item number 1, I am concerned, lordships. Other items, my lord, they have sold, and even sale deeds are available after the disposal of the case. My case is that, my lord, it's a self-acquired property of a defendant number 4 grandmother.
ಆದ್ರೂ 9 ವರ್ಷ.
My lord, kindly look at ಮೇಲ್ಮನವಿದಾರರ ಜೊತೆ ನಾವು ರಾಜಿ ಮಾಡಿಕೊಳ್ಳುತ್ತೇವೆ ಎಂದು ಹೇಳಿಕೊಂಡು ಬಂದಿದ್ದರಿಂದ ಅವರು
ಅದು
ತಡವಾಗಿ
ನಿಮ್ಮ ಹೇಳಿಕೆ, ಅದಕ್ಕೆ ಏನಿದೆ ಡಾಕ್ಯುಮೆಂಟ್?
it is in the cross examination they have admitted.
Where is that?
My lord, kindly look at the orders on IA1 third page, lordships.
Page.
My lord, I'm sorry, my lord. Full
Orders
details.
on IA.
Just before point number 2, above that.
16, sir.
ಏನ್ ಪೇಜ್ ಲಿಲ್ಲ ಅದರ್ ಸರ್?
Page number 16, appeal memo, petition memo.
That is the reason, my lord, sorry, man.
ಮೇಲ್ಮನವಿದಾರರ ಜೊತೆ ನೀವು ರಾಜಿ ಮಾಡಿಕೊಳ್ಳುತ್ತೇವೆ ಎಂದು ಹೇಳಿಕೊಂಡು ಬಂದಿದ್ದರಿಂದ ತಡವಾಗಿ ಅಪೀಲ್ ಹಾಕಿರೋ ಅಂದರೆ ನಿಜ.
That's what they have admitted.
ಅದು ನಿಜ ಅಂದ್ಮೇಲೆ ಪೆಟಿಷನ್ ವಜಾ.
I pass on the evidence, your lordship. I will read it. In all the evidence, your lordship, she has stated, we have not contacted with him, we have not done anything.
ಮತ್ತೆ ಯಾಕೆ ಒಪ್ಕೊಂಡ್ರೆ?
ಹೇಳ್ತೀವಿ, ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಒಂದು ಹೇಳ್ತೀನಿ, ಮೊದಲು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್, ಅದಕ್ಕೆ ಪಾಸ್ ಓವರ್ ಮಾಡ್ತೀನಿ, ಬರೀ
ಪಾಸ್ ಓವರ್ ಮಾಡ್ತೀರಾ?
ಅದನ್ನ ಸ್ವಲ್ಪ ನೋಡಿ ಸರ್. She has also tendered evidence, he also tendered evidence. In the evidence, your lordship, earlier what she has said, ನಂತರ ನಾನು ಮತ್ತು FD ಪ್ರಬಂಧದಲ್ಲಿ ಹಾಜರಾಗಿದ್ದಾರೆ ಅಂದ್ರೆ ಸರಿಯಲ್ಲ. ನಾನು ಮತ್ತು ಅವರ ತಂದೆ ಮೇಲ್ಮನವಿದಾರರ ಜೊತೆ ಅವರು ಮಾಡಿಕೊಂಡ ಜಮೀನನ್ನು ಬಿಟ್ಟು ಕೊಡುತ್ತೇವೆ ಎಂದು ಅವರ ಜೊತೆ ರಾಜಿ ಸಂಧಾನ ಮಾಡಿಕೊಳ್ಳೋಣ ಎಂದು ಹೇಳಿಕೊಂಡು ಬಂದಿದ್ದರಿಂದ ನಾವು FDP ಪ್ರಕರಣವನ್ನು ದಿನಾಂಕ 22/7/14 ಈವರೆಗೂ ಹಾಜರಿಲ್ಲ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನಂತರ ಮೇಲ್ಮನೆದಾರರು ಮತ್ತು ಜಮೀನನ್ನು ಬಿಟ್ಟು ಉಳಿದ ಜಮೀನುಗಳಿಂದ ಭಾಗ ಮಾಡಿಕೊಳ್ಳಿ ಎಂದು ಹೇಳಿಕೊಂಡಿದ್ದರಿಂದ ಸರಿಯಲ್ಲ. ನಂತರ ಮೇಲ್ಮನೆದಾರರು ಮತ್ತು ವಿರುದ್ಧ ಮೇಲ್ಮನೆ ಸಲ್ಲಿಸಿದ
ಅದೆಲ್ಲ ಬಿಡಿ, ಐಸಿಂಗ್ ಒಂದು ಕೇಕ್ ಇಲ್ಲಿದೆ.
ಓನ್ಲಿ ಸಿಂಗಲ್
ಅದೆಲ್ಲ ಬಿಡಿ,
ಒಂದ್ ನಿಮಿಷ
ಇಲ್ಲಿ ಹೇಳಿದ್ನಲ್ಲ, ಇಲ್ಲಿ ಎಲ್ಲ ಇಲ್ಲಿದೆ.
ಅಲ್ಲ ಒಂದ್ ನಿಮಿಷ. I will pass on the judgment of the division bench of this honorable court
ಅದ್ಯಾಕೆ?
in a similar matter. Similar matter.
ಕೊಡಿ.
I shall produce the sale deeds also, lordships. After this time,
similar matter.
they all the
Division bench of
defendants
this
settled themselves and entire thing they have sold the properties, my lord, except mine.
ಅದ್ ಸರಿ, ನೀವು 9 ವರ್ಷ ಯಾಕೆ ಕಾಯ್ತಾ ಇದ್ರಿ ಸರ್ ಅದಕ್ಕೆ?
ಎಲ್ರು ಎಲ್ಲ ರಾಜಿ
ಅದೇನು
ಮಾಡ್ಕೊಂಡು
9 ತಿಂಗಳಾಗಿದ್ರೆ ಮಾಡ್ಬೋದು, 9 ವರ್ಷ.
my lord, ಬೇರೆ ಎಲ್ಲ ರಾಜಿ ಮಾಡ್ಕೊಂಡು ಎಲ್ಲಾ ಪ್ರಾಪರ್ಟೀಸ್ ಮಾರಿದ್ದಾರೆ.
ನೀವೇನ್ ಮಾಡ್ತಾ ಇದ್ರಿ ಅವಾಗ?
my lord, that's why my lord, I am a purchaser of the property.
14 internal page.
If it is on merits, my lord, then I have a good case.
Para number 4 ಅಲ್ಲಿ.
But that gets washed away with this
My lord,
delay,
because,
sir.
my lord, she herself has admitted that, my lord, ರಾಜಿ ಮಾಡ್ಕೊಳ್ತಾ
Delay
ಇದ್ದೀನಿ.
defeats equity.
My lord, the delay, the number of days delays, lordships.
Number of days ಅಲ್ಲ sir, years.
Years, my lord, but cause, my lord, is accepted by her.
Para number 3 ನಲ್ಲಿ 3ನೇ ಲೈನ್ ನೋಡಿ ತೋರಿಸಿ. He says the learned judge has chosen to dismiss the suit by relying upon the portion of the evidence without taking into consideration the entire evidence.
ಇದು ನಿಜ ಅಂತ ಹೇಳಿದ್ದಕ್ಕೆ.
ಅದನ್ನೇ ಅವತ್ತೇ ತಾವು ಹೇಳಿದ್ರೆ ಅವತ್ತು ಮಾಡ್ತೀನಿ. So that my submission, your lordship, the honorable court, without looking into the entire evidence what she has been tendered and the cross examination she has been subjected, without looking into that one last line al kone line alli one suggestion has been put it that she said that we are not separated, but earlier it, your lordship, she has stated you are separate.
ಆಯ್ತು ನೋಡ್, we'll see, we'll hear it after vacation.
Please, my lord.
And another judgment, your lordship.
10th October.
Lord, one more aspect is.
ಅಲ್ಲ 17th
TP is
October.
filed after 17 years. That is also, my lord.
I will take note of everything next time. 17th October. Entry mod subsisting would continue to the next date of hearing. Yes. Suit for?
That suit for recovery of money.
Why 711? Oh, recovery of money.
Recovery of money. Suit is decreed.
Decreed,
Decreed.
Igeno?
This is defendant's petition. My lords, we say that, my lord, we have repaid the amount by borrowing amount from the friend. And my lords, we have examined the friend as a witness. And my lords,
Deposit ಏನ್ ಹೇಳಿತ್ತ? Deposit?
Deposit, my lords, we already made a deposit. I have already produced the receipt.
25%.
ಹೌದು, ಕೊಟ್ಟಿದ್ದೀವಿ.
This court on coordinate bench had directed deposit of certain amount on 15/2/2021, which is said to have been complied by the petition. There is no representation on behalf of the respondent. The registry is directed to delete the indication of memo not having been filed. 5/6/25.
It is, my lords, 5/6/2020, but my lords, amount is deposited on 25/3/2021, but the receipt was not produced before this honorable court. Already deposited.
Yes, the registry to delete the indication of not having filed a memo for deposit in the light of the deposit being made and the receipt produced at a later point in time. AV IO. Next.
Let's interim order make you continue.
Granted.
Interim order is
Ide,
subject to that, my lords.
Yes.
So that.
Next.
81.
Petitioner has taken back an OC.
OC? NOC.
My name may be deleted.
Registry to delete the name of Dwarkanath HS and print the name of
Narasimhan, yes.
Narasimhan, so.
But,
Respondent, interim order ಇದೆಯಲ್ಲ? After
he
vacation.
submitted saying along with all documents, a petition copy authorized, it other documents annexures ಕೊಟ್ಟಿಲ್ಲ. But
ಅದಕ್ಕೆಲ್ಲ
anyway,
ಆರ್ಡರ್ ಮಾಡಕ್ಕಾಗಲ್ಲ, ಅವ್ರು ಇಸ್ಕೊಳ್ಳಿ ಅವ್ರು.
But anyway, my lord, I am ready to go on with the matter.
Respondent ಬೇಕಲ್ಲ ಸರ್?
ಅಲ್ಲಲ್ಲ. My lord,
ವಿಶ್ವನಾಥ್ for R1 ಅಂತ ಯಾರೋ ಇದಾರಲ್ಲ? There is an interim order also.
There is an interim order. There is no interim.
ಇದೆ ಸರ್.
My lord, but anyway.
19/2/2021 itself.
But my lord, even that is actually going against me because of the strange situation that I am stuck now in, my lord. My lord, hear me for just 3 minutes. And
Respondent ಇದ್ರೆ will dispose it, no problem at all. If it is disposable, ಆಯ್ತು ಹೇಳಿ, ಏನ್ ಹೇಳಿ?
My lord, the strange circumstances leading to this issue is, let's just suit for specific performance.
filed by the respondent number 2 herein. I had executed the agreement. The petitioner herein has executed an agreement to sell in favor of respondent number 2. Respondent number 1, sorry. Respondent number 1. This agreement was executed initially in the year 2016. Then a small change in terms of the consideration amount was made in the year 2017. Advance sale consideration of 60 lakhs is given to me. While executing the agreement of sale, it was clearly made known the existence of certain disputes in relation to that property. It was also made known that the original documents of title had been lost and we had given police complaint, etc. And having fully known of these facts, the respondent number 1 agrees to enter into an agreement to sell with me. Now, thereupon, what he does is he conducts an individual search for the title documents, etc. He gets to know that respondent number 2, who is my relative, is in possession of those original documents. Now, my lord, he files a suit for specific performance, saying that direct me to execute the registered sale deed in his favor. I have filed a memo of undertaking saying that I am ready to do so. On the one hand, I have already said that, all these documents were lost. There is a paper publication to that effect. There is a police complaint to that effect. Everything is concluded. Now, I don't even know which of these original documents he's speaking of.
Court holds that it is all your submissions are a bundle of
please, my lord,
questions of law and fact.
My lord, the only
and
thing,
therefore rejects the 711 application.
I understand. But then my problem is this, my lord. I have got only 2 options to do. Either I will repay back that 60 lakhs. Let him fight his case as against.
Let him come. Yes, pass over Marti. Respondent Bandra will see.
Please.
Next. Pass over.
Otherwise, my lord, if it is possible, any short accommodation, any specific date, my lord, so I can keep them in.
10th October.
10th October, my lord.
Immediately after vacation.
Please.
Yes.
That would be 10th October. Interim order will be stayed.
Yes, next.
82.
For specific performance of a land, of a granted land belonging to an
Stay there.
stay there.
After vacation.
Date may kindly be fixed.
Yes.
83.
Yes.
Interim order may kindly.
Granted land alva idu.
Howದು granted.
Interim order continue.
83.
Petitioner, return of plaint under order 7 rule 10.
Rule 10.
Yes, my lord.
Commercial OSA.
Illa.
Regular.
Regular.
Why written?
Well, it's under section 92, it is held that suit is not maintainable before that court.
Representative suit.
Allah, it's for declaration.
Before a particular court.
How? Well,
Yes, sir.
May, my lords. Present revision is not maintainable for the reason that
ಅದು unmaintainable ಅಲ್ಲ, ಇದು ill maintainable ಅಲ್ಲ.
appeal lies, my lords, under order 43, appeal lies. Rule 1.
May draw the attention of the court to rule 10, my lords.
Rule 10 of?
Order 7, rule 10.
Yes.
Otherly, revision or appeal ante ಇದೆ. Subject to the provisions of rule 10A, the plaint shall at any stage of suit be returned to be presented to the court in which the suit should have been instituted. Explanation.
I think maintainability early. What's the matter there? Tell me.
That's the contention, my lords, taken by the respondent, my lord, the operative portion of the order.
Now 23 in the, there's no interim order.
There is an interim order, my lord.
There is an interim.
Return of plaint, my lords. There is.
Return of plaint will have interim order. Maintain status quo. Suit schedule property. After vacation, yes.
Grateful.
Interim order subsisting will continue to the next year. That's absolute, man. In status quo antide ashte.
84.
For the petitioner, I'm not.
A paper respondent.
May only say that the petitioner.
Arrears of rent, my lord.
ಕೊಡ್ಬೇಕಾ ಇದೆಯಾ?
ಸರ್ವ್ ಮಾಡಿದೆ.
ಅವ್ರು ಕೊಡ್ಬೇಕಾ ನೀವು ಕೊಡ್ಬೇಕಾ?
ಇಲ್ಲ ಇಲ್ಲ ನಾವು ಕೊಡ್ಬೇಕಾಗಿರೋದು ನಾನು ಟೆನೆಂಟ್.
He is a tenant, I am a landlord.
ಎಷ್ಟಿದೆ?
2,17,000.
ಯಾವಾಗ ಕೊಡ್ತೀರಾ ಸರ್?
ಮುಂದೆ ಒಂದು ನಿಮಿಷ ಸ್ವಾಮಿ. I will take my instruction. I only can suggest this. I am a tenant. He's a job typist, not working for the lawyers in Mufassil Court near Maddur. A small man. He's around 73 years. Some reasonable time, if they can grant nots, I think ultimately.
Vacate.
To vacate. That is all what we are requesting.
On the affidavit haki.
So if they are agreeable for around 18 months, ultimately it's his only livelihood. 73 years old man.
ಎಷ್ಟು ದಿನ ಬೇಕು?
18 months. In ಎಷ್ಟು ದಿವಸ ಕೆಲಸ ಮಾಡಕ್ಕಾಗತ್ತೋ? That is all minutes.
The arrears are 2,17,000.
ಕೊಡ್ತಾರೆ.
Arrears,
That
it
will
is
be given.
computed at the rate of 1,400 rupees per month.
No, that will be given.
That should be given minutes. I'll make a list of what.
ಆಯ್ತು, you file, get an affidavit.
I'll get an.
I'll take it on Wednesday.
Please, minutes.
Yes,
Please.
list on Wednesday.
Please, minutes.
The petitioner shall file an affidavit of the timeline in which he would vacate the premises and deliver vacant possession, subject to conditions.
85.
Petition. Landlords.
Vacated the end of the key, only just.
ಈಗ ಮನಿ
80,000 ರೂಪಾಯಿ ರಿಲೀಸ್ ಆಗಿದೆ ಸ್ವಾಮಿ. 80,000 ರೂಪಾಯಿ ಕೊಡ್ಬೇಕು.
80,000 ರೂಪಾಯಿ
88,000 ರೂಪಾಯಿ ರಿಲೀಸ್
ಕೊಡ್ಬೇಕಾ?
ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ದಾರೆ.
ಎಲ್ಲಿ?
ಬಿಫೋರ್ ದಿಸ್ ಆನ್ ರಿಪೋರ್ಟ್.
ನೀವು ವಿಡ್ರಾ ಮಾಡಕ್ ಕೊಡ್ಬೇಕಾ?
ಇಲ್ಲ, ಆಲ್ರೆಡಿ ಲಾಸ್ಟ್ ಟೈಮ್ ಆರ್ಡರ್ ಆಗಿದೆ. 80,000 ತಗೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಸೊ ರಿಮೈನಿಂಗ್
80,000 remaining.
88,000.
Who is entitled to that? You?
I am entitled for that.
Pass an order.
ಇಲ್ಲ ಸರ್, ಲಾಸ್ಟ್ ಟೈಮ್ ಆರ್ಡರ್ ಆಗಿದೆ. 80,000 ಲಾಸ್ಟ್ ಟೈಮ್ ತಗೊಂಡಿರೋದು ಅವರು.
ಆರ್ಡರ್ ಯಾವ್ದು ಆರ್ಡರ್ ಇಲ್ಲ ಇಲ್ಲಿ?
ಐ ಆಮ್ ರೆಡಿ ಫಾರ್ ದಿ ಆರ್ಗ್ಯುಮೆಂಟ್. ಈಗ
ರೆಡಿ ಫಾರ್ ದಿ ಆರ್ಗ್ಯುಮೆಂಟ್. 80,000 ಕೊಟ್ರೆ ಆರ್ಗ್ಯುಮೆಂಟೇ ಇಲ್ಲ.
ಇಲ್ಲ, 80,000 ಅಂದ್ರೆ ಅದೇ ಟೋಟಲ್ ಅಮೌಂಟ್ ಡೆಪಾಸಿಟ್ ಮಾಡಿ.
Actually, I am éniде. I handed over the key and I vacated the property. The advance which I have received, they are not returned back.
Amount ಬಗ್ಗೆ dispute ಇರೋದು because
The learned counsel for the respondent submits that the advance amount that the landlord has received is not being returned despite the handing over of the vacant possession of the premises and the keys thereon. Therefore, list the matter on 17th October. In the event the petitioner, 16th October, in the event the amount of the advance amount that is, if it is not returned without justifiable reasons, the petitioner would be saddled with exemplary interest upon the said amount by the next date.
One thing where the entire
Also,
amount
we
is
paid
in
the court fee
deposit.
and all, and we paid the court bill as part of the orders have 6%
It's
interest.
17th, yes.
Entire amount deposit ಮಾಡಿದೀವಿ as per
ಪರವಾಗಿಲ್ಲ.
the compliance ಪ್ರಕಾರ.
Next.
86.
No, 711 comes to be dismissed.
Notice ಆಗಿದೆಯಾ?
Agide, no one's appeared for the respondent. Your lordship, in fact, if your lordship sees the order.
There's a detailed interim order.
How the 26th June, if my lord has the
Yes,
order.
detailed order I have passed.
Please. So in fact, here, 711 is preferred on the ground that the suit is preferred in the year 2023, challenging a 91 sale deed. We said barred by limitation.
Yes, list after vacation interim order subsisting.
May I just trouble your lordship to dispose of the petition your
Today.
lordship had indicated. As it's not contested.
Let's see.
And your lordship has taken note of a coordinate bench's order in MFA.
Correct, yes.
Because the petitioner, my lord, is 73 years old. I'm told she's chronically unwell, wants to settle her affairs. So I'm just placing that for my
List on
lordship.
Tuesday in preliminary hearing.
Great.
Next. In admissions, sorry.
87.
For the respondent in this case, my lords, filing statement of objection with
Senior
non-for
counsel is
citation,
not
my lord.
available today. He's in Delhi, my lords, if it may
Objections.
Objection.
Learned
copy has been served.
serve ಮಾಡಿದ್ದೀರಾ?
Yes, my lords. We'll file in the registry.
Learned counsel for the respondent seeks time to file objections. The same be filed in the registry. List after vacation interim order subsisting will continue to the next date. Next.
88.
Happy for the petitioner. My lord, there are other two writ petitions. My lord, I will narrate the facts. My lord, the plaintiff has filed a suit for a declaration. And also, my lord, the compromise decree which has been entered between the defendants is not binding upon the plaintiff. My lord, according to the plaintiff allegation, he has become absolute owner of property by virtue of the order of the land tribunal passed by this one. My lord, there is no order of the land tribunal. Only there is a form number 7. Against that, my lord, I challenge the form number 10 issued before this honorable court in writ petition number 10,964-20.
I will continue at 2:30.
Yes. My lord, the records are of those writ petitions are necessary.
Records ಬೇಕಾದ್ರೆ.
ಆ writ petition, otherwise I will produce all the records. My lord, there is an endorsement given by the land tribunal saying there is no order. I have to produce them, my lord. The village was registered of the form number 7. An endorsement given, my lord, there is no, my lord, the land which has been mentioned in the village was registered also.
Will pass that order to.
My lord, may I seek for an adjournment?
Serial number 44 that is disposed of. There's some confusion regarding the instructions because we have specifically stated in the plain that it was not commercially utilizable from 15/7. Now the direction is that after the expiry of rent repair, the possession was not even given to me.
ಯಾವುದಕ್ಕೆ ಸರ್?
Serial number 44 it was disposed.
ಏನಾಗಿದೆ ಈಗ?
Now the order that is passed says that after the expiry of rent free period, I am supposed to deposit the entire rent.
Correct.
Now I have stated specifically.
ಅವ್ರು ಕರ್ಕೊಂಬನ್ನಿ.
No, ಅವ್ರು ಇದ್ದಾರೆ sir.
ಯಾರು ಸುನಿಲ್ ಇದಾರಾ?
It may post it on Monday, may request my lord.
We'll see, get him, we'll see, yes.
May I seek for an adjournment, please, my lord?
In what?
Serial number 95.
No, admission matters don't seek. B group ಏನಾರು ಇದ್ರೆ.
Serial number 91.
For the
91, my lord.
For the
103 is settled, my lord. Serial number 103, matter is settled in the trial court and closed. Petition doesn't survive for consideration.
Serial number?
103, my lord.
My lord,
Learned
respondent
counsel.
is agreed. I'm making payment of 5 lakhs in 95.
ಯಾವ್ದ್ರಲ್ಲಿ?
In serial number.
No, lunch hourಲೇ ಮಾಡ್ಬೇಕಾ ಇದೆಲ್ಲ? Come at 2:30.
Serial number 91, my lord.
179, my lords, for the petitioner.
There is a bench in the afternoon. After the bench, I'll come back, then we'll take.
Serial number 91, my lord. 91, my lord.
Adjournment.
Adjournment.
Respondent ka ನೀವು?
ಅಲ್ಲ, petitioner.
Non-respondent game. Because of this, my lords, they have stalled the proceedings and they.
No adjournment. There is a.
170.
I have a root canal in the afternoon.
You get it done, sir. Don't worry.
I'll
5 lakhs ಬೇಕಾ ಅದಕ್ಕೆ?
ಇಲ್ಲ, I'm making payment of 5 lakhs.
Oh, sir.
He agrees for adjournment, my lord. Serial number 95.
ಯಾರು? You don't worry, you carry on with your root canal. We'll pass an order.
It's 179
Monday, my lord.
files.
The matter is settled.
103 ಅದನ್ನ settled ಅಂತ.
That's 179, my lords. Charge sheet has already been filed by, in the trial court, my lords. 179, may I
Want to
seek
withdraw?
liberty, please, my lords.
Learned 179, once learned counsel of the petitioner submits during the pendency of this subject petition, charge sheet has been filed before the concerned court, reserving liberty to challenge the said,
That's 179.
disposed as withdrawn.
My lord, 179.1 petition.
Two matters, yes.
That's grateful, my lords.
170, 2 weeks time.
ಅದು ನೋಡೋಣ ಆಮೇಲೆ. Yes.
And serial number 90, my lord. Even the petitioner counsel is there, my lord. I request for it.
But wait, admission
44 on
don't ask.
Monday, my lord.
We'll come back.
Non-compliance is Monday, my lord.
ಈಗಲ್ಲ ಆಗಲ್ಲ.
44.
Sir, madam, serial number
taken as an order from the court so that.
Yes,
nobody's put
that's
them
what.
back.
It's serial number 155, my lords. If
You want to
lords
withdraw?
Directed the executive engineer present, but my lords,
Available
it is-
warrant, ಅದೇನಾ?
ಇದು ನಮಗ್ ಬರಲ್ಲ government ಗೆ. Executive engineer, project director ಅಂತ ಅವ್ರಿಗೆ.
ಯಾವ ಪ್ರಾಜೆಕ್ಟ್ ಡೈರೆಕ್ಟರ್ಗೆ?
National Highway Authority is the.
ಮತ್ತೆ ಯಾರು ನೀವು ತಾನೇ ಹೇಳಿದ್ದು?
ನಾನಲ್ಲ, ಅವ್ರ petitioner council submit ಮಾಡಿದ್ರು.
ಶೋಭಿತ್ ಶೆಟ್ಟಿ ಅವರೇ.
ಅವರು ಹೇಳಿರೋದು ರಾಂಗ್ ಸಬ್ಮಿಷನ್ ಮಾಡಿ ಇದ್ ಮಾಡಿದಾರೆ. ನಮಗ್ ಬರಲ್ಲ ಅದು government. He is present, my lords, if executive engineer, Maintainability.
ಅಲ್ಲ ಅವೈಲೇಬಲ್ ವಾರೆಂಟ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದು ಯಾರಿಗೆ? ಅದು ಬೇರೆದ್ರಲ್ಲ.
ಇದ್ರಲ್ಲ ಅದು ಬೇರೆದು. ಇದು ಮೊನ್ನೆ ನಾನ್ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದೆ.
ಶೋಭಿತ್ ಶೆಟ್ರೆ.
ಹಾ.
ಒಂದು ಮ್ಯಾಟ್ರಲ್ಲಿ ಇಟ್ ಇಸ್ ನ್ಯಾಷನಲ್ ಹೈವೇ
ಡಿವಿಷನ್ ಅಂಡ್
ಇವರೆಲ್ಲ ಅಂತ ಇದಾರೆ. ಈಗ ಜಾಯಿಂಟ್ ಅಂಡ್ ಸೆವೆರಲ್ ಅಂತ ಆರ್ಡರ್ ಮಾಡ್ತೀನಿ ಕಾಂಪನ್ಸೇಷನ್ ಕೊಡಕ್ಕೆ. ಅವಾಗ ಗೊತ್ತಾಗುತ್ತೆ.
ನಮ್ಮ ಅಂಡರಲ್ಲಿ ಏನು ಇಲ್ಲ, ಸ್ಟೇಟ್ ಅಂಡರಲ್ಲಿ.
In this matter, very clear, they are transferring the file from NH division Mangalore to NH division Hassan. That is the document they are producing. If they produce document to show that, because this land acquisition officer constituted on 2012. Acquisition.
ಅದೆಲ್ಲ ನೋಡಿದೆ ನಾನು, ಆರ್ಡರ್ ಮಾಡಿದ್ದೀನಿ.
97,
Now they say it is with the NHAI.
If they produce one document to show that they have handed over this particular pending case during 97, 98, then
Kodi,
they have no
produce
case.
that document. Don't
Produce
see
any document.
all of you are trying to escape grant of compensation to a land loser.
Yes, ma'am.
This is highly incorrect. I will direct joint and several to be granted compensation costs ಎಲ್ಲ. ನಾವಲ್ಲ ಅಂತಂದ್ರೆ ಇದಾಗಲ್ಲ ಇದೆಲ್ಲ.
ಪ್ರಾಜೆಕ್ಟ್ ಡೈರೆಕ್ಟರ್ ಅಂತ ಬರ್ತಾರೆ ಅವರು.
Whatever, ಅದಕ್ಕೆ what he is saying, you give the file, get the records where you have transferred this particular file.
Particular file with survey number and LAC.
If you want Rajkumar avare, if this person is wanting to escape responsibility, he will face it, I am telling you. ಅದಕ್ಕೆ ಫೈಲ್ ಬಂದಿಲ್ಲ ಅಂತಂದ್ರೆ ಕಾಂಪನ್ಸೇಷನ್ ರಿಲೀಸ್ ಮಾಡಿದ್ರೆ ಸರಿ ಫಾರ್ ಲ್ಯಾಂಡ್ ಲೂಸರ್. ಇಲ್ಲ ಅಂದ್ರೆ ಐ ಆಮ್ ಗೋಯಿಂಗ್ ಟು ವ್ಯೂ ಇಟ್ ವೆರಿ ಸೀರಿಯಸ್ಲಿ.
Because 23rd January Lordship directed them to be present. They said we
And
engage lawyer.
ಈಗ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕರೆದ ತಕ್ಷಣ ಬರಕ್ಕಾಗಲ್ಲ ನಿಮ್ಗೆ? ವಾರಂಟ್ ಇಶ್ಯೂ ಮಾಡ್ಬೇಕಾ? We will record it in your service register that you have disobeyed the orders of the court. Promotion ಸಿಗೋದೇ ಇಲ್ಲ.
Now also I am requesting them, let them give some piece of paper to us.
The records, the executive engineer who was dilly-dallying appearing before the court is now present before the court and submits by singing the same swan song that the files have been transferred to the National Highway Authority of India.
Hassan.
Project Director NHAI Hassan. The learned counsel for the petitioner submits that if a document is produced of such transfer, it would vindicate the stand of the executive engineer. Therefore, the document of that kind be placed before the court on the next day, Tuesday at 2:30 PM.
Particularly that document with case number, that's all.
ಈ case number ಹೋಗಿದ್ರೆ fine. Otherwise, if he is trying to escape, then we will take care. Yes.
Obliged, ma'am.
My lords, on submission, my lords. Serial number 110, my lords. Kindly grant me short accommodation.
I'll reach shortly. Wait, madam.
Please,
ನಿಮ್ದೇನ್ ಸರ್?
Sorry to make a mention.
ಅಡ್ಜರ್ನ್ಮೆಂಟ್
ಇಲ್ಲ serial number 171 ನಲ್ಲಿ further hearing ಇದೆ. All the disciplinary inquiry report ಅನ್ನು ಹಾಕಿದ್ದೀನಿ, exonerate ಆಗಿದ್ದು. And all of them.
ಆ ಟಾಪಿಕ್ ಹೇಳಿದ ತಕ್ಷಣ ಅವ್ರು ಎದ್ದು ಬಂದ್ರು ನೋಡಿ.
All of them.
ಇಲ್ಲ ಅವ್ರಿಗೆ.
In the verge of retirement. That is why I will take it. Requesting.
We will take it and leave the court. Don't worry. Yes.
Judgment ಗೆ ರಿಸರ್ವ್ ಫಾರ್ ಜಡ್ಜ್ಮೆಂಟ್ ಮಾಡ್ಕೋಬಹುದು.
ರಿಸರ್ವ್ ಆಗಿ ಫರ್ದರ್ ಕ್ಲಾರಿಫಿಕೇಶನ್ ಇದು ಹಾಕ್ಲಿಕ್ಕೆ
ಇವರೇ ಮೂವ್ ಮಾಡಿದ್ರು.
ಅಲ್ಲ ಅವರು ಮೂವ್ ಮಾಡಿದ್ರು.
ಅದು ನಾನು ಎನ್ಕ್ವೈರಿ ರಿಪೋರ್ಟ್
ಮಾಡಿದ್ರಿ.
ಎನ್ಕ್ವೈರಿ ರಿಪೋರ್ಟ್ ಒಂದು ಹಾಕ್ಬೇಕು ಅಂತ ಹೇಳಿ ಹಾಕಿದ್ದೀನಿ. ಮೇ ಬಿ ರಿಸರ್ವ್.
ಫೈನ್. ಎಸ್
ಪ್ಲೀಸ್.
ಅಲ್ಲ ರಿಸರ್ವ್ ಬೇಡ. ವಿಲ್ ಪೋಸ್ಟ್ ಇಟ್ ಆನ್ 24th. ಅವತ್ತು ಮಾಡುವ.
ಸಾರಿ ಟು ಮೇಕ್ ಎ ಮೆನ್ಷನ್.
ವೈ? ಸಾರಿ. Yes.
Can permission?
Yes, sir. Serial
number 11 I request next week.
Ella next week, sir. We will take it there only. Don't worry.
Interim order.
That will continue, sir. Yes.
Great.
Continue the list, ma'am.
Kindly pass over it, madam. 155. Serial number 88, madam. 88.1. Cell number 88.1, my lord, kindly pass over it, madam.
Pass over.
Senior is there.
Serial number 88. Or
Actually for
argument.
the 88,
Ah.
it is for 88/1.
ಆಯ್ತು. What's the matter?
My lord, the question involved is, my lord, whether tenancy matter is pending before this honorable court. My lord, whether the civil court can, my lord, decide the matter. That is the, my lord, the
I will hear. Pass over back. Passed over to October 16th.
My lords.
Yes, next.
Have it on next week, my lords.
Next week. Email ಇದೆ.
ಅಲ್ಲ ಒಂದು ವರ್ಷ ಸ್ಟೇ ಆಗಿದೆ ಸ್ವಾಮಿ, ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ನಡೀತಾ ಇಲ್ಲ.
ನಾನ್ ಕೊಟ್ಟಿಲ್ಲ ಅಷ್ಟೇ. We'll see.
Have it on next week.
ಇಲ್ಲ 10ನೇ ತಾರೀಕು ತಗೋಣ.
Entry
model. Yes. 10th October ಅಂತ ಮಾಡಿ.
And for the petitioner, my lords, the petitioner has passed away.
Petitioner has?
He passed away, my lords. I shall take necessary, I'll file
Learned
necessary
counsel for the
application.
petitioner submits the, first which petitioner?
Rangaswamy, first petition.
First petitioner is no more and would seek time to take steps in the matter. List after 2 weeks, steps be taken by then. Next.
Lord, for the petitioner, I request for a date, my lord.
Date.
I
Date.
request for an adjournment.
Adjournment, yes, better.
Please.
Will be taken up next week, my lord, Monday or
We'll take it on Wednesday.
Wednesday. Have it after vacation, my lord.
What's the matter?
My lord, Order 7, Rule 11 was rejected. This honorable court, my lord, by a detailed order on 6/3/25, has stayed further proceedings.
Stayed, yeah.
Yes, my lord. The reason is, my lord, first one suit is filed against me. There's a third or fourth suit. One suit is filed against me on the same property.
Same property?
Yes, my lord. First one suit is filed by one set of plaintiffs in OS 437 of 2020.
What happened?
Their plaint comes to be rejected by order of this honorable court. Thereafter, the order is challenged before Supreme Court and the order of this honorable court is upheld. After that, my lord, the petitioner here, respondent here, who is a plaintiff, he files an application to challenge the Order 7, Rule 11 in OS 437 of 2020, even though he's a defendant. So in that suit, he's a defendant, but he challenges the order of rejection before the Honorable Supreme Court.
Anyway, that is confirmed.
Yes, my lord. Now, my lord, he has filed this.
This is the third one?
This is the third one, my lord.
They were totally not related to the.
My lord, could have it on Tuesday or Wednesday, my lord.
Extortion.
Yes, my lord.
All right. List on Wednesday.
Grateful, my lord.
Yes, sir. Yes, sir. No list the matter after vacation. No representation, list after vacation. Entry model continue. Shivrudra, sir.
Lord, the rejection of the plaint, I have made an application before the court below, Lord.
Entry model ಇದೆಯಾ?
Entry model.
Yes, ಹೇಳಿ.
Year ಮಾಡೋಣ ಅಂತ ಹೇಳಿದ್ರಿ.
ಹೇಳಿ.
So this is the photos which I, for a moment, I'll produce before my
711
lords.
photos ಮೇಲ.
ಅಲ್ಲ ಒಂದು ಫೋಟೋಸ್ ಕೊಡ್ತಿತ್ತ ಒಂದ್ಸಲ my lords have a glance at it, Lord. ಅದು ಶಾಲೆ ಮುಂದೆ ಇರುವಂತ ಒಂದು 60-40 ಸೈಟ್ ನಲ್ಲಿ ಆ ಮಕ್ಕಳು ಪ್ರೇಯರ್ ಅಥವಾ ಮತ್ತೆ ಏನೋ ಆಡ್ಕೊಳ್ಳೋದಕ್ಕೆ ದೇ ಹ್ಯಾವ್ ಫೈಲ್ಡ್.
ಚೆನ್ನಾಗಿದೆ.
ಅಲ್ಲ ಮುಂದೆಗಡೆ ಒಂದು ಗ್ರೌಂಡ್ ಇದೆ ನೋಡಿ, ಅದ್ರ ಹಿಂದಿನ ಫೋಟೋದಲ್ಲಿ. ಸ್ಕೂಲ್ ಮುಂದೆ ಒಂದು ಜಾಗ, ಒಂದು 60-40 ಸೈಟ್ ನಲ್ಲಿ ಆ ಮಕ್ಕಳು ಪ್ರೇಯರ್ ಮಾಡೋದಕ್ಕೂ ಸಣ್ಣ ಮಕ್ಕಳು ಆಡ್ಕೊಳ್ಳೋದಕ್ಕೆ ಮಾತ್ರ ಅದು. It is the property of the trust itself.
What's the problem now?
Problem is the person who is adjacent to that property. For the 25 years, he didn't have any problem. Now he has got a problem.
ಅದರಲ್ಲಿ ಏನು ಸೂಟ್ ಹಾಕಿದ್ದಾರೆ ಈಗ?
ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿ ಇದನ್ನ ಲೈಸೆನ್ಸ್ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿ ಇದನ್ನ ಮಕ್ಕಳನ್ನ ಆಡೋಕ್ ಬಿಡಬೇಡಿ ಅದು ಇದು ಅಂತೆಲ್ಲ ಹಾಕಿ.
How is it entertainable before a civil court?
ಮಾಡಿದಾರ ಅದು. That's what I made an
The
application.
petitioner is before this court calling in question an order dated 26/10/2024 by which the concerned court rejects an application to Order 7 Rule 11 of the CPC. The respondent is the plaintiff who institutes a suit in the said OS. The relief that is sought is that the license that is granted to the petitioner to run the school should be cancelled as he is the neighbor The said relief sought before the concerned court was not even entertainable by the court. Therefore, the application under Order 7 Rule 11D ought to have been answered favorably, albeit prima facie, should have been answered in favor of the petitioner prima facie. There is no representation on behalf of the respondent. List the matter on 24th October. There shall be an interim order of stay of further proceedings before the concerned court till the next day.
Lordship, there was some internet problem. Now I'm on respondent. I appear
Yes,
for
yes,
the
you come on 24th, sir. Next. Are not present on Tera Tagadbudi. Yes.
Let's appear for the petitioners, Mr. Navidgi senior.
Then, ನೀವು ಈ ಕಡೆದ?
ಇಲ್ಲ ಫೋಟೋ ಇಸ್ಕೊಳ್ಳೋಣ ಅನ್ಕೊಂಡೆ.
Photo ಕೊಟ್ಬಿಡಿ ಅವ್ರಿಗೆ.
My lords, Mr. Navidgi senior advocate is engaged in this matter. He's held up, my lords. I request for an adjournment.
CRP,
Yes, my lords.
no interim order?
No interim order.
List after 2, list beyond AV, no IOC, after vacation. At the request of the council appearing for the petitioner, AV. Next.
I am for petitioner. Your lordship, my 7 Rule 11 application rejected. The suit is barred by limitation of section 58 of the Limitation Act.
Suit for declaration?
Yes, your lordship.
Section 58, article 58.
Article 58.
Yes.
The page number 26, your lordship, the first date for cause of action arose on 23.
Plaint, go to the, take me to the plaint.
26, that is the cause of action.
20?
26, ink page number. The 14 is the cause of action para.
Yeah, just a moment, sir.
23/6/2008.
18, date of the institutional suit.
Suit is 24/11/2021. There is a 5-month delay is there. As your lordship.
My lord, it's a COVID period, my lord, it's the suit.
Oh, Supreme Court order. Limitation. Article 58 also stands extended.
It's a mixed question of law and facts.
ಈ ಏನ್ ಮಿಕ್ಸ್ ಇಲ್ಲ ಇಲ್ಲಿ 5 months delay ಡೆಫಿನೆಟ್ ಆಗಿದೆ. Facts are stubborn, but COVID ಸ್ವಲ್ಪ ನೋಡೋಣ ಬರುತ್ತಾ ಇಲ್ವಾ.
Nikhil Mehta case, your lordship is aware of. Nikhil Mehta case of the Supreme.
ಕೊಡಿ sir.
Your lordship is. Sorry, your lordship. That is my.
ಇದು ಕೋವಿಡ್ ಕನ್ಸಿಡರ್ ಮಾಡಿದಾರ?
COVID consider.
ಮತ್ತೆ ಇವರು ಕೋವಿಡ್ ಹಿಡ್ಕೊಂಡಿದ್ದಾರೆ.
17 and 14, madam.
We'll hear it after vacation.
The sale deed in the name of the joint name. Sale deed in the name of the joint name.
This cuts at the jurisdictional issue. I am afraid whether we can import the COVID limitation to this. We'll see. List on 16th, 17th October.
Some interim protection.
ಇಲ್ಲಿವರೆಗೂ ಇಲ್ಲ. 1 ವರ್ಷ ಆಯ್ತಲ್ಲ. ಅವತ್ತು ಕೊಡೋಣ. ಇಂಟ್ರಿಮ್ ಪ್ರೊಟೆಕ್ಷನ್ ಯಾಕೆ ಫೈನಲ್ ಪ್ರೊಟೆಕ್ಷನ್ ಕೊಟ್ಟು. ವಿಲ್ ಸಿ.
ಅವ್ರ ಆರ್ಡರ್ಸ್ ಅಲ್ಲಿ ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಮೇಲೆ ಆರ್ಡರ್ ಸಿಗೋದು. ಬ್ಯಾಂಕ್ ಇಸ್
ಅದಕ್ಕೆ ಏನಾಗಲ್ಲ. ಬ್ಯಾಂಕ್ ಬೇರೆ ಇಂಪ್ಲೀಡ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
ದೇರ್ ಇಸ್ ಅ ಮಾರ್ಟ್ಗೇಜ್ ಲೋನ್ ಇದೆ.
ಅದು ಮಾಡಿ. ಸಿವಿಲ್ ಕೋರ್ಟ್ ಎಲ್ಲ ಎಂಟರ್ಟೈನ್ ಮಾಡಕ್ಕೆ ಸ್ಟಾರ್ಟ್ ಮಾಡಿದ್ದಾರೆ.
ಸಮ್ ಇಂಟ್ರಿಮ್ ಪ್ರೊಟೆಕ್ಷನ್.
ಅವತ್ತು 17th.
I for the respondent, my lord.
90?
95, my lord. This is a matter regarding to.
No, sorry.
They have given the DD.
ಅವ್ರಿಗೆ ರೂಟ್ ಕೆನಾಲ್ ಟ್ರೀಟ್ಮೆಂಟ್ ಬೇಕಲ್ಲ.
DD ಇವತ್ತು ಕೊಟ್ಟು ಹೋಗ್ಬಿಟ್ರು. But the arrears of rent is, we have filed a suit for ejectment and arrears of rent. It is more than 15 lakhs.
ಪರವಾಗಿಲ್ಲ.
5 lakhs ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅದು ರೂಟ್ ಕೆನಾಲ್ ಬದಲು ಅಂತ ತಗೊಂಡ್ಬಿಡಿ 5 ಲಕ್ಷ.
ಅಲ್ಲ, it should not take away my right to evict.
You should, why did you receive it?
ಅಲ್ಲ ಇಲ್ಲ, ಅವ್ರು ಇದನ್ನ ಮಾಡಿ ಕೊಟ್ಟು ಹೋಗಿದ್ದಾರೆ. ಅದು
ಫೋಟೋನೋ ಡಿಡಿನೋ?
ಇಲ್ಲ ಡಿಡಿನೇ ಇದೆ.
ಆಯ್ತು, ಅವ್ರಿಗೆ ಟೈಮ್ ಬೇಕು ಅಂದ್ರು.
Please, a date may be fixed.
I'll record that. ವಾಪಸ್ ಕೊಡ್ತೀರಾ?
Last date of hearing.
The learned counsel appearing for the petitioner
to file an affidavit.
ಒಂದು ನಿಮಿಷ. Seeks time on the score that he has to undergo a root canal treatment. At the same time, hands over a demand draft of rupees 5 lakhs to the respondent. The respondent, without prejudice to his rights of claiming huge arrears of rent, has accepted the same. List the matter on 17th.
Arrears of rent as well as eviction also.
Without prejudice to his rights of getting the petitioner evicted apart from claim for the entire arrears of rent.
Please.
List the matter on 17th.
Please.
96.
96 No representation AV.
97,
Same.
98,
Complaining, there is an injunction decree in my favor. Complaining disobedience, my lord, I filed execution. No objections were filed by the judgment.
Execution
letter.
petition dismissed.
It is dismissed, my lord.
Why?
In spite of there being no objection, in spite of there being no cross-examination, in spite of there being no evidence by the
Again,
JDR,
Nadita, ಏನಿಲ್ಲ, everything is closed there.
nothing, no interim order, my lord, it is dismissed. So, my lord, unless the petition is allowed, I am seeking attachment of his property to
Correct.
enforce, my lord, disobedience.
We will list it on Tuesday. Yes. Preliminary hearing. Admission, sorry. Next.
99,
For petitioner, my lords. Plaintiff.
Nagesh sir, that criminal appeal I'll take at 5 o'clock because there was a bench 1 hour delay ಆಗಿದೆ. 5 ಗಂಟೆಗೆ ತಗೋಬೋದು. ನೀವು ವೇಟ್ ಮಾಡೋದನ್ ಬೇಡ. 5 ಗಂಟೆಗೆ ಬಂದ್ರೆ ಆಯ್ತು. ಅಲ್ಲ ಅಂದ್ರೆ ನೀವು ಕೂತಿರ್ಬೋದು ಹೇಳಿ ಬೇರೆ ಏನೋ ಕಡೆ ಇದ್ರೆ. Yes, yes. Yes.
Plaintiff's petition, my lords. Order 9, Rule 13 application filed by the defendant has been allowed. Only short point, my lord, limitation aspect. He has filed Order 9, Rule 13 application beyond the limitation period, my lords. As per Article 123, my lords, 30 days limitation period.
9 Rule 13 ga.
Order 9.
The expert judgment satisfied ಮಾಡಕ್ಕೆ.
Yes, ma'am. Beyond limitation period, everybody has filed application.
Date on which it was dismissed.
My lords, just a minute, my lords. Decreed on, my lords, 20th March 2019.
20th March 2000. Application filed on.
Application filed on 24/2/2020, my lords. As per his
11 months.
11 months, and it's from the date of knowledge. 30 days from the date of knowledge. As per his application averment, my lords, he came to the knowledge on 9/12/2019.
9/12/2019.
He has filed with,
ಅಲ್ಲಿಂದ
filed application on 24/2/2020.
24/2/20.
Yes,
Date of knowledge ಇಂದನೂ ಡಿಲೇ ಇದೆ.
ಅಲ್ಲಿಂದ delay ಇದೆ. I am relying on two authorities, my lords.
Yes sir. ಈ ಕಂಡೋನ್ ಮಾಡಿದಾರಾ?
ಇಲ್ಲ, application is allowed, my lords.
ಅದೇ
It is restored.
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 ಕೊಡಿ. Yes, Prasad sir.
Actually, 19/12/19 it's sorry, from the order 23/1/2020 is the date of knowledge. Copy obtained, it's a copy application delay they are not telling before this order court. And kindly similar to 123 of the
ನಿಮ್ಮ
limitation.
knowledge ಬಂದ ಮೇಲೆ ಕಾಪಿ ಅಪ್ಲೈ ಮಾಡಿದ್ಯಾ ಅವಾಗ?
Copy apply ಮಾಡಿದೆ.
Copy obtained on 23/1/2020.
23/1. ಇದು 24/2 ನಾ?
ಆದ್ರೂ 2 ದಿವಸ ಡಿಲೇ ಇದೆ.
2 ದಿನ ಡಿಲೇ ಉಂಟಲ್ಲ?
No, my lord. It's a kindly see, my lord, from the date of knowledge, the article 123, my lord, this is not applicable for the paper publication. Earlier, my lord, it's a 30 days is concerned, my lord, only
We'll
for the
decide.
purpose of.
The issue in the list is with regard to allowing of an application under Order 9 Rule 13 to set aside an ex parte judgment. It transpires that the ex parte decree is granted on 23/2019. The respondent then is said to have gained knowledge of the same on 9/12/2019, files an application on 24/2/2020. The interregnum is spent in securing a certified copy of the said order is a submission of the counsel V.S. Prasad. The matter would require consideration till the next date. Further proceedings before the concerned court shall commence.
It's a paper publication. It's not the 123 is
Say
not
idea?
applicable.
ಇಲ್ಲ.
ಹಾಗಾದ್ರೆ
123 is concerned, my lord, the first service fee is concerned, my lord, it's only paper publication.
I'd say we will consider it. List on 10th October.
My lords, till then, my lords, suit is proceeding further, my lords.
Let it proceeds. Vacation allunu ಈಗ. Yes.
100.
List on 10th. Next. Matter would require consideration ಅಂತ ಬರೆದು ಅಲ್ಲಿಗೆ ಸ್ಟಾಪ್ ಮಾಡಿ. IO ಬೇಡ. 100?
100.1 ಅಲ್ಲಿ ಸರ್ವಿಸ್ ಕಂಪ್ಲೀಟ್ ಕನೆಕ್ಟೆಡ್.
100.1 ನಲ್ಲಿ ಸರ್ವಿಸ್ ಕಂಪ್ಲೀಟ್ ಆಗಿಲ್ವಾ?
Plaintiff is served, others may not have filed a memo to dispense.
In terms of the memo, 100.1 dispensed list after vacation. Yes, next. That will continue. Next.
101.
File application, I have to file objection to the.
The counsel for the respondent seeks 2 weeks time to file statement of objections. List after 2 weeks. IO. Yes.
Please.
Next.
102.
The petitioners, my lord, I have also filed writ petition in writ petition number 25295 of 25 in respect of order passed on I number 3, my lord. It is posted on 18. Kindly have it on the same
That
day.
is
On
not
8th.
with respect to injunction.
It is posted
A
on
was
8th.
granted.
Yes.
That is
Tag this
confirmed by the-
petition. CRP na idu.
Idu CRP.
List on 8th. Yes. 8th October.
103.
I appear for the respondent in this matter. My lord, the matter came to be settled before the trial court.
Settled.
And my lord, the petitioners have agreed to execute the sale deed. But my lord, it has not yet been executed. So let this petition be pending, my lord, for 2 more weeks.
All right. Yes.
We will report settlement.
The parties to the list would seek 2 weeks time to report settlement, comma, if any, by list the matter after 2 weeks.
Obliged.
I appear for the petition. Application made under order 7 to 11 is rejected. But there is an admission. This is a suit for bare injunction. Page 21 is the.
711 on what ground?
On the ground that he has admitted that I am in possession. Para 7 may kindly be seen at page
That's a matter of evidence.
22,
Yes.
23.
Emma,
There is a clear
notice
admission.
ಆಗಿದೆಯಾ?
Service agide.
ಎಲ್ಲಾಗಿದೆ?
I was permitted to take out notice on the.
Who
plaintiff
permitted?
is represented also.
Represented also, no? Yes, list on 8th. Next.
105.
For the petition, the ejection suit came to be dismissed, holding that the daughter is the landlord, not the plaintiff. And plaintiff is the mother, and which was let out for a good on purpose for a limited period.
You are the tenant.
I am the landlord.
I am the respondent, I am the tenant.
Oh, you are the tenant. Eviction suit is dismissed. ಏನು ಓನರ್ಶಿಪ್ ಪ್ರೂವ್ ಮಾಡ್ಲಿಲ್ವಾ?
ಓನರ್ಶಿಪ್ ಮಗಳು ಅಂತ ತಾಯಿ ಮಗಳದು ಅಂತ ಅವ್ರದ್ದು ಮಗಳು ಮದುವೆ ಆಗಿ ಅಮೆರಿಕದಲ್ಲಿ ಇದ್ದಾಳೆ. ಇವ್ರು ರೆಂಟ್ ಪೇ ಮಾಡಿದ್ದಾರೆ ತಾಯಿಗೆ. ಲಾಸ್ಟ್ ಡಾಕ್ಯುಮೆಂಟ್ ಲಾಸ್ಟ್
ಲೀಗಲ್ ಫಿಕ್ಷನ್.
ಪ್ಲೀಸ್.
ಏನು ಮಾಡಕ ಆಫ್ಟರ್ ವೆಕೇಶನ್. ಎಸ್.
At least a deposit of rent since 2022 they have not.
Petitioner is not a owner of the property. She has no locus standi to
Correct,
claim
sir.
rent from.
Who is the petitioner? Mother or daughter? Mother.
Mother, yeah.
ಈಗ ರೆಂಟ್ ಯಾರಿಗೆ ಕೊಡ್ತಾ ಇದ್ದೀರಾ?
Daughter.
ಎಲ್ಲಿ ಕೊಡ್ತಾ ಇದ್ದೀರಾ?
We are paying rent. She is collecting rent.
Where? How?
Through maid, other people.
ಮೇಲ್ ಅಲ್ಲ.
Maid, yeah.
ಮೇಡ್ಗೆ ರೆಂಟ್ ಕೊಡ್ತಾ ಇದ್ದೀರಾ?
She is in America.
So you give the rent to the maid.
And yearly once she comes and collect and she gives the accounts here.
Oh.
Yes, yeah.
Maid in Manhattan. Yes.
The other, the annexure R3 I have produced is a partition between the Israel family of the petitioners. There.
ಈ ಮೇಡ್ ಅರೇಂಜ್ಮೆಂಟ್ ಗೊತ್ತಿರಲಿಲ್ಲ, ಓನರ್ಶಿಪ್ ಕ್ಲೈಮ್ ಮಾಡ್ತಾರೆ.
No, he admits that he is a tenant. And he says that I have been inducted by
So
virtue.
tomorrow you will have to come before the court saying maid is not vacating the premises.
And even tenant pays the rent to the plaintiff through account. It is reflected in the account and that is being marked. Somehow court.
Why the court has not taken note of all your submissions then?
Yes, yes, my lord, I agree. The admitted.
You
rent-
want to squat over the property without paying rent?
No, I am paying regularly. She is in the habit of, sometimes she will not issue receipts also.
Who made?
No. My lord, I am paying rent through maid.
Ade, who is not issuing receipt?
Either maid or the, my landlord. Sometimes I am submitting to this court, sometimes.
Now maid will claim ownership shortly, yes.
Page 39, my lord.
ಇರ್ಲಿ ಬಿಡಿ, ಅವರು ಕೊಡ್ತಾ ಇದಾರಂತಲ್ಲ, ಮ್ಯಾಟರ್ ಆಫ್ ಎವಿಡೆನ್ಸ್.
ದುಡ್ಡು ಕೊಟ್ಟಿಲ್ಲ since 2022. It is an
Let
admission.
the daughter say that ಬಂದಿಲ್ಲ ಅಂತ.
Even they have admitted that they have stopped the paying rent to the daughter since 2022 February.
Then don't squat over the property without paying rent, sir.
I am regular in paying rents, my lord.
You may pay, but to the owner of the property. The learned counsel for the petitioner is before the court challenging the order of rejection of an ejection petition on the score that the ownership of the petitioner was not proved before the concerned court. The issue is with regard to the tenant tenant having a lease agreement with the daughter who is now in the United States of America, and the mother staying in the premises. The mother is unable to prove the ownership before the concerned court, but the fact remains that the respondent tenant has not paid rent for a long time now is the allegation. The learned counsel for the respondent submits that the rent is being paid to the maid, and the maid pays it to the daughter. Therefore, on the next date, if adequate evidence is not placed before the court with regard to payment to the daughter as is contended, deposit of rent would be constrained to be this court would be constrained to direct deposit of rent for squatting over the property without any payment. Yes, very convenient, sir.
No, my lord. My lord, one submission. She is not the owner of the property.
The owner ge kodi.
Illa. My owner is one Bhavana Babu.
ಎಲ್ಲಿದ್ದಾರೆ ಅವರು? Where is she?
She is not in India, my lord.
ಅದೇ ಅದಕ್ಕೆ.
She has not authorized the mother to collect rent.
She is authorized the maid.
Not in her. Through maid, I am paying rent. I have submitted. Through maid, I paid. She is not. She has no low custom to claim rent from me, my lord.
Something fishy about this. Anyway, next time we'll see. Please. Yes, list the matter on 10th.
106.
AVIOC.
2 weeks time.
AVIOC. Yes. Next.
107.
No representation, AV. Yes, Panap.
Then 8.
The counsel for the respondent requested he had a personal inconvenience today.
After vacation. Intermodal, yeah?
There's no interview. 16th of October.
16th. List on 17th. 17th October. Sir. You're not there?
There is a function.
16th October.
Wait for this.
109.
AV. ಯಾರಿಲ್ಲ ಅಂದ್ರೆ ಅದು ವೆಕೇಶನ್ ಆದ್ಮೇಲೆ ಹಾಕ್ಬಿಡಿ.
110.
I appeal for respondent, my lords. Kindly grant a short accommodation, my lords.
Lord, in this case, my lord, the findings that has been noted in the interim order, that itself will be the final order, my lord.
ಅಷ್ಟೊಂದು ಎಂಟ್ರಿ ಮಾಡ ಬರ್ತಿದೆ.
The re-litigation proceedings, my lord. This is second round litigations. Your lordship can see the last but one operative portion of the interim order.
Oh, 26/6. My order.
Yes, my lords. Page number
ಅಷ್ಟೇ
3.
5-page entry order close. Final order ಇದೇನೆ.
Please, my lords.
Short accommodation.
The suit should not have been entertained at all, my lords. Second round of litigation.
2 days time may be granted, my lords.
Oh, this matter, yes.
Same property, my lord.
Abuse.
2 days time may kindly be granted.
2 days time. Wednesday.
Please, my lords.
Interim order subsisting will continue till the disposal of the petition.
Till further orders ಆಗಿದೆ.
ಆಗಿದೆಯಾ? ಸರಿ. ಹಂಗಾರೆ ಏನು ಕಂಟಿನ್ಯೂ ಮಾಡಿ. List on Wednesday. Next. Interim order continue ಮಾಡಬೇಡಿ. After vacation. Yes. Next.
111.
Appear for petitioner in this matter, my lord. My order 7 rule 11 application came to be rejected only on the ground that I have not mentioned the specific provision of the law, my lord. brief facts of the case is this, my lord, this present case is.
ಅಷ್ಟೇನಾ ಬೇರೆ ಏನಿದೆ?
Ashte, my lord.
Where is the order?
There is already an interim order by this honorable court.
Already ಇದೆ. At last time extend ಆಗಿಲ್ವಲ್ಲ?
Extended till the disposal of the CRP, my lord.
Or till the next date of hearing, ಆಮೇಲೆ extend ಆಗಿದೆಯಾ?
Extend agide.
Rest after vacation.
My lords, this matter is coming for admission from past.
We'll post it for hearing. Rest the matter for, we'll admit it then. Admit, post for hearing in usual course. Interim order subsisting is made, interim order is made absolute. Yes, next.
Grateful, my lords.
Next.
And then 12.
My lord, this 7 rule 11, home buyers file a suit against the bank saying the security must be replaced.
Bank is the defendant?
Defendant. Should have been before the SARFAESI court.
This is engaged matter, my lord. Senior is
Huh?
engaged matter, my lord. This is engaging matter, my lord.
Engaging matter.
Engaged matter, my lord. Senior counsel has been engaged, my lord.
Engaging matter.
But senior on record counsel is not keeping well today, my lord. And I have it in any date. in
Aitu
next
barli,
week,
we will stall further proceedings. Not even maintainable, sir.
First,
All
statement of objection has
civil
been
court is
already filed, my
entertaining
lord.
everything. Surface proceedings all civil court alli.
Just you any date.
Injunction for the asking is granted. Yes, Manu?
Lord, I have not filed a
Fundable.
stay application because interim orders are granted. I have been. Lord, if the
List
lordship-
after vacation.
The lordship could make it part hurt.
Why, sir? List after vacation.
That's the only issue.
Yes.
Plus.
113.
For response.
Petitioner challenge the allowing the LR application, my lord.
ಅದು ರಿಜೆಕ್ಟ್ ಮಾಡಿದಾರಾ?
My lord, I appear for petitioner, my lord.
ನೀವು ರೆಸ್ಪಾಂಡೆಂಟ್ ಗ?
I am for the respondent.
My lord, an application, my lord, under order 22 rule 4 filed by respondent number 1 came to be allowed. Against which, my lord, the present petition is.
Why are you before the court on that?
My lord, we rejected, my lord, the very relationship between respondent number 1 and one D Nanjundaya.
Suit for?
My lord, suit for partition was filed by D Nanjundaya, my lord, in 1982.
22 rule for in execution ಹಾಕಿದ್ದ?
FDPL.
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 Why?
My lord, claiming one Mahadevamma, my lord, files an application, that is the
Oh, is he
respondent.
the purchaser of a property or?
Wife anta
Is the wife.
Wife of whom?
Wife of D Nanjundaya,
Who is D. Nanjundaya?
decree holder.
Who is the plaintiff in original suit?
My lord, 1982 suit is filed.
Ah,
1986 suit is decreed.
ah.
2015 ಅಲ್ಲಿ D Nanjundaya files a FDP proceedings.
Oh, he dies during the.
Please, my lord, 2020 ಅಲ್ಲಿ expires. Subsequently, my lord, this application is filed by respondent number 1, that is Mahadevamma, claiming to be wife of D Nanjundaya. My lord, we take up a contention that she is not the wife of D Nanjundaya. My lord, that application is allowed. My lords, I'll show only one document, my lord, at annexure N at page 106. My lord, during the lifetime of D Nanjundaya, my lord, this respondent number 1 files a petition, my lord, seeking for declaration that said Nanjundaya is civil debt agide and also seeks for partition. In that OS, my lord, D Nanjundaya appears and makes a submission that she is not my legally wedded wife, and that suit, my lord, came to be dismissed and attained finality. My
Where
lord.
is that?
106, my lord. Lords may take page 106.
Lifetime of a man, his wife is not entitled to part. Therefore, the suit is to be dismissed as not made according. This has become final?
Please, my lord, no appeal has been preferred. In fact, my lord, one miscellaneous petition seeking for maintenance is also dismissed. So during lifetime of Nanjundaya, my lord, he takes up a categorical contention that she is not my wife anta. Ega, my lord, after even in his plaint, my lord, in the year 1982, no averment is made that this respondent number 1 is the wife of D Nanjundaya.
A suit in OS 47 of 82, na?
Please, my lord, 47 of 1982.
The petitioner.
I am one submission. I am for the loss of the, I am the wife of the Nanjundaya.
Correct, sir. We will decide it, sir.
This is the considerable order has been passed.
Very good, sir. Yes.
One in R1, invitation I produced.
Invitation na?
Invitation card.
Invitation bit ಬೇರೆ ಏನಾರು ಇದೆಯಾ?
Invitation ಇದೆ, ಆಧಾರ್ ಕಾರ್ಡ್ ಇದೆ, ವೋಟರ್ ಲಿಸ್ಟ್ ಇದೆ, ಬ್ಯಾಂಕ್ ಪಾಸ್ಬುಕ್ ಇದೆ.
ಓ ಬ್ಯಾಂಕ್ ಪಾಸ್ಬುಕ್ ಎಲ್ಲ ನೀವೇ ಹೇಳ್ಕೊಂಡ್ರ ಸೆಲ್ಫ್ ಅದು.
It is in the name of the.
Correct, ಎಲ್ಲ ಸೆಲ್ಫ್ ವಿತೌಟ್ ವೆರಿಫಿಕೇಶನ್ ಕೊಡೋ ಡಾಕ್ಯುಮೆಂಟ್ಸ್.
ಅಲ್ಲ, in fact the one of the branch of that Nanjundaya produced Jina Secretary,
The genealogical tree has admitted, I am the wife of Nanjundaya. Exhibit R1.
We'll hear it, no problem. The petitioner is,
One submission, my lord.
you are,
Suit
ನೀವು ಯಾರು?
is 1982, my lord.
Correct, sir.
Respondent
Because
number 4.
I have produced the 12 documents to show established she is the wife of the Nanjundaya.
We'll see, sir. I'm not dismissing I'm not allowing the petition right away. Who
Because
are you? Respond number 4.
Please, ma'am.
ಯಾರು
Respondent
ನೀವು
number
ಯಾರು?
4. I am the son of Nanjundaya's brother, ma'am.
brother, son of Nanjundaya.
Brother, son of Sanjay, I will say. The petitioner is before, petitioner, the fourth respondent in FDP 16 of 2015 is before the court calling in question an order of the concerned court dated 27th March 2025. The respondent claims to be the legal representatives of one D. Nanjundaya. They are the wife and ಎಷ್ಟೊಂದು ಮಕ್ಕಳಿದ್ದಾರೆ?
Wife ಅಷ್ಟೇ.
Wife ಮಾತ್ರ.
Wife ಅಷ್ಟೇ. Respondent number
She is
1.
said to be the wife of one D. Nanjundaya. D. Nanjundaya institutes a suit in OS 47 of 1982 seeking partition separate possession. The said suit comes to be decreed on 5/7/1986. Final decree proceedings are instituted by D. Nanjundaya, and during the subsistence of the final decree proceedings, Nanjundaya dies. One Mahadevamma files an application in the said proceedings seeking to implead herself on the score that she is the wife of Nanjundaya and wife of Nanjundaya. The said application comes to be allowed, therefore the other members of the family, therefore the petitioner defendant number 4, respondent number 4 is before the court. The learned counsel for the petitioner submits that a suit had been instituted by the said wife of Nanjundaya in OS 7 of 2013, claiming that she is the wife of Nanjundaya or Nanjundaya her husband. Nanjundaya her husband, and he had died 15 years ago, and therefore to be declared as civil death and all consequential benefits to flow to her hands. The suit comes to be dismissed by an order dated 1/4/2016 on the score that Nanjundaya, who is said to have died, appeared before the court and deposed that that Mahadevamma is not his wife. The said dismissal of the suit has become final. After the death of Nanjundaya, Mahadevamma has sprung again into these proceedings. In the light of the aforesaid reasons, the order which allows the application of Order 22 Rule 4 of the CPC seeking to bring in Mahadevamma into the proceedings stands stayed.
ನೋಡಿ FDP ನ ಸ್ಟೇ ಮಾಡ್ಬಿಟ್ರೆ
One submission.
ಯಾಕೆ?
ಅವರು
FDP may go on.
He is the only person who is contesting.
No, not only
let
person.
FDP be stayed ಮೇಲೆ.
ಯಾಕೆ FDP Nanjundaya ಬೇರೆ ಯಾರು ಇಲ್ವೇ ಇಲ್ಲ?
ಯಾರು ಇಲ್ಲ.
ಅಲ್ಲ ಅದರ
ನೀವು ಯಾರು?
ಮೇಡಮ್ ನಾನು ಕಂಟೆಸ್ಟ್ ಮಾಡ್ತಾ ಇಲ್ಲ.
Then who are you?
I am the respondent in the FDP proceedings.
Another brother of the Nanjundaya also contesting. Yes, misleading the court.
Yes.
Let
Only that order. No.
Let the FDP proceedings going on.
ಇನ್ನೊಂದು ಹಾಕೊಂಡ್ ಬನ್ನಿ.
Nanjundaya ತೀರೋದ್ಮೇಲೆ she is the one who has come on record as his
I have stayed it.
Please.
We'll see. Yes.
Great.
ಈಗಲೇ ಸೂಟು ಮುಗಿಸ್ಬಿಡ್ಬೇಡಿ.
One submission, my lord.